List first step second step. Officer ಬಂದಿಲ್ವಾ?
ನಮ್ಮ ಸರ್ ಬಿಟ್ಟಿದ್ದೀವಿ
ಹೌದು
ಅವ್ರನ್ನೂ ಬಂದು
ಸಪೋರ್ಟ್ ಕೊಡಿ ಸರ್ ಸ್ವಲ್ಪ ಅರ್ಜೆಂಟ್ ಇದೆ
ಎಷ್ಟೊತ್ತಿಗೆ ನಿಮಗೆ ಸೇಮ್ ಕೊಡಬೇಕು ನಿಮಗೆ ಸೇಮ್ ಕೊಡಬೇಕು
ರಿಜಿಸ್ಟರ್ ಮುಂದೆ ಲೀಸ್ಟ್ ಆಗಿದ್ರೆ ಫ್ರೆಶ್ ಮ್ಯಾಟ್ರ್ ಅದೇ ಸರ್ ಸಾಹೇಬ್ರ ಮುಂದೆ ಲೀಸ್ಟ್ ಆಗಿದ್ರೆ ಮಾತ್ರ ಪೆಂಡಿಂಗ್ ಸರಿ ಬಂದ್ಬಿಟ್ಟು
Usual force list are there.
What officer? Withdrawal again. Sir, kindly give this.
ಎಲ್ಲ ರೆಸ್ಪಾನ್ಸಿಬಿಲಿಟೀಸ್ ತಗೋಬೇಕಲ್ಲ. It is like a breaking up.
ಫೋಟೋ ಇದನ್ನ 5 ನಿಮಿಷ ಮಾಡ್ತೀನಿ.
ಟೈಮಲ್ಲಿ ಏನು ಮಾಡಿದ್ರು? ವೆರಿ ಗುಡ್.
ರವಿಶಂಕರ್ ಮಾಡಿದ್ದೀರಿ ಒಂದು ನೀನು 2:30 ಮೆಮೊ ಅಂದ್ರೆ 2:30.
ಮಾರ್ಕೆಟ್ ಆಫೀಸ್ ಯಾರು ಬರ್ತಿರಲಿಲ್ಲ.
Expeditions day after tomorrow, Your Lordship. Gadiparodu ಒಂದು 3 ಜನ.
ನೋಡಿ.
For 2:30. 2:30 minutes. The urgency is this minutes. Your Lordships on Friday had granted interim order. Despite that minutes, the authorities have precipitated and KPC chairman has been suspended minutes.
That's the governor's prerogative.
Minutes without jurisdiction.
Your only issue was, we'll take it up tomorrow. Your only issue was resolution should not be
listed
passed.
today. Connected matters listed today. May I request this also minutes to be taken up at 2:30.
Yes, 2:30.
Please.
Matter for 2:30, urgency is my lord, demolition. The state highway authority, my lord. State highway authority, it comes under the GM roster only, my lord. As in the similar matter, this honorable court passed the interim order also, my lord.
Who is trying to demolish?
The executive engineer, my lord.
PWD.
Yes, my lord.
Serve a copy on Ms. Jaffa get.
I'll serve, my lord. Kindly 2:30, please.
Yes, madam.
The solid waste management matters. It was all date given based on
We can't hear you well.
the solid waste management matters, my lord. Based on Advocate General's memo, your lordships had segregated the matters. It was date given to today at
It was
2:30.
date given today.
Yes, at 2:30. All matters were delinked and based on the
Those
baskets.
4 categories.
Yes, my lord.
ಯಾಕಮ್ಮ ಬಂದಿಲ್ಲ ಅದು?
It's for the second time this is happening, my lord. Last time also we had to make a mention despite it being date given. And one of the files is missing apparently, one of the connected matters.
Registry is incorrigible. ನಾಳೆ ಲಿಸ್ಟ್ ಮಾಡಿ. Yes, madam.
It's a tender matter, my lord. They'll finalize
Grateful.
the tender on Friday, my lord. We have
Friday, tomorrow. Yes, madam.
My lord, one matter pertaining tender, my colleague is there, my lord. Yesterday the tender is open. My lord, there is a direction from the 15th commission.
Mute ಆಗಿದ್ದೀರಾ?
Finance commission, my lord, they have to, my lord, they follow the Make in India product. Contrary to that, they have opened. Therefore, your lordship may kindly have it today, end of the list, my lord. Yesterday they have opened the tender. Anytime they may.
2:30. Yes.
Withdraw the petition.
Parties ಬರ್ತಾರಾ ಬರೀ withdrawal?
The joint memo.
ನಾಳೆ ತಗೊಳ್ಳಿ.
Joint memo file. Please, Your Lordship.
Yes.
Lord's request for listing today at 2:30, Your Lordship.
What is the urgency?
Petition is an NRI, Your Lordship. He is from Dubai. LOC has been issued by a Department of Enforcement Directorate under FEMA Act, Your Lordship. I am mentioning this matter since 7th of July, Your Lordship. It's been allowed a number of times for listed tomorrow.
See, if your compliance are to be made,
Complied, Your Lordship. It was lastly listed before the registrar on 13th.
earlier it was being listed with non-compliance. See, it goes into non-compliance in the orders category. If you comply, it will be listed.
As per order of 13th this month by the registrar of the court, all the objections being overruled, it was supposed to be listed before this honorable court yesterday, my lord. Yesterday I mentioned before this honorable court, it was allowed for listing today. Eventually, this is not being listed today also, your lordship.
Check ಮಾಡಿ ಅದು compliance ಆಗಿದ್ರೆ tomorrow.
No, request for today is possible.
Comply tomorrow, please.
Lordship, the matter for today 2:30 matter.
What is the urgency?
Writ of mandamus for constituting SIT or transfer the
That is no urgency. It will come in the regular.
My lords, one passport matter wherein I was given a Tatkal passport. I had already filed and passport authorities were also being given notice. I have taken that. Now the passport authorities are asking me to surrender the passport which was issued on Tatkal. And this is the issue where a stay order was given in a criminal case, my lords. I had intimated the police that
Passport authorities are asking you to surrender.
Yes, my lords.
Tomorrow.
My lords.
Your lordship, attempt to murder against an advocate, your lordship. You were shot in
It's a mandamus you are asking for. There is no urgency. It will come tomorrow, please. Senior citizen matter.
Yes, my lord.
Tomorrow.
PI granted for in favor of me, but respondent illegally locked my home. So I don't have a stay home because I'm ಅಂದ್ರೆ ಟೆಂಪ್ ಅವ್ರಿಗೆ ಇರೋದಕ್ಕೆ ಮನೆ ಸಿಗ್ತಾ ಇಲ್ಲ ರೆಸ್ಪಾಂಡೆಂಟ್
ಕನ್ನಡದಲ್ಲಿ ಹೇಳಂಗಿದ್ರೆ ಕನ್ನಡದಲ್ಲೇ ಹೇಳಿ ಪರವಾಗಿಲ್ಲ.
ಅಂದ್ರೆ ರೆಸ್ಪಾಂಡೆಂಟ್ ಸೈಡ್ ಅವರು ಕಾನೂನು ಬಾಹಿರವಾಗಿ ಅವ್ರ ಮನೇನ ಲಾಕ್ ಮಾಡಿದ್ದಾರೆ ಸ್ವಾಮಿ, ಹಂಗಾಗಿ ಅರ್ಜೆಂಟ್ ಇದೆ. ಮನೆಯಲ್ಲಿ ಉಳ್ಕೊಳಕ್ ಮನೆ ಇಲ್ಲ, ಹೊರಗಡೆ ಟೆಂಪಲ್ ಅಲ್ಲಿ.
ಸೀನಿಯರ್ ಸಿಟಿಸನ್ ಮ್ಯಾಟರ್ ಏನಿದು?
ಇಲ್ಲ ಸ್ವಾಮಿ, ಅಂದ್ರೆ ಮನೆ ಅಂದ್ರೆ ಹಸ್ಬೆಂಡ್ ತೀರೋಗಿದ್ದಾರೆ, ಅವರು ಇನ್ನೊಬ್ರು ಬಂದು ನಮ್ಮ ಹಸ್ಬೆಂಡ್ ನ ನಾವು ಕೂಡ ಅವ್ರ ವೈಫ್ ಅಂತ ಹೇಳಿ ಮಾಡ್ತಾ ಇದ್ರು. ಸೊ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಆಲ್ರೆಡಿ ನಮ್ಮ ಪರವಾಗಿ TI ಗ್ರಾಂಟ್ ಆಗಿದೆ. ಬಟ್ ಆದ್ರೆ ರೆಸ್ಪಾಂಡೆಂಟ್ ಸೈಡ್ ಅವರು ನೀವ್ ಹೆಂಗ್ ಬರ್ತೀರಾ ಬನ್ನಿ, ನೀವು ಬಂದ್ರೆ ನಿಮ್ಮನ್ನ ಉಳಿಸಲ್ಲ ಅಂತ ಹೇಳಿ ಬೆದರಿಕೆ ಹಾಕಿ ಇದು ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
ಇಲ್ಲಿ ಏನಕ್ಕೆ ಬಂದಿದ್ದೀರಪ್ಪ?
ಪೊಲೀಸ್ ಪ್ರೊಟೆಕ್ಷನ್ ಗೆ ಡೈರೆಕ್ಷನ್.
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಪೊಲೀಸ್ ಪ್ರೊಟೆಕ್ಷನ್ ಕೊಟ್ಟಿದ್ದಾರಾ?
ಹೌದು, ಅಂದ್ರೆ ಆರ್ಡರ್ ಆಗಿದೆ, ಬಟ್ ಪೊಲೀಸ್ ಅವ್ರು ಇನ್ನೇನು ಮಾಡಿಲ್ಲ.
ಅಲ್ಲಿ ಕೇಳಬೇಕು, ಇಲ್ಲಿ ಕೊಡಕ್ಕಾಗಲ್ಲ, ಅಲ್ಲಿ ಅವ್ರು ಕೊಡದೆ.
ಅಂದ್ರೆ ಅದಕ್ಕೆಲ್ಲ ನಾಳೆ ಒಂದ್ಸಲ
ಸುಮ್ನೆ ಡಿಸ್ಮಿಸ್ ಆಗತ್ತೆ ಕೊಡಿ, ಬಟ್ ಅಲ್ಲಿ ಹೋಗ್ಬೇಕಾಗತ್ತೆ. ಎಸ್ ಮೇಡಮ್.
For 230, my lord, the urgency is that it's with respect to the Senior Citizens Act. They have cancelled the gift deeds, my lord, and they're telling us to vacate at the very instant, my lord. It may be kindly be taken at 2:30.
They can't vacate you. When was the order passed?
Lords,
They should be ready with all the facts tomorrow.
Tomorrow.
Yes, madam.
My lord, respondent number 3 has encouraged the 60 acres of land with regards to the same. Order has been passed, my lord, but again fourth time they are issuing the survey. They are calling for the survey, my lord.
Survey has happened 3 times early.
3 times happened, and stay is also obtained by the petitioner in the another matter, my lord. Even though they have issuing the survey.
Then you move that matter. Why are you moving?
In that we are not the party, my lord.
Then petitioner is obtained.
In that matter, we have filed the impleading application, my lord. In this also we have challenged one more notification.
Put that number also. Give that number. Both of them tomorrow.
Yes, ma'am.
Petitioner is a priest and he is a senior citizen. He is performing puja in one temple, and all of a sudden, without any allegation remarks, the Tahsildar have issued a notice to him to change that priest. There is some urgency, have it, and tomorrow day after tomorrow.
The appealable order, alva.
It will come before this.
Before the commissioner appealable order, 26.
Thereafter, the deputy commissioner also have issued a notice to him. Therefore,
it seems to be appealable order.
Tomorrow.
Yes.
I am challenging the District Caste Verification Committee answered my schedule caste certificate. In that, I am working from past 7 years in the Baba Research Center. That is a central government apartment. If his order is continuous, the stay, if it is not grant any stay order in this matter, my job will be went to vain.
Tomorrow. Yes, tomorrow, please.
Lord, CCB has issued a notice in a financial transaction matter where 138 proceedings is pending, my lord. Now there is a threat of arrest, my lord. I went to investigation, I cooperated. No crime registered. They're saying to settle the matter.
CCB has
CCB, my lord.
serve it on.
I have served, my lord.
Find 2:30. Get the instructions.
At 2:30, your lordship. Petitioner is the resident of Mysore.
2:30 ಅಂತ ಹೇಳ್ಬಿಡ್ತೀರಾ ನೀವು?
Petitioner is a resident of Mysore, your lordship, and the assistant commissioner has issued an extendment order for a period of 1 year to reside him in Bidar, your lordship. 2:30.
2:30.
It's a mandamus direction to the police, my lord. Holiness.
Mandamus, why are you mentioning it? Come in the regular.
On 1/7/2025, FIR has been registered. Till they have not taken any action.
Please give the memo. It will come in the regular course. Yes, it will come, madam. Give it. It will come after 3 days. If you have complied, it will come.
Well, this is a society matter. There's a grant which is made in favor of society. Because this petition is pending, they're unable to disperse the amount, my lords.
Pending matters will be taken only in Syria.
Because there's a connected match is listed on 16th, my lordship.
16th.
Please, my lords, 16th.
Madam, we have told you twice. It will come in the regular course. Please give the memo. Yes.
Adjournments. List number 1, page number 4, serial number 32 and 33.
My lords, serial number 29, my lords.
What is being called out? Only mention that.
Page number 5, serial number 34 to 38. Page number 6, serial number 39 to 45. Page number 7, serial number 46 to 49. Page number 8, serial number 50 to 52.
Serial number 51, my lord. I appear for the respondents. I have to file our statement of appeal.
Have you informed the petitioner and the other counsel? All of them you have informed?
The interim order is there. That may be
51.
an IM, it's not come up today.
At the request of counsel for respondent number 4, relist on
1, 2, 3.
Respond number 1 to 3.
AB Patil.
Leave it, okay. At the request of respond number 1 to 3, relist on 12th August, interim order earlier granted is extended till next date.
Has to be BB Patil, Manoj.
BB Patil. Registry correct the name of the council appearing for respond number 1 to 3 as BB Bangalore Patil.
Interim order.
Extended.
Great. 27.
27. At the request of council for the petitioner, relist on 12th August.
The serial number 54.
Hmm.
I was directed to file the written submissions in the senior citizens matter, reserve ಆಗ್ಬೇಕು. That was heard and reach ಆಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಸಾಯಂಕಾಲ.
Let it reach, Mr. Arun. Mention it at.
My lord, 63.6, my lords.
63.6.
Pray time for compliance of the office objections, my lord.
Have you informed all the council? There are 20 matters.
Yes, my lords.
When it reaches, please.
Thank you, my lords.
This number 1 for being spoken to, serial number 1.
Please, please.
Manmohan Kian.
Serving on the council. Now she has informed that she no longer appears on the name may be deleted and may be sent to serve on Nabat.
So who appears for respond number 2 now? Who appears for respond number 2? Nabad Yaramma? She no longer appears. It is submitted that Ms. Jayashree Narasimhan no longer appears for respond number 2. In that view of the matter, the direction issued
To respond
on
number
29/6/26, directing her to accept notice for respond number 2 is recalled. The order dated 29 June 26 is also recalled. Issue notice to respond number 2, returnable by 18th August.
Fresh matters.
Can't do that. But second respondent has to be heard.
Fresh matters, serial number 2. DK Manjunath.
Non-payment of balance of subsidy amount.
Will accept notice for all of them, Mr. Jaffer?
Yes, sir.
AG accepts notice for respond number 1 to 6. Petitioner is before this court seeking for the following leaves. Yes, same order.
Serial number 3. Girish, yes.
Yes, Mr. Girish?
Already, section further, the cultivation land at village, Bidadi, Burmala.
Your appeal has been dismissed.
Concurrent finding, my lord.
Get ready and address arguments.
1935 notification, it is not denotified also.
Concurrent finding doesn't mean we'll just dismiss it. You have to address arguments.
Granting the land, considering that it is a Gomala land, in the year 1997, madam.
Aitappa, our time kodta no interim relief. And AG accepts notice for respond number 1 to 5. She seeks fund is granted 2 weeks time to obtain instruction and address arguments. Relist on 11th August.
Serial number 4. Veena N.
Yes, Mr. Manmohan.
An auction bidder, but I deposited about 50 lakhs. But then not, because of certain disputes, not I did not take it forward, but I sought for refund of that money. The bank says, not, I'm not entitled for refund. That's the only issue.
Auction was under surface A.
Yes.
Would this come before us or will it have to go as TMDRT?
Here, my lord, the bid, my lord, I have submitted my amount. 50 lakhs is, I'm only asking for refund of that amount.
Classification, Chief Manager, Canara Bank.
TP Muttanna.
CP Muttanna is directed to accept notice for respondent. Registry to verify the classification of the matter and post the matter before the appropriate court. Relist on 11th August.
Please.
Serial number 5, Rafi Somshekaraya.
Position of LPG dealership has been rejected only on the ground. Vehicle number ಎರಡು ಕಾಲ್ ಮಾಡಿದ್ರು ಒಂದೇ ನಂಬರ್ ಕೊಟ್ಟಿದ್ವಿ ಅದು ರೆಕ್ಟಿಫೈ ಮಾಡಿದ್ವಿ ಡಿಸ್ಪೈಟ್ ಮೇಲೆ they have rejected the tender ಮೇಲೆ.
ನೀನು ಸರಿಯಾಗಿ ಹೇಳಿ ಮತ್ತೆ ಸೋಮಶೇಖರ್.
Malad, the respondent invited tender for transportation of LPG malad. We have submitted all the documents, all documents are perfect malad. Vehicle number was mentioned, same vehicle number was mentioned for two tender malad. Therefore, they have sought for clarification. We have informed we have given the correct vehicle number.
Where did they seek for clarification? Where is the clarification?
Malad, well, you can turn to page number. Malad, page number 48 malad.
48.
Yes, ma'am. Sorry. Well, 50, well, I should turn to page number 50.
48 is cash certificate.
No, ma'am, 50, page number 50, ma'am.
50.
Bidder name KVC, KSVM Enterprises bid number. So you are requested to upload the documents which were not submitted along with the truck mentioned in annexure A to case. However, RCN they submitted for the truck number. So please submit the revised annexure R2 along with declaration mentioning the correct truck number offered in the tender of Karnataka. IVC to submit it to PCSO drawing for truck KSO without PCF approval, seal and signature. Bidder to submit the missing documents only. This does not deserve any commitment towards confirmation. Thereafter, we have submitted Malad. However, Malad, this has been rejected only on the
Where is the rejection order?
Malad, annexure B, Malad.
Annexure D.
Annexure B, page number 49.
Page?
Page 49, Malad.
Page?
Page 49, annexure B.
49.
Yes, Malad. This is the communication. Malad.
Not qualified in BQC and
Yes, ma'am.
commercial parameters.
Yes, ma'am.
Notes, what has happened is, notes, OMCs had called for tenders. Notes. There are three different OMCs. Notes, HPCL, BPCL, and IOC. Notes, petitioner, as far as my instructions are, petitioner has got only one truck. Notes. He has given it to IOC and BPCL both. Notes.
In the tender.
One day truck for both he has offered. Notes, IOCL has rejected it, saying that there is a tender condition that clearly says
exclusive.
It has to be only exclusive.
It is also challenged. My
Can't be
notice has
for
been
both.
ordered in that case, ma'am.
Can't be for both. And he has also given an undertaking affidavit also to that effect that he will offer to only one. Here, Manoj, he has offered to both, same truck. And
So it is not about annexure C.
it's not about.
The annexure C, you yourself asked for 807. And 807 has been given to both BPCL and IOC.
IOC. Tender condition.
ಅದು ಅಪ್ಲೋಡ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ವೆಹಿಕಲ್ ನಂಬರ್ ಒಂದೇ ಮಾಡ್ಬಿಟ್ಟಿದ್ರೆ ಅದನ್ನ ರೆಕ್ಟಿಫೈ ಮಾಡಿದೀವಿ ಇಬ್ರಿಗೂ.
ನೀವು ಅಪ್ಲೋಡ್ ಮಾಡಿದ್ 806.
ಹೌದು ಅದು
806 ಗೆ ಅವ್ರು
ಅದಕ್ಕೂ ಅದೇ ನಂಬರ್ ಅದೇ ವೆಹಿಕಲ್ ನಂಬರ್ ಇದಕ್ಕೂ ಅದೇ ವೆಹಿಕಲ್ ನಂಬರ್ ಮಾಡಿ.
ಹೇಳಿ ಸೋಮಶೇಖರ್.
ಪ್ಲೀಸ್ ಮೇಡಮ್.
806 ಅಪ್ಲೋಡ್ ಮಾಡಿದೆ, ಅದಕ್ಕೆ ಪೆಸೋ ಇರ್ಲಿಲ್ಲ.
ಹೌದು.
ಅದಕ್ಕೆ ಅವ್ರು ಕೇಳಿದ್ರು ನಿಮ್ ಕ್ಲಾರಿಫಿಕೇಶನ್ 806 ಬೇರೆ ಯಾವ್ದಾದ್ರು ವೆಹಿಕಲ್ ಅಂತ.
ಇದೇ ವೆಹಿಕಲ್ ಅಂತ
ಅದಕ್ಕೆ 807 ಅಂತ ಅಪ್ಲೋಡ್ ಮಾಡಿದೀರಾ.
ಹೌದು.
ಮಿಸ್ಟೇಕ್ ಆಯ್ತು.
ಹೌದು.
ಇವಾಗ 807 you have given it to both BPCL and IOCL.
Yes, madam.
How can you give the
ಅಲ್ಲ
same?
ಎರಡು ಕೊಟ್ಟಿದ್ವಿ ಬೈ ಮಿಸ್ಟೇಕ್ ಅಂತ ಆಮೇಲೆ ರೆಕ್ಟಿಫೈ ಮಾಡಿ ಇಬ್ರಿಗೂ ಕ್ಲಾರಿಫಿಕೇಶನ್ ಕೊಟ್ಟಿದೀವಿ.
ಏನಂತ ಕ್ಲಾರಿಫಿಕೇಶನ್?
ವೆಹಿಕಲ್ ನಂಬರ್ ಇದು ವೆಹಿಕಲ್ ನಂಬರ್ ಇದೊಂದು
petition. Now, even after that, in the October, my lords, we have started issuing.
My lord, page number 39, my lord.
It's, we are in
Page
July
number
now.
30.
Yes.
Page number 39, K, register K02H0807.
807.
ಹೌದು
807 you are given to BPCL also.
ಅದನ್ನ ಅವ್ರಿಗೂ ಎರಡಕ್ಕೂ ಇದು ಮಾಡಿದ್ವಿ ಆಮೇಲೆ ಕ್ಲಾರಿಫೈ ಮಾಡಿ
806.
ಅದೇ ಬೇರೆ ಇದೇ ಬೇರೆ ಅಂತ
ನೀವು
ಕೊಟ್ವಿ.
806 ಇನ್ನೊಂದು ವೆಹಿಕಲ್ ಇದೆ
ಇನ್ನೊಂದು
ಅಂದ್ರೆ
vehicle ಇದೆ.
where that 806 registration?
My lord, that is in another writ petition, my lord, which I have filed, 39,372 of 25.
Another writ petition.
Yes, my lord.
Shri B. Pramod accepts notice for respond.
One, my lord.
Or one. IOCL ಯಾರು? Who is for IOCL?
It was Kavita Damodar.
It's Kavita Daman for respond number 2. Connect with WP number so and so.
39,372 of
Birth code,
25.
birth code, so that there is no issue.
Date.
And relist on 21st.
Please.
Much.
Serial number 6, Akshata Shetty.
Yes, madam.
Writ of 9 number seeking direction to investigate into my complaint, my lord, which discloses commission of cognizable offence by
What are the offences alleged?
offences, my lord. It is a landslide issue, my lord, causing death, multiple deaths, my lord. I have petitioner has lost her 2 children, her mother-in-law, and she has it has 80% disablement. It has cost, my lord, to her and her father-in-law, my lord. It is because of, my lord, unscientific formation of road in the hill slope area, my lord, without following IRC guidelines, my lord. They have not obtained any NOC or permission from mines and minerals. There is no
And
NOC from
DGA
forest
accepts
department.
notice for respond number 1 to 3. Manjanadi Gram Panchayat, Mangalore. Sharanjit Setti for respond number 5. KRDIL.
Vandana PL.
Vandana PL for respond number 6. Counsel for the petition to furnish 2 sets of the petition along with annexure on the said council. Relist on 29th July.
Great.
Serial number 7, Girish R.
Appear by petitioner in this case, my lord. Is an emergency payroll matter, my lord.
What is the emergency?
Annexure C, page number 22, my lord. The convicted mother is suffering from critical renal function and spinal cord problem, my lord. So she want to treat in a air hospital.
Yes.
Boxer case.
Hmm?
Boxer case.
Foxo case, but he has spent 8 years and he has been given parole 3 times earlier. Court parole once. Petitioner is, Land AG accepts notice for the respondent. Petitioner is before this court seeking for the following leaves. Petitioner, wife of ಬಾಲ ಏನಪ್ಪ ಹೆಸರು ಇದು
ಭೋಜ ಬಾಲ ಗುರಮ್ಮ.
We are given, there's Kondaya, there is Bala Kondaya, there is B Kondaya. Who is the petitioner?
Petitioner is the wife of the convict prisoner, my lord.
Wife of the, you have split the words and you have mentioned differently in different places. Petitioner, wife of Bala Kondaya, son of B Kondaya, CTP 10173, is before this court seeking for the following leaves. The detainee had been convicted for offences under section 376, read with section 3 and 4 of the POXO Act on 28/2/2018 in SC number, special CC number 512 of 2017 by the 53rd Additional City Civil and Session Judge Bengaluru, which came to be modified by this court in Criminal Appeal number 843 of 2018, dated 11/12/2023, the highest of the sentence being 14 years of imprisonment. the detainee has been incarcerated for a period of 8 years, 0 months, 5 days. And during that time has been granted parole on 3 earlier occasions. On 1 earlier occasion for 3 months. The petitioner is before this court contending that the detainee's mother is suffering from critical renal function and spinal cord problem, and she has been advised to undergo specialty treatment, and it is on that basis that the petitioner is before this court seeking for emergency parole for the detainee, taking into consideration the medical certificate which has been produced, as also taking into consideration that there is no complaint against the petitioner, his conduct is detainee, and his conduct is satisfactory during his incarceration, as also that he had been granted parole on 1 earlier occasion, which terms and conditions the detainee has satisfied. I am of the considered opinion that the detainee would be entitled for 15 days, emergency parole of 15 days. As such, I pass the following: 15 days commencing from 20th July.
Serial number 8. Mahesh Bayan.
In this matter, I appear for the petitioner.
Learned ASG would be appearing in this matter, my lords. He's on his legs in another matter. Learned ASG would be.
Pass over.
Serial number 9. Shailaja K.
Yes.
Serial number 10, no? 9. Serial number 9.
9, Ms. Shailaja. Pass over.
Serial number 10.
The sought for writ of mandamus. Since from 2018, December Court has been directing the authorities to provide the basic amenities to the layout, Ashaya scheme layout. The government has not provided the basic amenities. On the contrary, the third respondent, BMTC, officers come on and disturbing the position of the occupants, grantees, allottees. Therefore, I sought a restraint order against the third respondent and direction to other respondents to provide the basic amenities in the free sites allotted to the.
Why you made BMTC a party?
So employees claiming under the BMTC, they're coming and disturbing there. They're disturbing the position of the allottee, saying that we have been allotted and that. So for that, when we sought the information from the authorities, they are not providing any information. Therefore, we have made them as a party and have caused a notice also.
Yeah, accept notice for respondent number 1, 2, 4, and 5. BMTC.
HR Renuka.
HR Renuka is directed to accept notice for respondent number 3. She is directed to secure instruction and make a submission as to on what basis the BMTC is making a claim on the subject property. And AGA is also directed to secure instruction and make a submission as to the status of the layout form, whether all the amenities like drinking water, asphalted roads, sewage, drinking water, sewage and sanitary, water, sewage and sanitary connection, electricity connection, asphalted roads have been provided or not.
Respondent number 4, my lord. The Chief Executive Officer. The PDO, Chief Executive, CEO of a taluk. We don't appear, my lord. That I think.
PO, Bangalore North.
MS Devraj.
MS Devraj for respondent number 4. And AGA and MS Devraj are directed to ascertain.
A restraint order against the third respondent. Restraint order against the third respondent, BMTC.
You are asking for a mandamus and a restraint order. That cannot be granted in a mandamus. Don't expand it.
Implementation of a legal notice. Anyways, my lord, because.
Let us find out what they are doing.
I'll find out.
7. Ravishankar K.
Challenge the annexure B, demand notice issued by the respondent number 2 and 3.
Beneficiary capital contribution.
BCC. What is it? And AGA for respondent number 1. Shri B, the BWSSB had
Monesh,
Monesh Kumar for 2 and 3. Same order.
serial number 12. Praveen, yes.
Yes, Mr. Srivatsa.
My grandfather and grandmother,
Huh?
apart from having a lot of other joint family properties, had purchased a house property.
Hmm.
Grandfather released his share to the grandmother. He passed away.
Hmm.
On the same day, the grand and they had built 4 floors around and 3 floors.
Forest
Hmm.
land.
On the same day, grandmother, they were daughters and one grandson. Gifts 3 floors, 1 floor each, 3 times 1 floor. Meanwhile, sister,
Hmm.
mother filed a suit for partition which is pending. One of it against my grandmother, and other two for joint family properties.
Hmm.
Meanwhile, it appears if you not receive the order of the assistant commissioner, second page, then what happens is, now I am occupying the first floor. The other floors are not in my possession. Now they want to get me out of the premises. So what they do is they go before the assistant commissioner and say I am mistreating, etc. The assistant commissioner records everything and says she's been mistreated, she's not been looked after well. The other arms come and say they have no objection to allowing the petition. But who would admit that they were mistreating their mother? This is the second page, para 2. They have not acted upon gift. They have no objection to allowing the petition. There is no material or record to show that I have mistreated, that I even mistreated.
What is your right in this property?
I got a gift.
From whom?
My grandmother. My grandmother, on the day she got released from her husband,
Hmm.
she executed 3 gift deeds in favor of myself and her 2 daughters. Hardly. And I occupied 1 floor out ground and 3 floors. I got the first floor, I was occupied. Meanwhile, it appears that they have entered into an agreement which also we put for and received like 5 crores of rupees as advance. Now I am occupying 1 premises.
Respond number 1 and 3 have stated that they have not acted upon the gift deed.
And there is no objection.
No
to allowing
objection.
the petition.
Yes.
No objection to allowing the petition means what they admit that whatever she has said that they've been mistreating her, not looking up, everything is true. Well, the bottom seems to be that if they side with the mother, they get more property ultimately in that partition.
Yes, if you have taken care of her properly, you would have got a larger
I'm
property.
staying in 1 floor, 200, 300, 400.
It's not where you are staying. It's taking care of the elders.
Grandsons, daughters are there, sons-in-laws are there. Why only me to be thrown out?
When you want the property, you are the grandson. When you don't, for everything else, you are not the grandson. The other daughters and sons are there.
There is nothing to say that please see the order, madam.
So what have you done to take care of
There is
her?
no conditional gift.
What have you done to take care of her?
I am living with her. Whenever she is there, I go down and meet with her. I
And
don't
say,
know how to
hello,
cook.
how are you? Give me some more money.
My grandmother will cook. I gently go and eat with her.
That's all. She is taking care of you, or you are taking care of her.
My mother and grandmother apparently have had a tiff. I am the victim of that tiff between my mother and grandmother. Madam, please see the order, madam. Please see the order. He doesn't talk.
Show us what you have done to take care of your grandmother, Mr. Vatsa.
There's nothing saying. Madam, grandson, what will he take? 20-year-old grandson, what will he take care of his grandmother? Grandmother has got. Madam, please see.
Issue, learned AGA accepts notice for respond number 4. Issue notice to respond number 1 to 3, returnable by 17th August.
I've been asked to vacate for tomorrow, madam. Please see the order, madam. 30 days I have to vacate. The date is appears only against the QR code on the last page. 15 June 2026. QR code, madam, there is no date anywhere. 30 days I have to vacate.
Yeah, the digital signature is not QR code.
No, the order itself doesn't seem to have a date anywhere.
It's a digital signature. That date is sufficient.
Sufficient, no, I'm date is sufficient. But
Those are not issues.
no, I'm not an issue. I'm only saying that tomorrow I have to vacate.
So why did you come today? Why not earlier?
They fight, they got
The artificial pressure on the last day then.
Artificial pressure, madam. 1 floor, 4 floors, they still got vacant. Even apartment, vacant, madam. I'm not even occupying. It's not.
That is what you say. We'll get to know the story when they come.
Occupying.
How much are you going to deposit per month? 50,000. 50,000. And that's why we asked. You tell us. Hey, Lordship may say, we'll say what. Correct, ಹೇಳಿ.
Otherwise, I would never have bargained with the
We are not bargaining. Something that will take care of your grandmother who is 61 years old. 10,000 is not, 20,000 deduct. Since the submission of Shri S. Srivatsa, the senior counsel for the petitioner is that a sum of rupees 20,000 would be paid to respond number 1 for her upkeep. From today now, every month, month on month from 14th July. 20,000 every month on month on 15 July. On 15 July, the direction issued by the fifth respondent to the petitioner to vacate the premises is stayed till the next date of hearing. The petitioner is however put to notice that he shall not in any manner cause any disturbance to the respondent number 1 who is residing in the same building. Issue emergent notice to respondent number 1 to 3, returnable by 10th August. If the payment aforesaid is not made by end of day 15 July and acknowledgement thereof produced by the petitioner, the interim order will stand automatically vacated.
Payments day after tomorrow, we'll have to contact you.
16th.
And I'll hand over the cleaning to her.
Acknowledgement has to be produced.
13, Sachin BS.
Because 1906 converted change of land was converted to Paradina land. But earlier, this is here 1 minute endorsement and annexure is saying it cannot be done because the land rate was 3 rate. Thereafter, the RTCs are still saying it is a Paradina land. Thereafter, second endorsement issued saying that it is the DCF who has to now look into the matter, saying based on the 2023 resolution that is passed by the government. Because in that, as know that they say that lands which are prior to the alienation, it belongs to the government. The lands which are after the alienation belongs to the petitioner.
This is Jamabane.
This is Jamabane land. Thereafter, in the year 1906, it is reclassified as Paradina. Land is no existing. Since then,
Yes, madam.
it is.
Yes, but now that with the amendment to the Land Revenue Act, they become the complete owners. What is left for you to claim prior to that date? That circular was issued prior to the amendment. After the amendment, how will that circular be applicable? Difficult for that to apply. Yes. And because of the circular.
That is the first circular.
But now circular is a executive order. There is an amendment to the act. And AGA accepts notice for respondent number 1 and 2. Petitioners claim to be the absolute owners of the property bearing survey number 18/3, 18/4, 18/5, 18/6, 18/7, 18/8, and 118, situated at Modduru village, Shontikoppa Obli, Kushalnagara Taluk, Kodugu district. The said land was earlier classified as Jamabane and subsequently reclassified as Paradina Bane. The petitioners had made an application on 21/9/21 before the first respondent seeking permission to cut and remove the standing trees existing on the Bane land. Respondent number 2 had sought a report from respondent number 2. Deputy Conservator of Forest had sought a report from the Deputy Commissioner regarding the rights of the petitioner over the trees standing in the land in respect of which permission was sought for. the land being assessed to land revenue, the Deputy Commissioner submitted a report on 2/11/23 stating that the subject land being Jamabane land, the petitioners have ownership right over the land, but they have no rights over the standing trees therein. And it is based on the said report that the second respondent rejected the application filed by the petitioner. It is challenging the said rejection that the petitioner is before this court. Now, counsel for the petitioner, relying upon the decision of this court in Brigadier Malathiria A. Devaya versus State of Karnataka and others in WP number 55534 of 2013 and other connected matters dated 25/7/24, submits that in view of the amendment to the Karnataka Land Revenue Act, once a Kodwa family is granted full ownership of land, the ownership of the timber standing trees would also vest with the Kodwa family. And as such, he submit that the petitioners being Kodavas, they have complete right over the trees post the amendment made to the Karnataka Land Revenue Act. And as such, the respondents could not have claimed interest over the trees. The trees also belong to and form the ownership of the petitioners. Now, AGA would have submit that there is a circular which has been issued by, where is the circular? Circular dated 2023, issued by the Additional Chief Secretary, Forest Department. And by virtue of the said circular, all the trees naturally grown trees that existed before the date of alienation, unless redeemed, belong to the government. And further, all natural grown trees that existed before the date of alienation, whether reserved or not, reserved or not reserved, belong to the government. Trees grown after the date of alienation shall belong to the landowner unless reserved by the government. On that basis, she submits that in the present case, the trees having been grown on the having existed on the property of the petitioner prior to the alienation, the government would have ownership over the said land, over said trees. Heard? So and so peruse papers. The claim of the petitioner is on the basis of the amendment to the Karnataka Land Revenue Act, whereas the claim of the AGA is on the basis of a circular issued by the Additional Chief Secretary, Forest Department. The amendment having come into force even prior to the circular was subject matter of challenge before this court, and this court had upheld the amendment in the decision in Brigadier Malathiria A. Devaya. While doing so, this court has categorically taken into consideration the categorical submission made by the learned Additional Advocate General therein that post the amendment, the entire land exclusively belongs to the Kodwa family, to whom the land belongs, even if it is Jamabane land. When the entire land belongs to the avail to the government post the amendment having been upheld by this court. In that view of the matter, this court passes the following order. A certiorari is issued. The order dated 2/11/23 bearing number so and so, passed by respondent number 1 at annexure A to consider the application of the petitioner to cut the tree standing on the subject land belonging to the petitioner in terms of Annexure C series in accordance with law. In the event of there being any requirement for any further permission to cut any particular variety of tree, of the application. The entire process to be completed within 60 days from the date of receipt of a copy of this order.
My lord, they have to seek.
Wherever the
Please.
permission, that is why we're putting that condition.
Please, my lord.
If they cannot cut it, they cannot cut it.
Please, my lord.
Only
without-
the waste trees for the purpose of shade and everything that they can do. Not,
Please.
they can't do rosewood, sandalwood.
No. Lords, we have
The-
given application, Lords, let them make a survey what trees can be cut and what not.
They'll do
Please,
that.
Please.
Serial number 14.
Please, get to
Kalyan
it.
Dash.
Yes, Kalyan?
Petitioner is challenging a lot the endorsement issued by the sub-registrar, Annexure A, page 11.
There is no interim.
Has obtained, my lord,
11 is
court
sketch.
decree.
Court decree, na?
Court decree, my lord, page
Page?
13.
Page?
And thereafter, page 13, Annexure B, my lord.
13,
13, I think it's.
39.
And after obtaining, my lord, decree, you filed a, my lord, execution petition. Through court, my lord, a commissioner was appointed. After appointing the court commissioner, my lord,
Yes.
court sale did along.
And AG accepts notice for,
But the same thing, my lord, the lordship has also, in the previous order also, lordship has noted, let them submit a revenue sketch from a licensed.
licensed surveyor.
License surveyor, we will.
You furnish it. This is actually in your benefit.
Please.
Revenue sketch. It'll
11 is
avoid future issues.
Now, my lord, obtaining 11 is sketch through the revenue authorities.
You are
Private
in,
surveyor, I'll-
and you know it.
Private
You
surveyor
appear
with
for
the
the
right of
authorities also what problem happens.
I'll do it.
It's actually advisable in your client's interest that 11E is produced. But now you produce a license, this one, it won't help in any manner.
At least as authorities, my lord, we'll have some record. In case after this, if they apply for 11E, my lord, we can rely upon.
It won't help at all.
The boundary. if a-
11E would have to be issued.
Only reason, my lord, the court decree is there, my lord, they've
11E madak munche Ford, everything adbust has to happen, then it protects them.
yes.
Not, this won't protect them.
This will not protect them, but at least the authorities can say that you have given some sketch to us. Based on that, we can.
And he accepts notice for respondent number 1 to 3. Petitioner is before this court seeking for the following reliefs. The petitioner had entered into an agreement of sale dated 16/9/2013 to purchase property bearing survey number 46/1 measuring 1 acre 0.1 guntas out of 23 guntas situated at Adigonarli village, Esargatta Obli, Bangalore North Taluk. Since the vendor did not come forward to execute the sale, a suit in OS number 1028 of 2019 for specific performance had been filed, which came to be decreed in favor of the petitioner. The petitioner thereafter filed execution petition number 28 of 2026, when a commissioner was appointed to execute a sale deed in favor of the petitioner, in pursuance of which a sale deed came to be executed at Annexure E. When the same was presented for registration before respondent number 3, the respondent number 3 rejected the registration on the ground that the 11E sketch has not been produced. This court in
Lord Dattaram Raikar,
page,
Lord, judgment is not produced, which is in Dattaram M. Raikar. I'll place it.
ಇಲ್ಲಿ the details ಎಲ್ಲಿದೆ.
In page 7, my lord, para 7. Page 7, para 7, Dattaram M. Raikar versus State of
ಇಲ್ಲ
Karnataka.
ಇಲ್ಲಿ.
Para 7, I said.
Para
Second
7
line.
doesn't have any details.
Dattaram Raikar.
Dattaram M. Raikar.
Citation ಏನಪ್ಪ?
Citation ಇಲ್ಲ.
This court in so and so, citation ಬೇಕು.
Citation, I'll furnish.
So and so has held that the sub-registrar cannot refuse registration of a sale deed for want of 11E sketch when there is a court decree which has been passed. The said decision would equally apply. It would apply on all fours to the present matter. In that view of the matter, this court passes the following order. Writ petition allowed, a certiorari is issued, Annexure A is quashed. A mandamus is issued directing the respondent to consider the sale deed submitted by the petitioner with insisting on a Lebanese sketch and register same within 15 days from the date of receipt of a copy of this order. The registration shall, however, be subject to the decision of the Honorable Supreme Court in Ramachar versus so and so.
Much.
1 gunta out of 23 guntas, you are asking for trouble. You will end up in further litigation.
It will be further.
Bill number 15.
Initial sign for the petition. Annexure K, page number 88 is the impugned notification regarding uniting the application for allotment of fishing rest in particular time. Without providing the reservation, they are allotting the single.
Randomization, my lord. I have filed objections in one of the matter. It's coming up on
Very same
21st.
similar situated matter.
Accepts notice for
It may be
respondent number 1,
connected
2, 3. Connect with so and so. When is that
I have
matter?
given the
The
number.
impugned order,
I have given the number.
When is it?
21st, my lord.
21st.
Released on 21st.
It may, the similar situated matter stayed by this number not to finalize the tender process.
We're not granted
There
any
is no
stay in those.
Initiated, I have to do.
Lift irrigation and this one, we'll consider it on that day.
Serial number 16. Kiran R.
Yes, Kiran.
Annexure A, page 10 is the endorsement issued by the passport authorities about the pendency of the crime number 9 of 2017. Still it is in the crime stage, my lord. No charge sheet has been filed.
Yes, but you have to seek for permission.
That's what, my lord. The endorsement says that I have to seek for permission, my lord. Travel permission anyhow I will seek from the magistrates.
Before you travel. Short while. Swamini Mohanambal accepts notice for respondent. Petitioner is before this court seeking for the following reliefs. The petitioner, being a permanent resident of JP Nagar, Bangalore, is working as an executive engineer in the Karnataka State Warehousing Corporation. The petitioner having made an application for renewal of his passport, they said up an endorsement at Annexure A dated 2/7/26 came to be issued, stating that the petitioner had not submitted the court judgment decision allowing the petitioner to travel abroad. Since there was a proceeding pending in crime number 9 of 2017 initiated by the ACB, Bangalore City Police Station. Now, counsel for the petitioner submits that before the petitioner were to travel, he would obtain the said permission from the concerned court seized of crime number 9 of 2017 and only thereafter travel. In view of the said undertaking of the petitioner, categorical undertaking of the petitioner, and the considered opinion, this court is of the considered opinion that the right to travel being a fundamental right under Article 21 of the Constitution of India, as recognized and upheld by the Honorable Apex Court in Mahesh Kumar Agarwal so and so. The respondent passport authority cannot deny the renewal of the passport to the petitioner, albeit the renewal can always be on short validity, on a short validity basis. The interest of the respondent being safeguarded by the petitioner obtaining such permission from the court seat of the criminal proceeding before traveling abroad. In that view of the matter, this court passes the following order. Writ petition is allowed, a certiorari is issued, the letter dated 2/7/2026 bearing reference so and so at Annexure A is quashed. A mandamus is issued directing respondent to consider the application of the petitioner and grant renewal of the passport of the petitioner on a short validity period within a period of 15 days from the date of receipt of a copy of this order. It's made clear that the travel of the petitioner the petitioner shall be permitted to travel only after obtaining permission from the court seized of the criminal proceedings.
17. HP Leeladhar.
Petition is sought for writ of mandamus to direct the respondent number 3 to 5 minutes. And also not to interfere with the running beauty spa minutes.
Spa. And AG accepts notice for respondent relist on
22/7.
22nd at 2:30 p.m.
Serial number 18. Yes, Vishweshwaraya.
Let's appear for petitioner.
Yes.
But petitioner is the highest bidder and he has participated in the action and deposited 25 lakh with the bank. But subsequently, borrower has challenged the action sale before this honorable court. And
For
the
refund. The refund check ಮಾಡಿ ಬರುತ್ತಾ ಇಲ್ಲಿ ಅಂತ. Union Bank of India.
Divya Purandar.
Ms. Divya Purandar is directed to accept notice for respondent. Counsel for the petitioner served 2 sets of the petition along with annexures on the said counsel. Registry to verify the classification of the matter and post the matter before the appropriate bench on 21st July.
21st July, March.
19.
Yes. Were you heard by the respondent?
He was heard by the respondent, but I'm challenging the lack of jurisdiction also, my lord. For the reason that when second respondent is a superintendent of police, my lord. Which is sponsoring authority is the respondent number 3 is the police inspector of the Kundapur police station, my lord. Directly is subordinate to the second respondent, my lord. The division bench of the Madras High Court held that, my lord, the power granted under section 20 of the CRPC, appointing any person as an executive magistrate, which will not apply to the police officer. Now, the judicial powers given to the police officer, which were discarded by the Madras High Court, division bench of the Madras High Court, my lord. Now, here, my lord, Taluka executive magistrate, I have produced the annexure, my lord.
Page.
11 para, my lord. Page number 118, my lord.
118.
18. Para 100, my lord. Before that page, para 94 also with regard to fairness and impartiality, my lord. But para
94.
94, my lord. Para 100, my lord. Page number 118, my lord.
ಯಾವ para?
Now I will first I'll relate para 100, my lord.
100. You are making us, yes, 100.
The argument that the police officer would come within the net of the term any person under section 20 of 21. 21 means it's a CRPC, my lord. Was rejected with the following observation. It is true, as contended by the learned additional advocate general, that the superintendent of police is the person well posted with the local factual situation of the persons who has a proclivity to involve in offences to disturbing the public peace, law and order, and committing the crime, etc., and that he is charged with the duty to keep safety and security to the society. They are indisputable. But the question is an exercising the power under section 20 clause 1 and section 21 of the code, though discretionary, can the government appoint any person whomsoever it likes, or whether the exercise of the power should be in conformity with the statute, with the designated class of persons to be officers. True, normally it is acknowledged the fact that the officials from the executive revenue branch, that is the district collector, RDO, Tashildar, or deputy Tashildar having the local jurisdiction are being appointed as executive magistrate and have been exercising the powers under the sections referred to earlier. But the question is whether the superintendent of police, the handmaid of law and order, could be invested with the powers to execute upon the same at the cost of reputation. It is to be remembered that
it's a categorical finding. SP cannot be.
Let me get instructions.
We'll state to get your instruction. This is important. Learned AG accepts notice for respondent number 1 to 3. Taking into consideration the decision of the division bench of the Honorable Madras High Court in 2023 SEC Online Madras 9008 P. Satish versus State. More particularly, para 100 thereof, wherein the Honorable Madras High Court has categorically concluded that a superintendent of police could not be designated as an executive magistrate in respect of under section 20(1) and 21 of the Code of Criminal Procedure. In the present case, the impugned order having been passed under section 55 of the Karnataka Police Act by the superintendent of police acting as a executive magistrate would fall in the teeth of the said judgment in P. Satish. As such, the operation of the order dated 24/6/26 bearing number so and so passed by second respondent and annexure A is stayed till the next date of hearing. Objections, if any, to be filed on or before 3rd August, relist on 11th August.
20, Bharat Kumar.
Recreation Club. And AGA for respondent, ಅದು benefit of so and so. ನೆನ್ನೆ ಒಂದು ಮಾಡಿದೀವಿ. Benefit of the interim order in so and so is extended to the petitioner. Connect with so and so, relist on
17-8.
17-8. ನೆನ್ನೆ
31.
ಮಾಡಿದೀವಿ.
PM Arun.
Yes, Mr. Arun.
That's payment of amount which has matured under Rural Electrification Corporation. The petitioner's father expired, he was a joint owner at page 9. Along with him, and he filed an.
Respondents.
You are appearing for whom, madam?
Respondents.
All. When will you release this money?
It will be listed after 2 weeks. We have sorted for the instructions. It may be listed after 2 weeks.
Can't be delaying these kind of things.
I'll seek the instruction and I'll make my submissions.
We'll increase the interest double. People's money you have to give back.
Yes, my lord.
Whose name has to be mentioned?
Satyavati. Satyavati.
Ms. Satyavati. Write down the full name. Accepts notice for respondent 1 to 3. She seeks for and is granted a week's time to obtain instruction, make a submission as to when the release of the matured amount.
In terms of direction under Annexure E by the.
In terms of Annexure E.
Page 22.
Would be made. Relist on 21st July.
Great.
Serial number 22.
But I appear for the petitioner. The question regarding the layout approval in KADB areas was settled by this court by a comprehensive judgment in September 2024.
Yes.
Annexure J, page 38. On the same day, this honorable court disposed of the matter pertaining to petitioner at Annexure K, page 75, based on that judgment, and directed at page 80, operative portion. The writ petition is dismissed, but the petitioner is however granted a period of 60 days from today to make payment of the balance amount due to KADB so as not to be default of the obligations. That I have made within 2 months. 1,83 lakhs are paid immediately thereafterwards. Page 81, typed copy is at page 82. Ivattargu possession kottilla. No proceedings are. Despite this court clarifying in that matter, in all these matters.
And AGA accepts notice for respondent 1. KDB.
R1, my lord.
KDB ಯಾರಿದ್ದಾರೆ? Accepts notice for respondent number 2. He seeks for and is granted 2 weeks time to obtain instruction and make a submission as to why, despite payment of the balance amount as far back as on 21/11/2024, neither the possession of the subject property has been handed over to the petitioner nor a lease cum sale agreement executed in favor of the petitioner. Relist on 29th July.
The 20th 11. The payment was made on 20th 11.
2011-24.
First intimated to them.
2011-24.
Some date.
29th.
Please.
Serial number 23. Rakshita DJ.
Respondent number 2 had issued notice inviting tender dated 20/11/2025.
Yes.
Subsequently, petitioner has participated and petitioner is declared as the successful bidder. If I may request my lord to kindly take page 43, my lord.
The process is not completed.
It is not completed. Page 43, if my lord sees, letter of intent is also.
And AGA for respondent number 1. RGUHS.
Farah Fatima.
Ms. Farah Fatima is directed to accept notice for respondent number 2. She is directed to secure instruction, make a submission as regard the status of the tender dated 2011-25, subject matter of the above petition. Counsel for the petitioner served 2 sets of the petition along with annexures on the said counsel. Relist on 29th July.
That we one indulgence, my lord. Till then, any action taken, let it be subjective.
You want them to process it.
But if they cancel, so my apprehension is if they cancel.
We'll see.
Obliged.
24.
Mandamus. Consider the petition representation as per Annexure R. This case, my lordship, 4 persons are died in the road traffic accident. Initially, due to negligence of the lorry
Annexure
driver.
R is page number
Page number 174, my lordship. I'm seeking for further investigation for the reason is that, my lordship. Initially, the FIR registered against the lorry driver. Subsequently, by recording the statement of the lorry driver and cleaner, charge sheet is laid against the car in which the deceased and his friends are going proceeding, my lordship.
Who are you
I'm the father of the deceased, my lordship.
in the car driver?
Yes, ma'am. Abetted charge sheet has been filed against the deceased.
Huh?
And even though the deceased possessing the valid DL and insurance, the ME Act also invoked while filing the charge sheet stating that he did not possess any valid DL and insurance at the time of alleged accident. So I produced all those documents before your lordship.
You will have to make the application before the court seized of the matter once the report has been filed.
I'm seeking for further investigation, my
You will
lord.
have to do it before that court.
Because now the proceeding is going on.
Not on the basis of mandamus representation in a criminal investigation. If they don't do anything, yes, we'll direct them. They have done, they have filed the
I have
charge sheet.
requested
You have
them,
a
I
grievance
requested
as
the
regards.
investigation agency on the several occasions. And also I have requested them to change the investigation officer stating that we are not faith with the investigation agency.
That you raise it
that,
in the before the court in seized of CC 183 of
My lord.
26. And AG accepts notice for respond number 1 to 5. Petitioner is before this court seeking for the following beliefs. The grievance of the petitioner is that on
25/7/25, my lord.
what is the crime number?
Crime number.
Crime number 143 of
143/25.
25, having been registered by the Madikeri Rural Police, Madikeri Subdivision for offences under section 281, 106 bracket 1 of the Bharatiya Nyaya Sanhita 2023. Investigation has not been carried out properly, and a charge
Actually,
sheet.
the FIR is against the lorry driver. Thereafter, charge sheet.
We are not observing anything. So if we observe anything, it will be a problem. Improper charge sheet. Investigation has been carried out improperly and a charge sheet has been laid in CC number, which is now pending in CC number 0143 of 2025. The submission of Shri Girish B. Baldare, learned counsel for the petitioner, is that the investigation not having been have been conducted properly. A representation had been submitted by the petitioner on 28/6/2026 at Annexure R, calling upon the investigating officer to reinvestigate and or carry out further investigation in terms of the points which have been pointed out, issues which have been pointed out by the petitioner. Once the charge sheet has been laid, this court cannot direct the concerned officers to carry out further investigation as sought for by the petitioner. It would be for the petitioner to approach the court seized of CC number 183 of 2026, making appropriate request. If such a request is made, the court is directed to consider the same and pass necessary orders in accordance with law. With the above observation, petition stands disposed.
All the contentions of the petitioners are yet to be considered.
25, GB Nandish Gowda.
Yes, Nandish.
Hearing for petitioner. Joint compromise petition has been filed before the trial court, my lord. The same has been.
Lok Adalat.
Lok Adalat. My lord, they have been, while my lord, accepting the compromise, my lord, they have, my lord, included
Where is
the
the
land
compromise petition?
annexure G, my lord.
Page?
Ink page number 63. My lord, what happened, my lord? Previously, suit has been filed with respect to land. Kindly turn to ink page number 42 for a moment.
You are a party to the suit.
I am not a party to the.
You are not a party to the suit.
My lord, what happened? Suit has been filed with respect to land bearing survey number 4/2 measuring 2 acres 20 guntas. Kindly turn to ink page number 42.
42.
Schedule of the plaintiff. My lord, the respondents number 1 to 4, my lord, they have manipulated entire court documents without there being any order from the court. They have included the land belongs to the petitioner 6 guntas. My lord, 2 acres 26 guntas. Suit filed with respect to 2 acres 20 guntas. My lord, they have manipulated entire court documents, plaintiff written statement, applications, affidavit, including the plaintiff evidence affidavit. Also, my lord, they have manipulated 2 acres 26 guntas. And my lord, compromise petition is filed.
Manipulated and they have Included your property.
Included my 6 kuntas.
What
also.
document is there to show that you are the
But,
owner?
the very same, the annexure A is the sale deed. The very same plaintiffs, my lord, they have executed the sale deed in my favor. Pursuant to that, my lord, annexure B, kindly turn to ink page number 28. Mutation has been registered in my favor. Thereafter, my name entered in the revenue record, annexure C. I have produced the latest RTC, ink page number 29.
29.
ಅದರಲ್ಲಿ ಹಿಸ್ಸಾ ನಂಬರು ಆಗಿದೆ 4/13 ಅಂತ ಆಗಿದೆ.
6 Gunta Sunita N.
ಹಾ.
Issue notice to respond number 1 to 4. One of the few matters where compromise. Most of them, the signature is there, everything is there.
ಅಲ್ಲ ನಂದು
Name the different again. Issue notice to the respondents returnable by 17th August. Considering that in terms of the documents which have been produced, the petitioner is the owner of 6 guntas of land in survey number
4/2.
which has been, as regard which ISA 40 has also happened, and now is numbered as 4/13, which is also included in the compromise entered into before the Lok Adalat in OS number
213 of
213 of
2021.
2021. The operation of the compromise decree.
ಡಿಕ್ರಿ ಅಂತ ಹೇಳ್ಬೇಕಾಯ್ತು. ಡಿಕ್ರಿ ಡೇಟೆಡ್ 8/3/2025.
Decree dated 8/3 order ಅಂತ ಹೇಳಿದಿರ. Decree dated 8/3/25 passed by the principal senior civil judge and JMFC at Anekal. He stayed till the next date of hearing. Process fee and copies to be furnished by end of day 15 July, failing which the interim order will stand automatically vacated. The petitioner, as also the respondents, are restrained from any manner dealing with alienating, encumbering, or changing the character of the subject property till the next date of hearing.
26, Harshavardhan.
Yes.
I appear for the. This is the tender called out by the respondent number 7. Who is the tender calling authority of the respondent number 6, my lord? The respondent number 7 called out the tender for providing security services, housekeeping services, and ward attendant services. 3 separate tenders were called out on 17/2/2026, my lord. While calling out, they had inserted some arbitrary tender conditions, my lord, which may be seen in the page number 66, my lord. Page number 66 of annexure A.
Yes. This tender was called on?
Called on 17/2/2026, my lord.
17/2/26.
17/2/2026. In, there were several arbitrary tender conditions, my lord.
Yeah,
Which, one is, in case, page, kindly see page number 66, my lord.
Yes.
Appendix H, point number 13, my lord. In case more than one bidder is identified as L1, the bidder offering the highest performance security deposit above the stipulated 5% submitted in the form of demand draft shall be considered for award of contract. My lord, that is, there is no provision to insert such kind of conditions. In the KTTP Act, there is only, they can only award the tender either on the basis of LCS method or on the basis of QCBS method. My lord, kindly see page number 48, madam. 48, kindly, page number 48.
Yes.
Below the table, point number 6, my lord. In case of more than one bidder is L1, the quality and cost-based selection method, bracket QCBS method shall be followed for final selection and award of the contract. This was the main selection criteria which was fixed by the respondent number 7.
You participated?
We participated, and more than 3 bidders came to be L1. And
that before participating, you did not raise this issue?
No. We raised it in the pre-bid meeting itself.
Where is that?
24/2 and 2026 pre-bid meeting was held.
Page number?
And we had raised our objections on the pre-bid meeting itself, my lord. That is Annex. Sorry, just. Pre-bid meeting, my lord. That is annexure H, my lord. Page number 403. Page number 403, my lord.
403.
Yes, my lord. 403.
Where is this issue raised?
My lord, we pointed out table wise, my lord.
Show us the.
Table wise. Yes.
Show us this aspect. Where did
This,
you?
this aspect is page number 405, my lord. Page number 405. In case of more than one bidder is identified as, that is the tender condition. On the right side, we have raised our objections, my lord. In table, when more than one bidder is identified, designated as L1, it is inappropriate to favor the bidder providing the highest performance security, as this goes against.
What is the response to this?
There is no response, my lord. Actually, when more than three bidders came to be L1, they decided to continue with the same procedure, and they fixed some meetings. They more than 3 to 4 times they postponed the meeting for selection of the.
All three of you are the
bidder.
same. L1 5%.
Yes, madam. The selection criteria was the same, and they kept on postponing the meeting, and finally on 22/6, after strong objection from our side, they recalled the tender. They recalled the tender and issued fresh notification.
Tenders are a farce. You say 3 to 5%, 3%, 4%, 5%. Everybody quotes 3%. Everybody quotes 5%. Everybody quotes 5, whatever percent.
Yes, madam.
All these issues happen. And then you are saying we will give more.
Can I make one submission, my lord? I admit that the correspondence annexure W is against KTPTP. Just let that be stayed, my lord. Since he has participated in the tender, once it is stayed, annexure U will come into picture. Where I have at 36, my lord, page number 443.
Please request Advocate General or Additional Advocate General to assist us in this matter. These kind of manpower services, which is basically outsourcing without hiring. You are only paying that to the contractor. And once you say that it can't be below this, plus or minus, everybody will quote only that. After that, how to assess this? You can't do this proportionate whatever. QCBS is maybe fine. Even QCBS is a problem.
One more submission, my lord. After this, they recalled the tender dated 17 to 2026.
You are also equally responsible.
No, my lord.
The exception is he is still providing the service for me from last 5 years.
Every one
more submission. They recalled the tender and they deleted that condition by provisionum dated 30/6/2026, my lord. And they kept silent till 7/7/2026. Just before 2 days of last date for submission, they again reinserted the same condition, my lord, to favor some particular bidder.
Yes.
That is highly arbitrary.
All the bidders are here only. And AGA for respond number 1. Bangalore Medical College and Research Institute. Sumana Baliga for respond number 2, 3, 4.
My lord, Sumana Baliga is not in the panel, my lord.
BMCRI. Bangalore
Mohammed
Medical.
Ayub.
Yeah, Rama.
Mohammed Ayub is in the panel. Sumana Baliga is not in the panel, new panel, my lord.
Mohammed Ayub for respond number.
Basuraj Patil and
2 to 5. Either 6 and 7 or na?
6 and 7 over.
Mohammed Ayub for respond number 2 to 7.
My lord.
Any action taken by the respondent post in respect of the tender notification subject matter of the above petition shall be subject to the final result of the above petition.
My lord, kindly stay the further proceedings. They already technical bid is
The issue
opened
is
and
the
they are
corrigendum, my
they are
lord. If
going to
that is
proceed the
There are
further
people required, it
open
will
the
be
financial
subject to that. IA 1 of 26 is allowed. Yes. Please request AG or AAG
They have
to
already,
assist.
they are acting upon the second corrigendum, my lord, that's why.
Released on 21st July.
Much.
Serial number 27 Arjan, serial number 28 Krishna S. Vyas.
For the respondent, my lord.
That's
The last date of hearing, my lord, I have given the copy of the same for verification, my lord. The reason for rejection of their applications.
Have you furnished the copy?
Yes, my lord.
Lords, on the earlier occasion, the submission was made that a single window committee has cleared my proposal, my lords, and the project has been approved. Posterior to that, my lords, I had made a representation that it is not given to me, one allotment has not been provided to me, and I find on the website that, my lords, my status is shown as rejected. No reasons have been attributed towards that.
Now
Then
he has
I make
given
a
you a copy.
representation. I will complete, my lords, sir. I make a representation, my lords, on 25/8/2025, after which I have approached this honorable court, my lords. Learned counsel for the other side had submitted before the court that, my lords, the representation, whatever has been submitted by me on 25/8/2025 has already been replied by them. And they will give a copy to me, my lords. On that aspect, my lords, your lordships had informed on the earlier occasion that because the prayer too would not be fructuous, my lords. But they have given the copies which does not contain any reply to my representation, but it is an internal communication, my lords, amongst themselves.
Give us a copy of the order. Where the rejection order? What
No
have you
rejection order till
communicated?
date, my lords. It is a letter which has been addressed by the principal secretary. One nimisham, sir. Sir, one nimisham.
Gopal, you can have any number of communications between. Have you communicated to the petitioner? And communication agila andre?
It is a representation. We will consider the same and we pass the order.
Lords, one more request I have.
We are allowing your petition, that's all.
Yes, yes.
What you have
As good
sought
as
for, you are
allowing-
getting.
Only one aspect, my lords, I want to add here is that this single window committee, my lords, is for a particular project to be approved. Post, after the single
That
window.
you can raise once you get the rejection. We don't know what the rejection order is going to be.
In the event that, my lords, my only request is that in the event that single window would be appropriate, I'm not asking in this project, any project for that matter. They say that there is a upper limit capping of about 15% in a particular project, my lords.
For that, you'll have to submit one more. We can't pass that order. Can we pass such an order?
Yes. Yes.
Petitioner is before this court seeking for the following leaves. The submission of learned counsel for the petitioner earlier as also today is that the petitioner grievance would be redressed if prayer at Roman 2 is granted. The Gopal BV learned counsel for respond number 2 and 3 submit that. By when will you consider it, Gopal? By when will you consider the representation pass orders? Yes, Dina. How long?
8 weeks.
Very long time.
I think 8 weeks in a couple. New submission now
My validity of a single window committee report is up to.
This is from 24 it's pending. Half this litigation should not come before the court if you do your job. August 25, 1 year. And you want 8 weeks more. The representation of the petitioner dated 25/8/25 in persons of the approved 27/2/24 communicated on 11/3/24 is still to be considered by the respondents. Whenever any approval is granted by a concerned authority, the other authorities required to act on the same are required to do so with alacrity and as early as possible. The sanction in the present case having been made on 27, approval of the sanction having been made on 27/2/24. No action having been taken, the petitioner had submitted a representation on 25/8/25, which has also not been acted upon by the respondents till date. It reflects poorly on respondent number 2 and 3. KDB ಯಾವಾಗ ಬೇಕೋ ಆಗ immediate next day it will be done. ಯಾವಾಗ ಬೇಡೋ 2 years, 2.5 years now. In that view of the matter, this court passes the following order. Writ petition is allowed. Respondents are directed to consider and pass necessary orders on the representation of the petitioner dated 25/8/25 at Annexure G within a period of 4 weeks from the date of receipt of a copy of this order. Yes, a single window clearance sanction committee. I-1 of 25 is allowed.
Serial number 29. Pradeep Kumar.
Appear for petitioner.
Yes.
I seek for short accommodation, my lord. Senior is not.
ಏನಪ್ಪ ಇದು ಕೊಡಿ.
Under the KPID Act, my lord, lands of the petitioner have been attached.
KPID.
There's an alternate remedy under section 16.
We won't pass. And AGA for respond number 1.
Viresh Budhyal.
1 and 3. Viresh Budhyal for respond number 2. Shruti Sawadra, any standing counsel? That is under liquidation. No? Viresh Budhyal for respond number 2, 4 and 5. Post before a bench of which SGRJ is not a party.
Case I'm preparing for respond number 3 to 5, my lord.
3 to 5.
The learned AG is online, my lord. 4 and 5. And I need.
One nimsha,
Okay,
just
the respondent in the matter, my lord.
Your lordship's recall, this is that water sharing matter.
Your petitioner, this one only is. You, Ms. Bhima, you appear now for whom?
3 to 5, my lord.
KVGN.
And 3 I filed wakalat.
KNNL you appear for.
Yes. Kaveri Niravari.
The matter for 22nd.
Registry. Registry direct to correct the appearance of the council has learned AGA for respond number 1.
2.
Shri K.S. Bhimaya, 1 and 2.
1 and 2.
Shri K.S. Bhimaya for respond number 3 to 5. 6 yaru.
Let's I appear for respond 6.
Shri Shurudrappa Shetkar has that appearing for respond number 6. Yes, Mr. Advocate General.
My lords, kindly have it next week, my lords. We'll file our objection to the matter, my lords.
Now, if you are going to cut across that particular channel.
Was made in court acquisition. Argument was made misleading this court.
Delhi, my lord.
Delhi ಅಲ್ಲಿ ಇದೆ.
My lord, the other two connected matters are, they have been substantially heard and they are posted for dictating.
May I make one
Coordinated bench.
May I submit on
Yes,
this?
my lord.
I have submitted on the last occasion that the oversight.
By the very same council.
May I
Matter
just
reserved
submit?
for judge and listed today before quote number 12.
It's the same point.
May I just? May I just?
Just one moment, madam. Let him complete. If all of you talk, who is going to listen? Somebody has to listen. Yes, Mr. Advocate General, we can't hear you well.
Am I audible now, my lords?
Slightly, yes.
Uh,
There is
my
echo
lords,
also.
no, my lords. Now I am audible, my lords.
Yes, please.
Now, my lords, the landowners had sought to challenge the acquisition, my lords. While challenging the acquisition, the very same argument which is raised in this writ petition was also raised. They are not, my lords, and with regard to whether the straight line can be drawn or not drawn, whether the whole case in this is, my lords, 3 TMC of water has to be given to downstream, my lords, insofar as 2 area extension pleadings were placed before the coordinate court. Matter was argued, is listed today for dictating judgment, my lords. Your lordship may have it next week. We'll file our objections, my lords.
When is
And
it
very
posted
same
for
council has
dictating
already
judgment? Today.
Today, my lords. Today.
It is posted. Yes.
May I just submit? Now, what has happened in this case is, as I submitted on the last occasion, the land losers have also challenged the acquisition, and they've also challenged the constitutional validity of the Karnataka State Amendment Act to the RFCTLI-RR Act. In that, I'm common counsel representing both the land losers and the persons who are affected by the project. So I made the submission on the last occasion that 2 other petitions are also pending. Now, in that matter, their entire argument, my lord, was that the project cannot be challenged in the land acquisition matter. This is an independent challenge to the project by persons who are beneficiaries of who live along the distributaries, whose lands are along the distributaries and who are beneficiaries of the drinking water schemes along the main canal. So in fact, their contention in that matter was
The
that
petitioners herein are petitioners there also?
no, my lord. Here they are the beneficiaries of the distributary canals and the drinking water schemes from chainage 70 kilometer to chainage 167 kilometer. That is along the main canal. My lord would just see one map at page 55.
Now that
which
it's
will-
posted for dictating judgment
Hello.
today,
My-
let the judgment come. We don't know what the impact is going to be. Let it be placed on record and then we can take it up.
My only submission is that the cause of action in that and in this is different. But if my lord please chooses,
We can't second guess right now,
My
nor
lord.
can any of you.
My
We'll
lord.
see what the judgment comes and
Yes.
then see.
my lord,
And it's posted for dictating judgment today.
my lord would give me a date next week.
Otherwise, we would have connected it there, but again, it'll come back here
Yes,
because
file
senior
objection.
judge, so that's why we are not connecting.
My lord.
Then that will get upset, so.
This matter at file objection.
File your
Some
objections.
time maybe.
Let the AGA as also number 3 to 5
Yes.
seek for and are granted.
1 week, the learned advocate general asked for 1 week, my lord.
Need my lord.
My lord,
2
1
weeks,
week.
minimum 2 weeks.
My lord, the learned advocate general mentioned and asked for 1 week's time.
That is, he is representing, we are asking for 3 to 5.
My lord, they have already, if their
Hey,
contention
next
is,
time you come for NHA, I will tell you how much time we will give you. That time you want 4 weeks time.
I have never, I mean, there may be an occasion when I will seek, my lord, but
Seeks fund is granted 10 days time to file a statement of objection. Objections, if any, by 24th, relist on 29th July. By that time, that order will also.
31. Tejaswini ji.
Yes, madam.
My lords. I am the L1 bidder, my lords.
You are the L1.
Yes.
Yes.
And the financial bidding has been published in e-portal, my lords. Later on, the respondent number 2 has not, respondent number 1 has not complied with the section 14 of KTPP Act, my lords, the general rejection. I am depending upon my lords, this court
Section
decision.
14. KDTPI. What does section 14 say?
Can I read out, my lords?
General rejection.
General rejection.
So there's a general rejection which has been made here.
They have not announced, they have not compelled, respondent 1 has not compelled the general rejection, my lords. As per section 14(2) also, they have not informed any bidder about the cancellation of the tender, my lords.
Yes. So what do you want? You want cancellation?
No. I would re-tender ಆಗಿರೋದು cancellation ಕ್ವಾಶ್ ಮಾಡಬೇಕು, my lords.
You cancel ಆಗಿದ್ಯಾ?
ಅದು ಕ್ಯಾನ್ಸಲ್ ಆಗಿ ರೀಟೆಂಡರ್ ಮಾಡಿದ್ದಾರೆ, my lords. I was the L1 bidder for the old tender, which was called tender notification bearing number IND 0305 and IND 0306.
That was issued on 39/25.
39/25, how do,
Yes.
my lords. Then the financial bid was opened on 27/3/2026, my lords.
Where is this 18/4/26 order?
18/4/26, the tender committee resolves to cancel the subject tender and call for the fresh
Where is that
short-term tender.
Where is that order?
Lordship, I have furnished it along with the memo.
You have furnished it.
Yes, Lordship.
I have furnished that, my lords.
At page
Annexure
number?
R1. Annexure R1.
One of you somewhere.
111 to 125, my lords.
111.
119 to 125, my lords.
19 is
Annexure E.
18/3/26 proceedings of the evaluation committee.
Proceedings ಹಾಕಿದ್ದೀನಿ, my lords.
Where is that 18/4?
18/4. sorry, my lords, 18.4,
You have produced it, madam,
104
18.4 at annexure R1.
annexure G, my lords, 133, my lords.
As per note, date, so and so.
They are filed up.
There was a improper rejection of iSense biosensors.
Yes, my lords.
So the process not being done properly, they decided to retender.
Yes, my lords. But my lords, here the respondent 1 and the respondent number 3 had the provision to apply go for an appeal, my lords. As soon as he came to know that his bidding has not been accepted,
A mistake conducted by the authority is being sought to be rectified by them.
but my lords, the respondent 1 number has not compelled with the section 14.2 of KTPP Act, my lords.
This is the reasoning that they've given.
ನೋ ಮೈ ಲಾರ್ಡ್ಸ್ ಏನಂದ್ರೆ ನಮಗೆ ಗೊತ್ತಾಗಿದ್ದೆ ಯಾವಾಗ ಹೊಸ ಟೆಂಡರ್ ಅನೌನ್ಸ್ ಆಯ್ತು ಅವಾಗ್ಲೇ ಗೊತ್ತಾಗಿದ್ದು ಮೈ ಲಾರ್ಡ್ಸ್, ಅದಕ್ಕಿಂತ ಮುಂಚೆ ನಮ್ಗೆ ಹೇಳಲೇ ಇಲ್ಲ ಮೈ ಲಾರ್ಡ್ಸ್, ನಮ್ಗೆ ಯಾರಿಗೂ ಇನ್ಫಾರ್ಮೇ
ಹೊಸ
ಮಾಡಿಲ್ಲ.
ಟೆಂಡರ್ ಯಾವಾಗ ಇಶ್ಯೂ ಮಾಡಿದ್ದು? On 26/5.
ಹೌದು ಮೈ ಲಾರ್ಡ್ಸ್.
ಆಯ್ತು. Have you participated in the new tender?
ಎಸ್ ಮೈ ಲಾರ್ಡ್ಸ್, ಐ ಹ್ಯಾವ್ ಪಾರ್ಟಿಸಿಪೇಟೆಡ್.
You will be considered at that time. We don't see anything wrong with this order because there was an issue.
My lords, what has happened? ಏನಂದ್ರೆ my lords, I have already my financial bid has been open, is been published, my lords. I have given the lowest bidding in my financial bid, my lords. ಎರಡು ಟೆಂಡರ್ ಅಲ್ಲೂ ಅಷ್ಟೇ my lords. My lords, ಇವಾಗ it has been published.
See,
and
sometimes tender proceedings don't happen, go through. It's again reissued. That doesn't mean for that reason we can say that it can't do a fresh tender and theodaka.
Correct, my lords, but the respondent one has not compelled with the general tender clause of section KTPP Act, my lords. Adike I have submitted the citation of this honorable court.
Yes, now only thing that they will do is they'll issue one more letter. If that happens, your second tender will also go. You want that to happen?
ಆಗಲ್ಲ ಮೈ ಲಾರ್ಡ್ಸ್, ಯಾಕಂತ ಅಂದ್ರೆ ಮೈ ಲಾರ್ಡ್ಸ್, ಮೈ financial bid has been opened and it has been published. Once again competing, see all the competitors.
It always happens in a tender, madam.
ಹೌದು
That
my
always
lords, but
happens in a
respondent
tender.
number 2 has not one has not compelled with this
Please
rejection.
understand the effect of what
On
you're
that
saying.
grounds it,
Please understand the effect of what you're saying. Now they'll issue one more letter in compliance with 14.2. That tender which has been issued, that will also go. Now a fresh tender will have to be done. That will be delayed by another 3 months.
my lords, kindly go through this citation what I have provided, my
Yes.
lords.
40.
Page number 12, my lords.
Yes.
Page number 12, para 19, my lords. It is very clear whether the general rejection of the tender has indeed taken place, because under section 14.2 of the said act, the rejection order is to be communicated to all the tenders and it has to be published in the tender bulletin. On being asked specifically, asked the learned counsel for the respondent submits on instruction that the rejection is not communicated to the tenders and it is not published in tender bulletin. However, he submitted that the tender can open e-portal online for the purpose of ascertaining the
Madam,
status
we are aware
of
of this decision. Come to para 21.
20, my lords.
21 nodi.
Similarly, this
That
crash
is
of
what
the
will
fresh
adversely
tender
affect you.
notification does not mean the petition. My lords, in this, the petitioner is blacklisted, my lords.
ಓದಿ ಅರ್ಥ ಮಾಡ್ಕೊಳ್ಳಿ, ಅದು 20. Come to 21 and read it. Second, if the respondent proposed to terminate.
Perennially, if the respondent purpose to terminate the tender person indebted to the earlier notification and assure, they can do so far on the grounds enumerated in section 14(1) and in the manner prescribed by section 14(2) of the said. Even section 1 also will not be compelled upon my lords.
See,
Because
we will pass the same order.
my lords,
You want to get instruction from your client, please get. Because this is only postpone it by 3 months. Same, whatever situation is today, 3 months later.
the purpose will not be served, my lords.
That is what we are trying to tell you. That's exactly what we are trying to tell you.
Yes, my
At least now
lords.
you have participated. If you succeed, you will get it. If you don't succeed, you won't get it, obviously. You will file some other litigation. But if we pass the same order today, it is only getting postponed by 3 months. Get instruction from your client and then make your submission.
This destroys my competitive neutrality and
That is the order passed
transparency,
which you
my
are
lords.
relying on. That is what we are passing.
As it were my
Practicality, please understand. Pass over. Get instruction from your client as to what you want. You want same order.
much obliged, my lords.
It should not be operation successful, patient dead.
Much obliged.
P group matters, serial number 32. Praveen HP and connected by
Appear for the respondent number 2. The petitioner is challenging the orders of the RERA.
RERA, you have appellate remedy.
No, this is without jurisdiction for this reason. But may draw your lordship's attention to, they made a, I'm sorry to use the word, they made a mess of the entire thing and come out with a hybrid procedure. Kindly similar to the memo filed by me, which encloses the application filed before the RERA by the respondent, the second respondent, that your lordships get along with the memo dated 12th of February 2024.
12th February 24.
Yes, sir. Kindly see, my lord, the application is prayer made in paragraph 4. Complaint 18, return of amount and compensation. Return of amount and compensation. This is the prayer. 31 month delay in handing.
Just one.
I'm sorry.
12 to 24. Copy of the complaint you have in.
Yes, yes.
Where is that complaint? This is online complaint.
Online complaint.
Yes, page 5.
Yes, page number 2, relevant page number 4. The prayer complaint section, section 18, return of amount and compensation. Now 31 delay in handing over possession. The reasons are spelled out in paragraph in page 5. I made a substantial payment. The builder delayed in handing over. Builder has lost paragraph 2 as promised to provide for a deck garden, etc., etc. Now section 18 may kindly be similar at this juncture of the RERA enactment. Section 18. May draw your lordship's attention to section 18 of the act.
Return of the amount.
Return of the amount and compensation. Now, when the as on the date of the application, sale deed was already executed. Under section 18(1), the return of the amount would be before the sale deed is executed. If he doesn't want to go ahead with the matter, the sale deed to the logical end. Section 18.
Section 18.
Section 18, subsection 1. If the promoter fails to complete or is unable to give possession of an apartment, plot or building in accordance with the terms of the agreement for sale, as the case may be, duly completed by the date specified therein, due to discontinuation of his business or developer on account of suspension or revocation of the registration, he shall be liable on demand to the allottee in case the allottee wishes to withdraw from the project without prejudice to any other remedy available, to return the amount received by him in respect of that apartment, plot, building, as the case may be, with interest as the rate may be prescribed in this behalf, including compensation in the manner provided under this act. So subsection 1 does not arise because the sale deed is already executed. He has not surrendered the house. What he is seeking is the compensation. That your lordships get paid at subsection 3. If the promoter fails to discharge any other obligations imposed on him under this act, rules and regulations made thereunder, or in accordance with the terms and conditions of the agreement for sale, he shall be liable to pay such compensation to the allottee in the manner as provided under this act. Now, I draw your lordship's attention to page number section 71. This is compensation. Adjudication of compensation is a judicial process, even under section 71 itself. For the purpose of adjudging compensation under section 12, 14, 18 and 19, the authority shall appoint in consultation with the appropriate government one or more judicial officer as deemed necessary, who has been a district judge, to be adjudicating officer for holding an inquiry in the prescribed manner after giving any person concerned a reasonable opportunity of being heard. Now 72 may kindly be seen. These are the factors to be taken note of by the adjudicating officer. While adjudging the quantum of compensation or interest, as the case may be, under section 71, the adjudicating officer shall have due regard to the following factors, namely, the amount of disproportionate gain or unfair advantage, wherever quantifiable, made as a result of the default, the amount of loss caused as a result of the default, the repetitive nature of the default, such other factors. Now, there are two aspects. One is interest on the delayed delivery is concerned. The RERA has the authority. It doesn't have a judicial officer. So far as the compensation is concerned, it go before a judicial officer who has to adjudge the compensation under section 71. But this is what exactly the Honorable Supreme Court has said. But in the New Tech company, pass on the judgment. But I read out the provisions of the Act. Now kindly see section paragraph 86. Sir. Paragraph 86. Your Lordship got it?
Near page
Yes,
86.
para 86.
This is all tone.
Pardon? I'll pass on this. I'll give the defective copy to the other side.
Yes.
From the scheme of the Act, which a detailed reference has been made, and taking note of the power of adjudication delineated with the regulatory authority and adjudicating officer, what finally comes out is that although the Act indicates the distinct expressions like refund, interest, penalty, and compensation, conjoint reading of section 18 and 19 it clearly manifests that when it comes to refund of the amount and interest on the refund amount, or directing payment of interest for delayed delivery of possession, or penalty and interest thereon, it is the regulatory authority which has the power to examine and determine the outcome of a complaint. That is one. Second one, at the same time, when it comes to a question of seeking the relief of adjudging compensation and interest thereon, under section 12, 14, 18 and 19, the adjudicating officer exclusively has the power to determine, keeping in view the collective reading of section 71 and 72, that is factors of the Act. If the adjudication under section 12, 14, 18, 19, other than compensation is envisaged, if extended to adjudicating officer as pride, in our view, may interpret that's different. So now kindly see what the authority has done. Your Lordships get the order at page number 12, annexure A. What is sought is refund of the amount that does not arise. Maybe it's a mistake because the sale deed was already executed. Now he is seeking compensation. The adjudicating, the RERA at paragraph 1, this is the fundamental error. This complaint is filed under section 18 of the Act, praying for direction to pay delay period interest. Nobody has sought for delay period interest. He sought for refund of the amount and compensation. The moment the application is seen by the RERA, it should have transferred the matter to the adjudicating officer, which we are ready to go. The reason for the delay is we were supposed to deliver the project somewhere in 2019. The COVID ensued, and there was considerable distress in the entire real estate market. And we could justify our action of delay before the adjudicating officer, who will take into consideration 72 factors. Now, RERA says the application is fair for delay period interest. This is nobody's case. And page number 19, page number 18, may kindly listen. In exercise of the powers, page number 18, order. In exercise the powers conferred under
Take up
section
that
31.
condition before the authority that he does not
The
have the.
issue before the authority was refund of the amount, which will not arise because the sale deed was already executed. He did not surrender the project. The compensation. Compensation is exclusively within the jurisdiction of the adjudicating officer, a judicial officer under section 18(3), read with 71 and 72. So far as return of the amount, and interest is concerned, RERA has the authority for the return of the amount. That is why, my lord, section 18, subsection 1. 18 subsection 1, if there is a delay, then interest can be awarded by the regulatory authority. If there is a refund, Lord, kindly say section 18 again, Lord. If the promoter fails to complete, is unable to give possession of an apartment, plot or building in accordance with the terms of the agreement for sale, as the case may be, duly completed by the date specified therein, or due to discontinuance of his business as a developer on account of suspension or revocation of the registration under the Act, he shall be liable on demand to the allottee in case the allottee wishes to withdraw from the project without prejudice to any other remedy available, to return the amount received by him in respect of that apartment, plot or building, as the case may be, with interest at such rate as may be prescribed. This for the return of the amount. You kindly see, my lord, paragraph subsection 2. The promoter shall compensate the allottee in case of any loss caused to him due to the defective title. My lord, that does not arise. Then provide. The proviso is important. I'm sorry, subsection 1 proviso, provided that where an allottee does not intend to withdraw from the project, he shall be paid by the promoter interest for every month of delay till the handing over of possession at such rates as may be prescribed. Subsection 3 deals with the compensation. If the promoter fails to discharge any other obligations imposed on him under this act or the rules, regulations made thereunder, or in accordance with the terms and conditions of the agreement of sale, he shall be liable to pay such compensation to the allottee in the manner as provided under this. But subsection 1 till the proviso is within the jurisdiction of the RERA, including payment of interest for the delay in handing over the possession. So far as compensation is concerned, it's the adjudication under section 71.
18.1 is
Yes,
not
madam.
speaking of compensation.
No, 18.1 is not.
It's only speaking of interest.
Interest. So there are two aspects. One is if the allottee says, I do not want the project. If he wants to withdraw from the project, then refund of the amount with interest.
And the proviso
Then-
says if it does not intend to withdraw,
Then, my
he
lord,
shall be
interest.
paid interest.
Certainly. Now, what the application is filed for seeking refund of the amount which will not arise and compensation under subsection 3. The RERA converts the application, misreads the application into an application
What
under
the RERA has
18.
done is it's exercise the powers in terms of the proviso. It's
Yes,
proceeding
certainly
in
they have
terms
the power. They have the power, but the application is not for the interest. It is for compensation. It has to go before the adjudicating officer, which you are ready. We will explain to the adjudicating officer the reasons for the delay. The kindly see the application again, Miller. Application is for return of amount and compensation. The Supreme Court makes a fundamental distinction between adjudication and return of interest. Compensation is entirely different. Compensation, section 18, return of amount and compensation. Return of amount does not arise because he has not withdrawn from the project, because the sale deed is already executed and possession was already handed over.
Is this a drop-down complaint section, Gautam?
My lord.
Is this a drop-down that you have to select 18 under is automatic and
The website.
Illa, is it a typed portion?
No, my lord. On the website, you will get to choose.
You just drop it and 18 select, it will come like this. There's no application of mind by anybody to type anything.
They submitted in the website itself.
The moment the RERA sees this compensation, it should have referred to the adjudication.
Then there's a mistake in your website.
My lord, as per the records.
You should make it 18.1, 2, 3.
Yes.
The 18.1 is different, 18.2 is different, 18.3 is different.
We will.
18.1 is written with a payment of interest. 18.2 is adjudicating on the basis of defect in title. 18.3 is default and adjudication for compensation.
We'll adopt that, my lord, whatever.
Mr. Basaraj is taking advantage of that drop down that you have.
It's a hyper-technical argument, my lord.
No, if approved, this sets a very bad precedent henceforth. They can file any application.
Finally,
Also respond, my lord, in this matter.
Records
My lord, how the parties have proceeded, my lord, basically in this case.
yeah, let him complete.
Let him complete.
That is the first point.
This is a hybrid procedure adopted by RERA. The moment it sees the application is referable to compensation, It should have sent the matter to the adjudicating officer under section
Did you
71.
take up that contention before the RERA that you should send it to the adjudicating authority?
They have already passed the order.
No, when you filed your objections, did you take up that contention?
We have taken that contention.
My lord, for easy reference, I have the
The
record.
reason is this, my lord, this hybrid
Complete
procedure,
it and then you can show it. Otherwise.
this hybrid procedure, if approved,
You
it creates a
have
mess.
said hybrid quite a few times, but did you take up that contention? That you cannot decide it, it has to go under section 71 and 72 before the adjudicating authority and not by the regulatory authority.
My lord, the compensation overlooked the clause 18. We have taken the contention. We have taken the contention.
Or this is after suffering an order, you're taking up the contention
No,
because
this
you
was
are happy.
filed in 2023. Before the order was passed, this is the application, statement of objections was filed before the developer, before the RERA itself. Before the RERA itself. And calculation is flawed. Second reason pertains to, indeed it is submitted that a complaint is.
This is all beneficial legislation
But
where
it's
there are people
sometimes
who are
these
not,
things will not, things will improvise over a
not
period of time.
legally advised by lawyers and everything.
These things, my
They
lord, will
file.
improvise over a period of time because of the understanding the
It
correct
can't
legal
be
position.
technical in that. It has to be a little more liberal way of understanding how it is.
No, that's okay, that's okay. But the reason it goes to the root of the matter, the reason is it goes to the root of the moment if it is compensation, it goes before
The
the
compensation has not been awarded.
No,
It's
that's what
only-
I'm saying.
In
That
the
is why I say
relief which has been awarded is only interest.
that's
So it will
because
come
RERA
under the proviso to 18(1).
But it falls under 18(1) proviso. There is no doubt about it. In which case RERA has the authority. But an application which filed seeking compensation, the reasons given in the application is that I have suffered loss. Kindly see page 5. I have suffered loss because of the delay and all that. The kindly see the
Correct.
paragraph.
Read that
Page 5.
properly. As
Page
per the builder delayed handing over of the apartment by
Page-
31st,
Yes.
31
So,
month and handed over possession to be
compensation,
only
I
on
suffer.
January 5th.
Yes,
As per
certain-
clause 10, builder was
Construction, the
promised to pay an
builder has
amount of.
promised to pay so and so, so and so, complete a delay in delivering possession. By commitment, the amount works out to the builder has promised to provide for a deck garden, so and so, so and so, handed over the possession of the without these, seeking total of 16 lakhs from the builder for construction agreement. No, this is not interest, this is compensation. No, the RERA takes upon itself by misreading the application, but I can understand there is some application of mine. The first paragraph of the application, the order says praying for a direction to pay delay period interest. This is nobody's case. But we have no problem in going before the
terms of,
adjudicating officer if he seek compensation. The reason of the COVID scenario and all that, Millard, it affected everybody, including the real estate scenario.
Yes, anything else?
No, Millard.
Well, I will make.
Who would go first?
Lord, 2018, my lord, as per the agreement, they were required to hand over the possession by June 2019, my lord. I filed a complaint, online complaint was initially filed on 23rd February 22. As on that day, my lord, even OC was not there. I filed an online complaint, the party in person files the complaint. Thereafter, the OC came in March 22. We appeared before the authorities. Then there was series of mails issued to me asking me about the relief that I would like to claim. A link was sent to me and I was asked to give the memo of calculation. In that, my lord, the memo of calculation is the basis for the entire proceedings. In the memo of calculation, I have confined my relief only to the delay period interest. I have not sought for refund. I have not sought for any compensation.
Where is that?
The part of records, the Lordship has secured for the records. There, my lord, this memo of calculation.
Has that been given to the petitioner?
I am not blessed with the
No, it's
documents yet.
You cannot have internal communication and then ask them to reply to it.
No, I have not taken it, my lord. Anyhow, I have only the pleadings which I have filed.
Their objections, whatever they say.
Their objections were called for what? Give us the file. This is worse than what Mr. Basaraj is saying.
My lord, madam.
Sorry. That was technical. This is
hyper.
From what you are saying is different. Let us see this.
Lordship may have the first case, my lord. They file on the first case. That is case of Sunil Surana. 3427.
You filed a separate complaint for payment of money. 831, counter complaint.
Counter complaint they filed. They wanted refund of difference of amount they had claimed.
Gautam, there's a little, you'll have to apply your mind properly and guide us in this, or assist us in this. There's a complaint, counter complaint. The issues which have been raised as regard the performance. And there are objections which have been raised. These are disputed questions. 18(1) proviso would come in when there is no dispute and interest is to be paid PLR plus whatever. If there is a dispute, can the authority decide it, or it has to be referred to the adjudicating authority in terms of 71 and 72? And here there is a complaint and a counter complaint.
My lord, based on what they did is, they are after submitting this online, then both the parties appeared before RERA, my lord. Then the petitioner, the respondent here, he submitted a memo of calculation. That was purely asking for interest, which only RERA has the authority, my lord.
Where there's a counter complaint which has been filed.
Yes, my lord. But what happened, my lord? So far as this is concerned,
What happened to the counter complaint?
we gave them the liberty to file separate complaint, my lord.
That is why we are asking you, can you do that? We find this, we want to use the word shocking. Complaint, counter complaint, you separate out the counter complaint and say you file a separate complaint before the adjudicating authority. we'll only decide this because this is interest.
But
Disputed questions, we don't want to decide.
My lord, what happens, it will be two authorities, my lord, because the Supreme Court judgment interpreted, we earlier to New Tech, my lord, we were dealing with it in that particular manner. Then what happened, New Tech specifically directed us to demarcate both, two different parts.
Correct.
So then we separated all of them. This was after that only, my lord, 2022.
But after separating, why did you separate the complaint and counter complaint?
Because it was for compensation, my lord, we told them to file
There's a
separate.
complaint and counter, everything has to go together.
But Supreme Court had not allowed us, my lord, that is why.
There are disputed questions. It has to be adjudicated.
It is only in this context we have passed orders.
We find it a little, you can't separate like that. Because the decision on the counter complaint would have a bearing on the complaint. You have regulatory authority, you go before the adjudicating authority, you send off the counter complaint.
Because only adjudicating authority could do it, my lord. We could not touch that matter.
Correct.
Because he himself is telling.
Then you
it
should have
is-
sent both. So it could be adjudicated properly. Can't separate one from the other. If you file an objection, can we say your objection go to another court, we'll only consider the petition? Counter claim is like that. Counter complaint is like that.
But
Please
Lord,
get-
it's all a developing, this one, my lord. It's all a developing process, my lord.
Understood. But there's a mistake which has been committed, rectify the mistake. Firstly, your website you rectify. Please get instructions properly as to what you propose to do. We understand this is a developing aspect. But even if it is developing aspect, you cannot,
We were under the impression that under New Tech judgment, this is the procedure we have to follow.
you are absolutely right as long as independent.
Yes, ma'am.
But both of them together, can you separate them?
We thought.
In a suit filed,
To Supreme Court ruling.
we'll give you another example. In a suit filed for recovery of 4 lakhs,
Yes, ma'am.
there's a counter claim made for 12 lakhs.
It has to be dealt together.
4 lakhs, the civil judge has a jurisdiction, 12 lakh, it has to go to senior civil judge. Now 12 lakhs you will send her and 4 lakhs you will keep it with yourself? Or we'll send both of them to the senior civil judge?
So both to.
That doesn't seem to be a proper way of doing it. Get proper instructions and make a submission as to what you want to do. Apply your mind also on this. And henceforth, what is the process that you are going to set up? Firstly, you will have to do your website. For each provision should be separately captured.
My lord, whatever, anything that is given to us, my lord, we are immediately following.
It is for you to apply your mind and do it, not for us to tell you. 18.1 is different, 18.2 is different, 18.3 is different. If you put all three in a single basket of 18, it becomes a problem. 18.1, if it is there, it will go before the adjudicating, before the regulatory authority. 18.2, adjudicatory authority. 18.3, adjudicating authority. No dispute. After this, if there's a counter, then it still has to go to the adjudicating authority. We don't want to pass an order right away, get your instruction because this will have an impact.
Yes, ma'am.
Apply your mind, get your instruction. This is not one case that it will have so many other cases are there. If it is to be passed as an order, we'll pass an order, but get your instruction.
And, take instructions and then.
What Mr. Basraj was saying was hyper-technical,
Yes, ma'am.
but what you have done is
No, my lord, what
not
happened?
acceptable.
One submission, any case, my lord, both the parties have proceeded with the case because they have filed counter after I filed the memo of calculation.
Yes.
So the understanding was very clear. They were only filing counter to my delayed payment interest only. And the authority also passed an order on delayed period
Counter
interest.
could not be separated.
The
the
counter
counter
claim,
we-
so far as counter claim, my lord, the authority says recovery action to be taken. That liberty is reserved to them.
By going before the adjudicating authority.
or before the civil court, whichever, because they were seeking for certain recovery of money due under the agreement.
That is gone before the adjudicating authority. Both should have gone before the adjudicating authority.
If it is for delayed interest, my lord, then the adjudicating authority will not have jurisdiction as per the judgment. Moment my claim is for the delayed period interest, and if he is making a counter claim for recovery of money, then both can't go before the adjudicating authority. Therefore, the authority said, I am deciding only on delayed interest. You initiate separate action for.
Take your submission on that. We'll have to
Very
deal with it. Because ex facie, you can't have two different proceedings
Yes.
arising out of the same transaction.
My lord, it was their complaint was
By two
registered
different-
separately, my lord.
By two different authorities, it can't be.
It can't happen.
It has to be done by same authority so that there's no conflict.
Conflict, yes.
And in this case, when there's an issue, it should go before the adjudicating authority, not before,
They did not file counter claim in my complaint. They filed it as a separate complaint.
before the same authority.
Same authority they filed.
And that authority sent that out.
Yes, saying that you have to initiate recovery here because adjudication is required.
When both of it were before it,
We'll seek instruction.
please see if there are any other judgments on it. Let us know.
All of us will go before.
My lord,
Years are already
I'll-
wasted. There is an interim order.
I'll seek instructions. my lord.
Seek instruction. No,
Not
see,
because
this
of
is
this-
the institutional issue for them also. Let them sort it out. How, way forward also you'll have to see. There'll be trial and errors. Hit and misses on, until it gets settled. When will you get back?
My lord, 2 weeks, my lord. 2 weeks.
2 weeks back.
1 week.
Relist on, no, we'll give you 2 weeks only, get it properly, because anyway interim order is there. Relist on, at the request of counsel for respond number 1, relist on 29th at 2:30 PM. Interim order earlier granted is extended till next date. You keep the original files next time also.
Yes, ma'am.
Serial number 33. Vincent Teacher.
Appearing for respondent number 1, my lords. They haven't served us a copy, my lords, in this case.
You not received copy?
No, my lords. On 2/6.
You served a copy. Where is the acknowledgement?
Received the copy today, my lords.
With the annexures you received?
Yes, my lords.
Lord counsel for the petitioner has today served a copy of the petition along with annexures. Lord counsel for respondent number 1 who seeks for is granted 2 weeks time to obtain instruction, make his submission. Relist on 6th August.
34. Mallikarjun Reddy.
Yes, Mr. Reddy. Recommendation was not accepted.
They had recommended 50% of the penalty to be withheld. Modified. 20.
So we are dealing with all these matters on
21st.
21st. Relist on 21st. There are batch matters. All of you can address arguments on the same day.
35. Gopala H.M.
21st, they're not tagged because each one will have to be individually dealt with. But we'll hear your arguments, all of your arguments, so that any point that one misses out, the other could also.
35.
This one, copy is not being served on me. Copy is not being served on me.
Copy not served.
Respondent number 3.
About 24 in the copy not served. Mahesh Upin.
Yes, ma'am.
Don't make copies the issue. When matter is listed, you should be ready with that. What is your representation for?
My lord, these petitioners, there are more than 300 persons. They have written to the petitioner organization. Seeking rights for their living people. So this is their petition before the authorities.
You file it as a society, or what is a society? These are individual rights.
Society, my lord. They are referred to.
Bahujana Samaja Vedike registered under Karnataka Societies Act.
Yeah, petition is registered under Society Act.
Yes.
Petition organization is registered under Society Act.
ನೀವು ಕೇಳ್ತಾ ಇರೋದು ಫಾರ್ ಎ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಟು ಗಿವ್ ಹಕ್ಕುಪತ್ರ ಪೊಸೆಷನ್ ಎವ್ರಿಥಿಂಗ್. ಮತ್ತೆ ಏನಿದೆ?
Allot the site.
Allot the sites.
They found that some of the Goma land is available. These are the petitioners, they are the shelterless people. And they are petitioning the government and authorities to consider their representation for site under the Ashraya scheme as well as the Rajiv Gandhi and others.
Right. Where are the names of the people? Who are the people to whom it has to be allotted?
They are members.
How details ಇದೆ?
That's why we have submitted to the Deputy Commissioner at the first instance, my lord, annexure B.
Make them petitioners. These are individual reliefs. This is not for the society.
With the relief they have sought through the organization, my lord.
How can you do that? It's not a allotment to the society. It's allotment to individuals.
This is not a society, my lord. This is an organization.
Registered under Karnataka Society.
Registered under the Societies Act with some objects, my lord. I have produced the annexure A, the
What is the object? To get sites for its members
members.
under Ashraya scheme.
Not only site, my lord, there are several objects, my lord, to help the downtrodden class. See, but what they are exposing before the court, my lord, now, if at all, if they are exposing a cause for the members, they are
Can't direct the consideration on your representation. They have to be parties here. In parties ಮಾಡ್ತೀರಾ ಏನ್ ಮಾಡ್ತೀರಾ? Counsel for the petition seeks fund is granted 2 weeks time to make the concerned applicants to bring on record the concerned applicants as party petitioners. ಯಾವಾಗ ಮಾಡ್ತೀರಾ? 3 weeks time. So relist on 12th August.
Serial number 36.
May I please, Your Lordships?
Yes.
May I please, Your Lordships?
Yes.
This is a matter, my lord, where the sitting judge of the Supreme Court of Sri Lanka has filed this petition against Google, my lord.
You are appearing for the petitioner.
Yes, my lord, I am appearing for the petitioner, my lord. The matter requires a detailed.
For R2 and 3.
Please.
Yes, my lord.
Deshpande. He no longer appears for Union of India. We'll have to issue notice. Who will central government? Anybody here from the central government standing council? Shri Shanti Bhushan and DSGI is directed to accept notice for respond number 1. You are for 2 and 3.
Please.
4 and 5 have been served. They have been served. Counsel for the petitioner to furnish 2 sets of the petition along with annexures on Shri Shanti Bhushan.
Lordship may fix a date, my lord.
Yes, we'll fix a date. Who is granted 2 weeks time to obtain instruction notice commission. Released on 30th July.
Much obliged.
37. Authority.
37.1 notice is not issued. 37.1 GA. Jafar notice ಆಗಿಲ್ವಾ ಅದು?
Notice ಆಗಿತ್ತು last time, ಅದು impeding notice has to be ordered.
One minute.
57.1.
So there is a National Human Rights Commission. Who appears for NHRC?
NHRC notice has been dispensed with, my lord. There are no grievance, my lord. The relief sought for is only against the government of Karnataka. My lord.
No, government of Karnataka has filed a writ petition against NHRC.
37.1. Then NHRC,
37.1.
in that they have filed a pleading application.
We are not.
Why filed it against NHRC?
So the
NHRC has decided the matter, my lord. It is
NHRC
execution. It is
matter.
more or less the execution petition, my lord. The Karnataka government has to pay the amount.
I will
Okay,
ascertain, my lord, and give the instructions as was.
Who are the petitioners before NHRC?
Well, the petitioners are those people who are the victims.
Victims, my lord.
NHRC.
Victims of
They filed impleading application in that matter. In our matter.
Non-filing of impleading application.
No, they said they'll file an impleading application.
Filed a writ petition. You had posted for complaints. More than 80 years, you neither appeared before the registry nor made any complaint. And thereafter, when the matter came up before your lordships, but they informed that the writ petition is pending. And thereafter, the matter was connected. And matter came for admission, came for hearing 26, Lord. Your lordship directed to
Order
file
sheet.
impleading. Lord, and again posted for 19/6. Till that, they never filed in this.
Order sheet. 12.6, is it?
Earlier posted on 12/6. Your lordship directed to file a plead petition. And adjourned, they sought for adjournment 1 week close.
Implead the claimants and WP 3-4. Why haven't you done that?
We'll file it.
They are simply telling, my lord.
Weeks
So
time will be granted.
you will actually please to see the judgment which are two judgments of the one judgment from the division which is the Karnataka High Court, my lord. They said that, my lord, they will pay. They are the party to the proceedings, my lord. They are never contested. They are party to the proceedings. They said they will pay.
Now they have challenged that, so we'll have to hear both of you.
No, they themselves, they volunteer, my lord. Now they are established from challenging an order which was become final long back. At their instance, they are part of that that has been considered by the judgment of the.
They have filed a writ petition challenging it.
No, that they can't challenge that because they consented. They said no objection for paying the
That's a
amount.
matter of argument, not for you to say that it will dismiss it. When will you file the application?
For a week's time.
I say only one thing, Lord. But what happened is NHRC passed an order to implement the compensation laws. There are 89% compensation laws, and Tamil Nadu belongs to 38, Karnataka belongs to 51. State of Tamil Nadu will not file a writ petition before the Honorable High Court Madras. The Honorable Commission will not dismiss the writ petition filed by the state government. The same proceeding which was challenged before the state of Karnataka before your lordship.
So place all these records before us. How will we know if
We are
you are aware of it? We are not aware of any of these things.
No, we have placed it, my lord.
38% not received the entire compensation, but 51% from the Karnataka government were waiting for more than 15 years.
My lord, this is that we have already. I'll place it on record. My lord. I will check it.
If the state of Tamil Nadu has implemented it, why don't you implement it?
We'll place it on record. A week's time, my lord, I'll file the implementation.
Was already tried.
Doesn't reflect good on you.
According to my
One state
instruction,
government implements it.
my
other doesn't.
instruction, my
It's
lord,
not
whatever people were assured, they have been given. I'll place it on record. My lord. A week's time may be granted.
The AGA seeks fund is granted a week's time to file impleading application, as also to file to place on record the action taken by the state of Karnataka pursuant to the orders passed by the NHRC. Released on 22nd July. It is made clear that no further adjournment would be granted if impleading application is not filed by them. The writ petition in WP number 34605 of 2024 would be liable to be dismissed for non-prosecution.
When the judgment rendered by the Honorable Commission,
File it in a memo properly. Whatever you want to, whichever judgment you want to rely on, file it properly.
38. Narendra Gowda.
Same position. How will the position change? It's in B group. It's in B group. Depending on number of matters that day, we are trying to make it manageable. Let us see. Yes, Mr. Narendra Gowda.
My lord, I appear for respondent number 4, my lord.
I have received the copy, my lord. For 2 weeks' time, my lord, I will file my objections, my lord.
That counsel for respond number 4 seeks for and is granted 2 weeks' time finally to file a statement of objection. Released on 6th August. It's made clear that no further adjournment would be granted.
39, Mohammed Alwa.
Yes. 25/11/25.
The house is released, seems, my lord. Just now took instruction from the Dharmasala PI. The property has been released in their custody. Just now took instruction. It's an.
Where is the order copy?
There. It's an appealable order. Just now I took the instruction from the PI. The property is released and it's their use, my lord.
Where is the order copy? What is this matter about?
Police notice.
8-1. It's an appealable order.
Yes, my lord.
Can't come
Appealable
before
order.
us.
To the
8-1 is an appealable order.
district court.
That's a ground of appeal.
District court.
That's a ground for appeal.
Also, I'm not accused in that case.
All that are grounds for appeal. If they did not have jurisdiction, yes, natural justice jurisdiction will intervene. But if there's an appellate remedy, you'll have to go to the appellate remedy. Petitioner is before this court seeking for the following reliefs. Appeal under section 8?
District court.
Like 8-4. Right?
8-4. 10, my lord.
10.
10.
What has been challenged is the seizure made under subsection 1 of section 8 of the Karnataka Prevention of Cow Slaughter and Prevention of Cattle Act 2020. The petitioner has a statutory remedy in terms of section 10. Could you have it?
10 correct. Cow slaughters. To the district court. Appeal to the district court, madam.
Our section will have to be clear.
10, madam.
Uh, 10 is power to enter and inspect.
No, 10, 10, 10. 10. 10. 10. Section 10 order. Hold on.
Please, this 64 Act ಕೊಟ್ಟಿದ್ದೀರಮ್ಮ. ಇದು 2020 Act ಕೊಡಿ. Change ಆಗಿದೆ. Under section 10 of the Act, reserving liberty to the petitioner to approach the appellate authority, petition stands disposed. All contentions are left open.
40, Rajeshwara PM.
Correction of the interim order passed by this bench or another? Body.
But it has not been put up.
Pass over, ತರ್ಸಿ ಅದನ್ನ.
Dated 11/2.
11/2.
ಇದೆ ಅಲ್ಲ. No, 11/2 order is not passed by this court.
This bench. Not this bench.
That is, correction is only to that bench. That is why we are asking you. Counsel for the petitioner submits that an application has been filed to correct the order dated 11/2/26. Registry is directed to post the matter before the bench which had passed the order dated 11/2/26.
41, Government advocate.
Lordships, may I seek a pass-over, my lord? Pass-over,
Interim order extended 40.
pass-over, my lord.
Lords,
Age
this is
is
that
appearing.
matter where, my lords, they had taken a
The
new
age
ground.
is
before.
appearing.
Age is appearing. Lords, that issue of forest land of people.
When they are there, pass over.
Please,
42.
Next week, Your Lordship. Next week.
Enamma?
no problem. Yes.
We'll go at your request
Your Lordships may have it at 2:30.
to seek for an agenda.
No, my lords, if the learned AG would be here,
Yes,
we'll
come and then we
wait.
can.
Grateful.
It's difficult to list when it is listed. Please
Very
go
well.
ahead.
We will do.
Lords, may I only make one request?
Yes.
Lords, let them say, my lords, if they're going to raise that ground, because, my lords, then there's nothing in the pleadings on their side or our side. No, my
We
lords.
can't say anything.
Very well.
Both of you know the matter. We
Yes.
don't know anything about it. Yes.
42. MCJKC.
KSTDC is served and not represented.
The private response is served and not.
Private is fine, but KSTDC, why is it served and not represented? Any standing counsel? The BL Sanjeev is directed to accept notice for respond number 1. He is directed to file the affidavit of the concerned indicating as to why, despite service of notice, there is no representation made on behalf of respond number 1. Counsel for the petitioner to furnish 2 sets of the petition along with annexures on the said counsel. Released on 4th August. Interim order in Vidya?
There's a merger in the distance.
4th August.
43.
For suspension of negotiation for a cost of suspension of negotiation for limited period of time. Trial court has already granted travel permission. But the investigation is already over. Charge sheet is filed.
Yes, madam.
My lords, kindly look into page number 10, my lords. In this, it is clear that she is a American passport holder, my lords.
Yes.
So the petitioner is American passport holder, my lord.
So?
And if she's been let to go, my lord, there is no guarantee that she'll come back, my lord.
The court has permitted it. If you are agreed by it, you should
Lords,
challenge that.
We need at least one person surety at least to confirm.
Sorry?
Some person's surety.
Madam, you can't ask anything more than what the court has ordered. We cannot direct anything more than what the court has ordered. There's an order passed by the trial court seized of the matter. That you have to implement.
My lord, but it's a matter of huge.
You are overreaching the order of the court. We put you on notice last time.
Yes, please.
You want to overreach, we'll observe that. How could you be doing all these things? When there's an order of the court, it's your business to just implement it. It is meager, that is what you made your submission. It's meager. Meager and all is not a contention, it's the order of the court. If you are aggrieved by it, challenge it. Not otherwise. Petitioner is before this court seeking for the following reliefs.
Already one of the director is arrested, my lord.
There is an order passed by a court, madam. Anything that you have,
Because of, it's a huge amount and she has got the passport.
we will observe, we'll note down all your submissions. But all your submission we'll have to deal with. If you want us to deal with it, we'll deal with it.
At least some
Tell us what is to deal with.
some conditions may be.
You can't be making this submission once there is an order passed by the court. Petitioner is before this court seeking for the following reliefs. Petitioner claims to be one of the directors of Mrs. Deepak Cables India Private Limited. As regards whom, complaints have been registered by respondent CBI in FIRs in RC number 3/E/2021 and RC number 6/E/2022 for offences punishable under section 120-B, 420 and 471 of the Indian Penal Code 1860, read with section 13(2), further read with section 13 bracket 1D of the Prevention of Corruption Act 1988, wherein the petitioner has been arraigned. Where in both the cases, the petitioner is arraigned as accused number 3. Upon completion of investigation, a charge sheet has been filed and the case has been numbered as CC number 28177 of 2025 and pending on the file of the 17th Additional Chief Judicial Magistrate, Bengaluru. The petitioner has also been enlarged on bail in both the said proceedings. A lookout circular, bracket LOC, having been issued by the immigration authorities, the petitioner is before this court for a temporary suspension of the LOC since the petitioner has been permitted to travel abroad by way of the order dated 25/2/26 in CC number 28177 of 2025. The conditions, the operative portion of the order reads as under page 137, 138. Submission of learned counsel for the petitioner, but this period has lapsed.
The period has lapsed, my lord, because the respondent had sought time, my lord, stating that the period might be extended. I seek for modification of the order in the trial court, my lord.
Reads as under. The grievance of the petitioner is that despite the order passed by the court seized of the criminal proceedings, the lookout circular was not suspended, thereby impeding the petitioner's right to travel, even though the criminal court the trial court has granted permission specifically, permission specifically to the petitioner to travel to USA for a limited period from 25/2/26 to 25/5/2026. The submission is that the petitioner was ready and willing and continues to be ready and willing to comply with all the conditions which had been imposed in the aforesaid order, but could not so comply on account of the respondents continuing with the LOC. We'll have to deal with your submission. You can't be doing this. The submission of learned counsel for respondent number 1 is that the petitioner being a US national, there's a possibility of the petitioner being a flight risk, and it is for that reason that the LOC was not lifted. The submission of learned counsel for respondent number 2 is that there are large amounts of money which are involved in the said offences, and if the petitioner were to travel abroad, those monies would be put to risk.
To recover back is difficult.
An application having been filed by the petitioner in CC 28177 of 2025, the said application was considered after hearing the public prosecutor. The public prosecutor appearing on behalf of the CBI, which in turn would also amount to him appearing on behalf of the de facto complainants, namely respondent number 2 and 3. The public prosecutor having been heard, the trial court has passed the order permitting the petitioner who is accused number 3 therein for travel to USA for a limited period of time. Once an order has been passed by a court of law, it is but required for everyone to comply with the said order. It is not open for any of the respondents to contend that despite the order passed by the trial court, the petitioner is a flight risk and/or that since large amounts of money are involved, the petitioner ought not to be permitted to travel, and/or that the conditions imposed are meager in nature. As indicated supra, once an order is passed by the court, it is for all the parties to comply with the same unless an appeal is filed challenging said order. In the present case, the order having been passed on 25/2/26, there is no particular appeal which has been filed, nor an application to recall the order which has been filed by the respondents. The respondents of their own have unilaterally impeded and obstructed in the
We did nothing.
That is why we are saying your arguments lead to that.
No, no,
My
no, we are
apologies,
not.
my lord. It
Have
is-
continued the LOC, which they ought not to have continued and ought to have suspended same as per the orders passed by the trial court. In that view, it's however now to be noticed that the time period during which the petitioner was permitted to travel has expired and the permission is no longer in existence. It would be for the petitioner to once again apply to the trial court for fresh permission. And if such permission were to be granted, the respondents would have to comply with the directions so issued by the trial court. With the above observation, petition stands disposed.
Great.
Would have to be complied by respondents by suspending the LOC for the period for which the petitioner is permitted to travel by the trial court.
My apologies, my lord, for this. 44, yes, Venugopal.
For the response. Lots of application directed to the petitioner serve a copy or not served on me.
Ian copies yakappa 2 years in the serve agalla.
I furnish.
That counsel for the petitioner undertakes to furnish one more set of the petition along with annexures on the counsel for respond number 5.
Please.
6. Who appears for 6?
6 copies issued, but the name has to be shown as B. Sharath Kumar.
Counsel for registry that print the name of Shri?
B. Sharath Kumar.
Birth code. Spelling correct.
Please.
Spelling mistake ಮಾಡಿದ್ರೆ ಆಮೇಲೆ ನಿಮ್ಗೆ ಸಿಗಲ್ಲ.
Please.
Is that appearing for respond number 6 who confirms having received a copy of the petition along with annexures. Relist on 6th August.
45, TJ Sultapur.
But then, my lord, my preliminary objection.
Not in the panel. P. Anand.
However, my lord, there is a serious question with regard to the maintainability. The dispute is arising out of an agreement. And also that agreement, my lord, in his own grounds, he admits that there is an arbitration clause. Without invoking the arbitration clause, my lord, they have not approached this
Cooperative
court.
society matter.
One of the.
The cooperative society matter. This cannot come up before us.
Page 9, my lord. And the dispute is arising out of an agreement, my lord.
Correct. This is a cooperative society matter. It can't come before us. It is submitted that Ms. Sumana Naganan is not on the panel of respond number 4 and 5. Shri P. Anand, who is now stated to be empaneled for respond number 4 and 5, is directed to accept notice for respond number 4 and 5. Registry is directed to print his name as such and delete the name of Ms. Sumana Naganan as that appearing for respond number 4 and 5. A perusal of the papers indicates that the same relates to cooperative societies. Registry to verify the correct classification and placed before the appropriate bench on 6th August.
46, Conrad.
My lords, I appear for the respondent number 2 in this matter. My lords, I filed a wakalat recently.
For respond number?
2, my lords, the water board.
Oh, yes, your name is there.
My lords, I need to
submit that she has appeared for respond number 2. Delete the name of Ms. Sumangala Gachinmat as that appearing for respond number 2. Yes, madam.
My lords, on the last date, your lordships had said by 7th July the statement of objections have to be filed. But my lords, since I've been recently allotted this matter, I pray for another short accommodation, my lords.
When will you file it?
My lords, your lordships may permit me 2 weeks, my lords.
That counsel for respond number 2 seeks fund is granted 2 weeks time to file a statement of objections if any by 31st July, relist on 6th August.
Very well. I'm grateful, my lords.
47,
Interim order earlier granted is extended till next date.
SK Acharya.
Yes.
The pleadings are completed.
Huh. No arguments to be completed.
This is the, after the remand order, my lord, another second round of litigation, my lord. So retail outlet petitioner was provisionally selected.
Ready, Pramod? Please. Yes. Hear it.
My lord, there is one judgment of your lordship is available, is not available, readily available with me, my lord.
Pass over.
My lord, next speaker.
Mr. Acharya, you have to argue matters. This is.
Yes.
Nowadays you are taking adjournment in all matters.
Judgment ಸಿಕ್ಕಿದ್ರೆ ಮತ್ತೆ ಮಾಡ್ತೇನೆ ಅಂತ ಅಷ್ಟೇ ಮತ್ತೆ.
ಆಯ್ತು, pass over.
Well, not pass over, my lord. Afternoon
Interim order ಏನಾದ್ರು ಇದೆಯಾ?
ಇಲ್ಲ.
At the request of counsel for the petitioner, relist on 11th August.
13th, my lord.
13th August. 13th ಒಳ್ಳೆ ದಿನ.
14th, my lord.
Yes.
48, Jawar Babu.
I'm filing Wakala on behalf of respondent number 5.
Respond number 5.
I pray for my lord respond number 2 in this matter.
So want to submit that you would be appearing for respond number 5.
I beg to appear for the petitioner.
Yes, Mr.
Copies have been duly served. This is a case where there is erroneous transfer of money through RTGS that is sought to be reversed by the Punjab National Bank via Annexure D. Via Annexure D at page 26. Axis Bank should have followed it and they have not done it so far. At the last hearing, your lordships were pleased to grant an interim order to create lien to the extent of 25 lakhs.
By inadvertence, it's been.
Yes.
Yes, Mr. Respond number 5.
My lord, sir, I have received the papers today, my lord. I need to go through and I'll file my objections.
You're holding on to money.
Wrongly transferred to his accounts.
I need to, my lord,
Section 72 of directed, he has to give it back.
I need to consult my client and seek instructions, my lord.
Don't scare him with all provisions. He'll get your instruction by one number going wrong, money has come into your account, so you have to transfer it to
I understand.
his account. Whether you give instructions or you have no relationship with the petitioner.
No relations.
Then what is there?
I need to seek instruction, my lords.
What instructions do you need?
About the
to return his own money.
About the transfer, my lords, I'll seek instruction. And
we'll direct them to transfer. We don't need your instructions.
Anyway, my lords, I have received the papers today, so I need to go through.
He is out of pocket. Learned counsel for respond number 5 seeks fund is granted 3 days time to obtain instruction, make his submission. Relist on 17th.
Highly grateful to you.
Let it go back to who is the owner of the money. Interim order earlier granted is extended.
Apologies for making the submission. Serial number 8 was passed over.
No, that can be disposed of. 8, if your lordship can.
Not out of turn like this. We'll take it up when it reaches.
49,
For the petitioner,
Kumar.
all are I think same zone word. Sanction for prosecution words. I have one ground lord where your lordships may kindly see. Permitted to place this on record.
49.
Yes. 49.
Who is appearing now?
Lord,
State, my lord.
State government and BBMP.
Also
and
BBMP,
lords,
my lord. Some of the DGOs are from
Swati
BBMP.
Panduranga. 49.1 service is not complete?
No, my lord.
49.1 could you? 49.1 IA 1 of 25, 2 of 25 are allowed. And AGA accepts notice for respond number
1, my lord.
1, my lord.
1.
2 is the
DL Sanjeev
BBMP.
accepts notice for respond number 2. Ms. Swati Panduranga is directed to accept notice for respond number 3. In 49.2, there's some problem with all this.
But I'm for respondent number 2. Respondent number 2.
49.1.
You are representing whom, Mr. Sanjeev or Ms. Swati Panduranga?
Sanjeev.
Where is Ms. Swati Panduranga?
Karnataka is already served, my lord.
49.2. Registry is direct, correct the appearance of the council as learned. AGA for respond number 1. Shri BL Sanjeev for respond number 2 and Ms. Swati Panduranga for respond number 3. ಎಲ್ಲದರಲ್ಲೂ ಅದೇ ಪ್ರಾಬ್ಲಮ್ ಆಗಿದೆ ಮಿಸ್ಟರ್ ವಿಜಯ್ ಕುಮಾರ್.
The 49.5 ಅಲ್ಲಿ, the other order sheet is reflecting in the
49.3. We go one by one so that.
all filed by the very same petitioner.
Same.
Yes, my lord, and all the response remains.
AGA for response, correct the appearance. AGA for 1, Sanjeev, BL Sanjeev for 2, Swati Panduranga for 3. 49.4. AGA for respond number 1, BL Sanjeev for respond number 2, Swati Panduranga for respond number 3. 49.5.
That order sheet itself is reflecting something else. Some bare case of the order sheet is reflecting in the
ಯಾವುದರಲ್ಲಿ
49.5.
49 point?
Website ಅಲ್ಲಿ some other case.
49.5 ಅಲ್ಲ ಕೊಡಿ 49.5.
Website ಅಲ್ಲಿ ಬೇರೆ ತೋರಿಸ್ತಾ ಇದೆ, but I'm not sure about that.
The 35778 and these are all connected matters.
Yes, sir.
In view of the order dated 8/12 passed in WP 35778, petitioner being first division assistant, member of the tender issuing authority, sanction is stayed till the next date.
Yes, sir. In all the 4 matters, no, there was interim order.
This is not the order which is uploaded onto the website.
No, something else is reflecting in there.
Learned counsel for 49.5. Learned counsel for the petitioner submits that the order dated 8/6/26 passed in the present matter is not the one which has been uploaded onto the website. Registry to verify and correct the mistake if any. Yes.
But sir, in 2 matters, no, there is no interim order.
Where is Ms. Swati Panduranga?
For respondent number 2.
BL Sanjeev, he is appearing as Sanjeev. Can you pass?
Pass over. You have her number?
No, no, I have no number. Maybe call next week anytime. So
ಮತ್ತೆ next week ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಏನು?
I'll inform you so that.
Relist on 23rd July, interim order earlier granted is extended till next date.
First matter, there is no interim order.
The interim order granted in 35778 of 25. The benefit of interim order in 35778 of 25 shall be available for all the petitioners in the other petitions.
Great.
Serial number 50.
50.
In serial number 50, before the petitioner, my lords, it is pertaining to non-execution of FLW by the respondents. So far as with respect to first respondent is concerned, on the last occasion, my lordships was pleased to direct them to submit the report.
Yes.
The property details has been given to the
Police.
this one, complaint, my lord. Many things I will get back. FLW, balance payment of 25 lakhs.
What is the status?
Property details has been given to the complaint. He has made 25 lakhs payment, my lord. Balance 25 lakhs he has to make. The trial court the matter settled before the Lok Adalat. In that, we made effort to.
Then is FLW.
FLW.
So we have to serve the FLW.
One report saying that he is not in the given address, and they are making effort to search, my lord.
Even in the present case,
No,
my
ma'am.
lords, the notice has been served. As
No,
per the cost title, my lords, the notice has served upon the 4th respondent.
I am appearing for the 4th respondent, my lords.
You are appearing.
Yes.
What is your address?
I am residing in the address in the cost title, my lords.
Edukoli ille.
My lords, my RTC has been taken from the Tahsildar, my lords, and they've submitted before the police, my lords, about 4 months ago.
Police saying that they can't find your client. And you are here. So
the FLW
she
has
so
been
to submit
executed,
that
my
you
lord.
would be appearing for respond number 4.
4, yes, my lord.
Registry direct print his name as such. Now what do we say about your submission?
The RTC has been given to the property details has been extracted from the taluk office and submitted to the complaint.
Submitted it to the complainant, you have to execute the FLW. What should the complainant do with it?
Will execute, my lord.
Complainant is not a police authority.
No, please, my lord. Will execute, my lord. Same day attack. Will execute, my lord.
By when?
Within a week.
They are yet to attach the property, my lords. They are yet to attach the property.
Yes, that is why we are asking them why they are not attached.
Yes, because details has
And
been taken
AGA
about.
6 point is granted a week's time finally to place on record the status of the execution of the fine levy warrant, since even according to counsel for respond number 4 is available at the very same address as indicated in the petition. Released on 23rd July.
My lord, serial number 31. Serial number 31 has been passed over, my lords. I'll take instruction from my client. ನಾಳೆ ಡೇಟ್ ಮೈ ಲಾರ್ಡ್ಸ್ 2:30.
ನೀವು ಇವತ್ತೇ ತಗೊಂಡು ಹೇಳಿ ನಾಳೆ ಮತ್ತೆ ನಾಳೆಗಾಗಲ್ಲ, it will go for another 10 days.
ಇಲ್ಲ ಮೈ ಲಾರ್ಡ್ಸ್, ಅದೇನಂದ್ರೆ ಹೈದರಾಬಾದ್ ಅಲ್ಲಿ ಇದ್ದಾರೆ ಮೈ ಲಾರ್ಡ್ಸ್, ಸೊ ಐ ವಿಲ್.
Serial number
31 my lords.
Serial number 31 at the request of counsel for the petition released on 23rd July. Yes, Mr. Jagdish.
ನಾಳೆ my lords.
ನಾಳೆ 140 ಮಾಡಿ.
Please my lords.
FR number ಮಾಡಿಗೆ ಮೂರ್ತಿದೆಮೋ. FR number
ಬರ್ದಿರಲಿಲ್ಲ ಕೊಡಿ.
I love 23rd ತುಂಬಾ
Next,
ಲೇಟ್
ಏನಿಲ್ಲ,
ಆಗುತ್ತೆ
dismiss
my lords.
ಆಗಿದೆ
ಇನ್ನೊಂದು ಶಾರ್ಟ್ ಡೇಟ್ my lords, please ಕಳಿಸಿರಿ.
Unpreferred memo filed by CH-10 ಅಂತಾನೆ ಕಳಿಸಿದೀವಿ. ಸರಿ ಸರಿ.
ಮೇಡಮ್ ಪಾಸ್ಟ್ ಓವರ್ ಮ್ಯಾಟ್ರು ಸೀರಿಯಲ್ ನಂಬರ್ 8 ಅದು 2:30 ತಗೊಳ್ತಾರೆ ಹೆಂಗೆ ಮೇಡಮ್?
ಫಸ್ಟ್ ಧಾರವಾಡ ಕಲಬುರ್ಗಿ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಫಾಸ್ಟ್ ಓವರ್ ಆಮೇಲೆ ಕಟ್ಟಿ.
ಹೌದಾ?
ಇದ ಹಿಂಗೆ ಪ್ರೊಸೀಜರ್. ಸರಿ ಇಲ್ಲ ಇದೆ ಸರ್.
ಮೇಡಮ್ ನೀನು ಒಂದು ಹೇಳಿದ್ನಲ್ಲ ಮೇಡಮ್.
ಹೇಳಿದ್ರಿ, ಅದು ಡಿಸ್ಮಿಸ್ ಅಂತ ಆಗಿರೋದು. ಡಿಸ್ಮಿಸ್ ಅಂತ ಆಗಿರೋದು. ಡಿಸ್ಮಿಸ್ ಆಗಿರೋದಂತೆ.
ಇಲ್ಲ ಮೇಡಮ್ ಕೇಳಿ ಚೇಂಬರ್ ಆರ್ಡರ್ ಕೇಳಿ ಆರ್ಡರ್ ರೆಡಿ ಆಗಿದೆ, ಅಪ್ಲೋಡ್ ಮಾಡಿಲ್ಲ. ಅಯ್ಯ ಮಾತ್ರ ಡಿಸ್ಮಿಸ್
ಇಲ್ಲ
ನೋಡ್ಕೊಂಡ್ ಬಂದೆ.
ನನಗೂ ಅವ್ರು ಹಂಗೆ ಹೇಳಿದ್ದು ಸರ್.
ಎರಡು ಮೈಕ್
ಮಧ್ಯಾಹ್ನ ಮಾಡ್ತೀನಿ. ನಾನು ಕೇಳಿದಾಗ ಡಿಸ್ಮಿಸ್ ಅಂತ ಅಂದ್ರು. ಕೇಳಿದಕ್ಕೆ ಸರಿ ಆಯ್ತು ಮಾಡೋಣ ಬಿಡಿ, ಮಾಡ್ತೀನಿ ಮಧ್ಯಾಹ್ನ ಮಾಡ್ತೀನಿ. ನೀವು ಮಲ್ಕೊಳ್ಳೋ ಟೈಮಿಗೆ ಚೆಕ್ ಮಾಡಿ, ವೆಬ್ ಹೋಸ್ಟ್ ಆಗಿರುತ್ತೆ. ಅದೇ ನೀವು ಮಲ್ಕೊಳ್ಳೋ ಟೈಮಿಗೆ ಚೆಕ್ ಮಾಡಿದ್ರೆ ಎಲ್ಲ ವೆಬ್ ಹೋಸ್ಟ್ ಆಗಿರುತ್ತೆ ಸರ್, ಮಾಡ್ತೀನಿ. ಸರಿ ಸರಿ ಮಾಡಿ ಮಧ್ಯಾಹ್ನ ಮಾಡ್ತೀನಿ. ಸರ್ ಅಲ್ಲ ನಾನೇ ಮಾಡ್ತೀನಿ. ಆಗುತ್ತೆ ಅಲ್ಲಿ ಬರಲ್ಲ ಲಿಸ್ಟ್ ಅಲ್ಲಿ
ಭಾರತಿ ಮ್ಯಾಮ್ ಅದೊಂದು ಡೈಲಿ ಆರ್ಡರ್ ಅಪ್ಲೋಡ್ ಮಾಡಿ.
ಯಾರ್ದು ಇಲ್ಲ ಇದ್ನಿಂದ ಆಮೇಲೆ ಇದ್ರದ್ದು ಒಂದೇ ತರ ಇದೆ. ಇಲ್ಲ passed also 3 matters. Dharwad bench matter. Yes, sir. Hegde Associates.
Dharwad, who appears for the state? Pass over.
Kalburgi bench matters. Serial number 1. Naresh V. Kulkarni.
Connect ಆಗಿಲ್ವಾ? Pass over.
Report is. Report is.
I'm sorry, my lords, in respect of Dharwad bench matter, my lords.
Just one more, Mr. Opar. We have started with Kalburgi. We'll come back to you. An email dated 14 July 2026 has been placed on record, providing the status report by the e-governance department. The same reads as under. Who's there from? Yes, madam. Serial number 1.
So in serial number 1, the software will be made available for the public on 20th July, as it is intimated to me by e-governance department. It may be posted after 25th, there will be a test regarding the new website.
And ACGP submit
AGA.
that software would be ready. AGA would submit that the test would be, software would be ready by 20th, and the test report would be received thereafter. Released on 3rd August.
Serial number 2, Arun Kumar.
Lords, in serial number 2, there is a interdepartment meeting, Lords. There are 3 to 4 departments are involved for developing the software.
Okay. Submit that.
It needs 8 weeks, they sort.
Coordination being required between more than 4 departments. She seeks for 8 weeks time. Released on 7th September.
Yes.
Dharwad.
Dharwad bench matter. SR Hegde Associates.
Yes, Mr. Opar.
They say that, my lords, within 2 weeks, my lords, the finalization of my lords, general directions would be issued by the lords, e-governance, my lords.
And AGA seeks for and is granted 2 weeks time. Released on 3rd August.
Please, my lords.
230 matters. List number 2, serial number 1. Mallikarjun Reddy.
Hearing for spot number 1 is
Plot.
It's counter affidavit, my lord.
Ian country. Nodra ado plan.
Lord, it's not college, my lord. My
only submission is the same. Whatever he got it, because Prana Enterprises had gotten it, he is shared it to the extent of 22 into 6.
He is filing something. You want to see it, or you will argue without that? See it and argue it once and for all. Every time, last moment.
Adjacent all sites, my lord, I have got the information. For everyone, the shed is 42 into 60, my lord. But the total extent, what is
Not concerned what is for the others. What is the allotment made in this property? Is
for
what
me
we are
also the
concerned.
same. That is
And
what-
the file is there.
Please.
That counsel for respond number. So you will be appearing for respond number 1 now.
Respond number 1.
Chandrakant Patil,
Along with him, my lord, I have this.
registry is directed to print the name of Sri Rakesh Shetty as that appearing for respond number 1 along with Sri Chandrakant Patil. You filed Wakalatama?
Please.
Yes, the counsel for respond number 1 is today filed.
Counter affidavit to the.
Counter affidavit. Copy thereof has been served on the counsel for the petitioner and respond number 2. Same is taken on record, released on 24th July.
Serial number 2, CN Srinivas Rao.
Oh, that.
My instructions were delivered on 30/1/2026 was the last day of consular access event. But thereafter the matter come up to your lordship, that is on 10/2/2026 and it is adjourned. But now I have been told that we need some
more time because we have not got any report from the Pakistan.
Likely to get or what? We'll adjourn it by around 6 months or so. If you receive the report, you can always mention it. Every time to have it and then adjourn it, no purpose served.
I received the report.
You can also mention.
But the other fact is that it's oral instruction which was given to me that the consular access was given on 13th. That has not been recorded.
You had access to the person or you had only?
It is said that the consular access was given to him. However, the DNA should match. That report has to come.
How about the identity? Until DNA is done, nothing. Not much in their control. Not much in their control, Papa. They can try whatever they can do.
But if at all the DNA matches, then it is different.
Yes.
To match the DNA, we have given the samples. It is for them to reply.
The reports have been sent. In that sample would have to be verified. The DSGA submit that the verification report is yet to be received. Relist in January on date today. If the report is received before that date, both the councils are free to mention the matter for early listing.
Serial number 3. Maybe Amarnathan.
ಏನಾಯ್ತು?
My lord, in this case, my lord, court commissioner, advocate commissioner, has filed a report. He told me that he has filed a report with sealed cover. I'm not aware.
He had filed it on by himself because the jurisdiction Tahsildar and ADLR were not there on that day.
That after that, on 4/7/2026, there was a joint survey by both of them.
The court commissioner was
Taken
also
place.
there.
But report is.
Inna
filed.
ಬಂದಿದ್ಯಾ?
Yes. Open. Sealed cover.
ಕೊಡಿ.
Petitioner.
additional copies ಇದೆಯಾ? ಕೊಟ್ಟಿದ್ದೀರಾ? You received copies. You also received copies.
Just now I received.
So you'll also have to tell us what action you take. You're not received. You are for 1 and 3. ಒಂದು ಕಾಪಿ ಮಾಡಿಸ್ಕೊಳ್ಳಿ. ಬರೀ ಇವ್ರಿಗೆ ಮಾತ್ರ ಕಾಪಿ ಮಾಡಿಕೊಟ್ಟಿದ್ದಾರೆ. ಕಾಪಿ ಮಾಡಿಕೊಳ್ಳಿ. That court commissioner has filed his report dated 9/7/26. The same is taken on record. Copies thereof have been furnished to the counsel for the petitioner and the counsel for the respondents, who are granted 2 weeks' time to file their objections, if any. Learned AGA is also directed to secure instruction, make a submission on the action proposed to be taken by the concerned authorities in pursuance of the commissioner's report. Released on 4th August.
Serial number 4.
Speak in the mic, please.
Already necessary steps have been taken. The training has been already provided with regard to the new features within the software to delete all the duplicate SAS IDs, and the process is also ongoing now. But due to that SIR thing, it's slightly going slow. So far, I was able to collect only 4 endorsements. So they are all in the process. So kindly pray for a small time.
Out of this batch, 4 are done.
4 are done.
Which are those?
So one is 4.12.
4.12.
And 4.13. And 4.33. This is complete. And then 4.17, 4.18, and 4.19, they're also.
So 1, 2, 1, 3, 1, 7, 1, 8, 1, 9.
Yes, my lord.
And 3, 3.
Yes.
1, 2, Mr. Madhav Kashyap. You can give him the endorsement.
Yes.
The counsel for respondent submit that the verification completed in 4.12, 4.13.
4.15.
4.17 or 18?
17. 17.
1,
17, 18,
1, 3, and 1, 8.
17 also.
Just 1, 7, 1, 8, 1, 9.
Yeah, 1, 2, 1, 3, 1, 8, and 3, 3. 33.
You said 3, 1, 7, 1, 8, 1, 9.
Yeah, those actually what had happened was those cases, the age education thing, they had already paid the this one tax during one time OTS, but unfortunately it was not mentioned in the system. So these notices were sent.
So now 1, 8 and 4.33.
Yes, ma'am. That letters detail I can give.
4.13 is also Madhav Balaji Kashyap. You received for both. 4.18 Ajay Nandalke. Give her the copy. 4.33 Natraj. G Natraj. So when will you complete this entire process?
My lord, just 3 weeks time, because as soon as we are actually on that this one, we are following it up on a daily basis with all these AROs who are supposed to raise that request for deletion of duplicate IDs. So we'll be, as soon as it is done, I'll keep filing, my lord.
Has been completed. Necessary endorsement in regard thereto has been handed over to the respective counsel for the petitioner. Insofar as the other matters are concerned, the counsel for respondent submit that it would take at least around 3 weeks' time to complete the verification and make a submission. Relist on 10th August.
4.3. Have paid tax in excess.
That is what they are verifying. All of it they are verifying. SIR is going on, so we can't put pressure also. 10th August, Interim order earlier granted is extended till next date. Try and complete it so that.
Yes, yes, my lord.
Bill number 5.
Yes, ma'am.
Both the council submit, seek for and are granted 3 weeks time for reporting settlement, released on 10th August.
Serial number 6.
Plus provisional attachment order was challenged. Statutory remedy is available.
Yes. You have a appellate remedy under section. Copy thereof is being served on the council for the petitioner. Released on
Judgment you give it to him.
I've given both to.
It's given.
22nd July. Interim order. Yes.
What's a provisional order of attachment? Once last occasion, I had brought your lordship's notice.
Yes.
Allegations pertains to the year 2011-12. The properties are purchased in 2004.
2011, property purchase in 2004.
Yes. 2004 and 2009, two properties.
2004 and 2009.
Yes.
Yes.
Milords, I don't even indicated, Milords, that in such cases they will have to come and concede because fairness is what is expected, Milords, from them. If they don't commit in the mischief of Section 5, they should not create litigations because what is expected of the state is to be fair. It is not that they have to create litigations in this manner. Milords, then your lordships was specifically asking me, Milords, as to whether there is a statutory remedy and how I should overcome for the purpose of your lordships to exercise the jurisdiction of 226. Milords, this matter came up. Can I just pass on this? Milords, the judgments which I have now passed on, Milords. Lords, first judgment is as to what is meant by proceeds of crime. That I'll take your lordships a little while later, but page 31, my lords, a coordinate bench dealt with this very specific issue.
31.
Page 31.
Yes.
Lords, page 36, the contentions are extracted of the petitioner. Page 39, para 19 and onwards, my lords, the contentions of the ED is extracted. Lords, then para 26 particularly, my lords, at page 40. Insofar as such contention is concerned, the position of law appears to be well settled and Apex Court has held that under exceptional circumstances, the available statutory remedies may not be a bar for invocation of jurisdiction under 226 of Constitution as observed in Mirpul. The Apex Court in Godrej Sara has observed that the power to issue prerogative writs 226 is plenary in nature and the exercise of the powers conferred on the writ jurisdiction being discretionary, and it is for the court to decide as to such exercise of power appropriate circumstances. Distinctions drawn between the concept of maintainability and entertainability, and it was observed that though the writ petition would be maintainable, however, the same could be entertained in a matter of judicial discretion as related to the observations in Willpool. Notes, I'll skip these portions because the interpretation which I am referring to, notes, is something else. Para 29, hence it is for the court to decide as to whether it needs to entertain the petition and interfere with and allow the proceedings under the statutory scheme to progress to a logical conclusion. The non-following of the procedure prescribed under second proviso to 51A of PMLA would be a jurisdictional issue that would warrant interference in exercise of the jurisdiction as being recognized exemption for waiving of the statutory remedy as made out in the case of Whirlpool. At the outset, it would be necessary to examine as to whether the statutory scheme does provide for an alternative efficacious remedy for redressal as regards the person aggrieved by not following the procedure prescribed under second proviso to rule up to section 5 before passing of an order of provisional attachment. The question of relegating an aggrieved person to avail statutory remedy would be only when the statutory remedy provides for a forum for redressal of the grievance. Under the scheme of the PMLA, the order of the provisional attachment when passed under section 5 would be followed by forwarding a copy along with the material in possession of the competent officer to the adjudicating authority in terms of 5.2. Subsequently, a complaint will have to be filed before the adjudicating authority in terms of 5.5 of the PMLA. Finally, the process of adjudicating is restored and section 8 is an order is passed by the adjudicating authority. It would necessary to take note of the procedure and power of section 8 of PMLA. Notes, I'll skip that reading of that provision, Milords. Notes, it comes up to paragraph number 36 at page 21. I'm sorry, page 51. In terms of section 8 of PMLA, the owner of the property which is subject to an order of provisional attachment served with a notice calling upon him to indicate the sources of his income, earning or assets out of which or by means of which he has acquired the property attached, show cause why all or any of the property should not be declared to be properties involved in the money laundering and confiscated by the government. The adjudicating authority may under 8.2 after perusal of the reply is theoretically vested with the power to drop the proceedings or to proceed under section 8.3 to confirm the attachment. Needless to state that adjudicating authority is required to record a finding as to whether the properties are involved in money laundering. However, the procedure contemplated under section 8 does not provide for testing the validity of an order of provisional attachment for non-following of the procedural requirements in terms of second proviso to section 5.1. As rightly contained by so and so, the procedure prescribed under section 8 is limited to confirmation of an order of attachment subject to the owner of the property establishing the acquisition of property which is attached was acquired from the sources of his income, earning or assets. The procedural safeguard provided under second proviso to section 5, as in the present case, cannot be a matter of inquiry before the adjudicating authority. Though section 5, 8 and 26 of PMLA do form a self-contained code, however, there are certain procedural aspects leading to exercise of power under the second proviso to section 5, breach of which are not the aspects that could be subject matter of proceedings under section 8. Accordingly, the power of under section 8 does not permit such an inquiry as raised in the present case. If that were to be so, it cannot be stated that power conferred under section 8 would be efficacious alternative remedy to redress a grievance regarding non-following of the restrictions imposed for exercise of powers in the context of second proviso. Needless to state that even if it was assumed that there is an alternative remedy in terms of law initiated in Godrat Sara, writ petition could nevertheless be entertainable, though subject to fulfillment of certain criteria. The responses relied upon. Notes, I'll not trouble your lordships on this. Notes, ultimately, the provisional attachment order, para 47, milords, the section 5 is again extracted. Then page 48, milords, para 48 at page 59. Admittedly, in the present case, the requirements of the first proviso are not met with insofar as final report forwarded to the magistrate as regards the predicate offence under 173 as on the date of passing of the order of provisional attachment. Such aspect is not controverted by the other side. However, the power to pass an order of provisional attachment is conferred upon the officer of the rank of director or any other officer not below the rank of the director of so and so for the purpose of enumerated under section 5, subject to fulfillment of the following criteria. Has reasons to believe, which is recorded in writing and on the basis of the material in possession. 2, that is, if such property is involved in money laundering is not attached immediately, the attachment is likely to frustrate the proceedings of the act. Undoubtedly, the present case, if such powers is exercised in the second proviso to section 5.1, which is called in question. It is necessary also to note that the respondent is asserted in the time of law that Lokayukta police was still investigating as regards predicate offence against the other accused. On the date of the passing of the provisional attachment, it was further submitted the response that though B report was filed against some of the accused number 1 to 4 pending investigation against the other accused, as at the relevant point of time has in effect indicated the continuance of the investigation. The second proviso of section 5 confers powers that contains non-obstante clause and provides that notwithstanding first proviso, competent officer could attach properties provided such officer has reason to believe on the basis of the material in his possession that if such property is involved in money laundering is not attached immediately, non-attachment is likely to frustrate the PMLA. Insofar as the contention that authority has failed to adhere to the statutory mandate provided in the section proviso, matter requires consideration. Notes, on the merits, I will not take your lordship's. The rest of the contentions is on the merits. Can I just persuade your lords? May I also have a look at a view taken, my lords, only a persuasive judgment, my lords. A similar issue came up before the Kerala High Court at page 23. Exactly the same facts, my lords.
Yes.
Lords, I'll not trouble your lords because para 13, para 12, my lords. It extracts, and then para 5, para 13, section 5 of the PMLA authorizes attachment of proceeds of crime. The definition of the term proceeds of the crime explicitly states that when the proceeds of crime is a property, such property must have been obtained or derived as a result of the criminal activity relating to the scheduled offense. No doubt, even if the property was obtained indirectly, it can still be regarded as proceeds of the crime. Assuming that a property derived out of criminal activity mentioned is not available, still attachment can be effected to the extent of the value of such property. The term value in 2(1)(u) can only mean that monetary worth of the property that was derived from the criminal activity. If the attachment is to be effected to the extent of monetary worth of the property, which was not derived out of the criminal activity, then PMLA mandates that property derived out of such criminal activity be taken out of India or is held outside India. In other words, the only power to proceed against a property of equivalent value which is no link with the predicate offense is when the property was taken out of or held out of India. Not just that distinction, fine distinction is there, Milords, where they wanted to attach the properties which is in India and which is likely to be taken out of India, which is determining is the value of the, not assuming that there is no proceeds of the crime which is readily available, but value of the property is to be attached. Then the prerequisite is that it is likely to be taken outside the frontiers of the country. Therefore, except where the property derived out of a criminal activity is not inside the country, can the provisional attachment be effected on a property purchased prior to such criminal activity?
So that will only be a movable property.
In this context, it is appropriate to refer to the decision of Seema Garg, wherein the High Court of Punjab and Haryana elaborately considered the concept of proceeds of crime and held the property purchased prior to the commission of the scheduled offense does not fall within the ambit of the first limb of the definition of proceeds of crime, though it certainly falls within the purview and ambit of the third limb of the definition. Andhra Pradesh High Court is also observed along the same lines in Satyam Computers, wherein it is observed that PMLA, being statute which deals with substantive rights, cannot have a retrospective effect. However, the Delhi High Court taking a different stance. In the case of so-and-so, where it was observed that the term value of property must be understood to have been used in the same sense as the third limb. With respects, I am unable to subscribe to the view of the Delhi High Court and on the other hand, wholly concur with the views taken by Punjab and Haryana and the Andhra Pradesh High Court. I am further fortified in the above view that I have taken in the observations of the Supreme Court in the case of Vijay Madan Lal Chowdhury. It has been held in para 295-296 that the precondition for being proceeds of the crime is that the property has been derived and obtained directly or indirectly by any person as a result of the criminal activity relating to the scheduled offense. Be it noted that the attachment must only be in respect of the property which appears to be the proceeds of the crime and not all the properties belonging to the concerned person who would eventually face the action of confiscation of proceeds of crime, including prosecution for offences of money laundering. As mentioned earlier, the relevant date for initiation of action under 2022 Act B, it of attachment and confiscation or prosecution is linked to the inclusion of offence or schedule offence and of carrying on the process or activity in connection with the proceeds of crime after such date. The pivot moves around the date of carrying of the process and activity connected with the proceeds of crime and not the date on which the property has been derived or obtained by the person concerned as a result of criminal activity relating to or relatable to the schedule offence. Apart from that, the above, in Pavana Dibbur's case, it has been observed as follows. Another allegation is that both the first and second properties have been acquired out of the proceeds of crime. First property ex facie cannot be said to have been connected with the proceeds of crime as the acts constituted the schedule offence took place after its acquisition. This is not a case where any material is placed on record to show that the sale consideration was paid from a particular bank account to the appellant. Therefore, it is not possible to record a finding at this stage. Second property was not acquired by using the proceeds of crime. The aforesaid observations indicate that properties that can be proceeded against, exercising the powers of attachment, must be those which has been acquired utilizing the proceeds of crime. The contention of the learned counsel for the respondents that the term proceeds of crime will also include the value of the property which had been acquired even earlier, according to me, is too far-fetched. and will not be justifiable in the light of the constitutional provisions of fairness and reasonableness. It is also necessary to observe at this juncture that the purpose of PMLA is to remove tainted money and also to initiate proceedings against the proceeds of crime which have been transformed or converted into any other property or intermingled with the legitimate sources, and then the value of the intermingled gain will assume the color of the proceeds of the crime. Such a provision cannot be used to enable the authorities to proceed against properties that are unconnected with the criminal activity in question. Viewed in the above perspective, the provisional attached immovable property was purchased in 2004, more than a decade and a half before the predicate offence was committed. Order attaching immovable property is expressly ultravies the powers of the statute and totally illegal and arbitrary to the extent of the said attachment. Since expressly illegal acts can be interfered under 226 of the Constitution, notwithstanding the existence of an alternative remedy, this court is of the view that provisional attachment of the immovable property, as seen from Schedule A to Exhibit so and so, is liable to be set aside. However, as relating the provisional attachment mentioned in respect of B to 11, in those relating to amount of the bank accounts, the petition has an effective remedy in respect of the statute because it was a continuing. Because wherever there is an intermingling or merging, where it is not capable of being bifurcated, certainly the remedies are still there. They can still trace it back. But when it comes to immovable property, two propositions, as I could understand from the judgment of the Kerala High Court is, when you want to attach any property which is not related to the proceeds of the crime, but you want to relate to the value of the property, condition is the removal. That means it should be movable property which is likely to be taken out of the country. That is one avenue which is available. But when we come under Section 5, you want to pass an order of provisional attachment. Condition precedent is that it should be proceeds of crime. Lords may now kindly have a look at Section 5 of the Act. Then I take you, Lords, to the first judgment, my lords, because it interprets what is meant by proceeds of crime. Where the director or any other officer not below the rank of the deputy director authorized by the director for the purpose of this section has reasons to believe, the reason for such belief to be recorded in writing on the basis of the material in his possession, that any person is in possession of proceeds of crime, and such proceeds of crime are likely to be concealed, transferred, or dealt with in any manner which may result in frustrating any proceedings relating to confiscation of such proceeds of crime. Under this chapter, he may, by order in writing, provisionally attach such properties for a period not exceeding 180 days from an order in such manner as prescribed. Provided no such order of attachment shall be made unless in relation to the schedule offence a report has been forwarded to the magistrate under 173, or a complaint has been filed by a person authorized to investigate the offence mentioned in the schedule before a magistrate or court taking cognizance of the schedule offence as the case may be, or a similar report or complaint has been made or filed under the corresponding law or any other any other country. Lords, I will not trouble your lords by reading the other provisions. It's only till here, my lords, which may be relevant for the purpose of this matter. Lords, may kindly have a look at the definition of proceeds of crime, section 2U. May I read it, my lords? Sorry.
Yes. Yes, please.
Proceeds of crime means any property derived or obtained directly or indirectly by any person as a result of criminal activity relating to the schedule offence, or the value of any such property. Lords, may kindly mark that it is such a property, or where property is taken or held outside the country, then property equivalent in value held within the country or abroad. Now, there are three things, my lords. This definition has got three facets. Number one, any property derived or obtained directly or indirectly by any person as a result of criminal activity. There's no difficulty. Two, relating to a schedule offence. Two, or the value of any such property is relatable to the properties which is referred to in the first part, because the word used is such. Lord, that is already interpreted, Lord. I'm sorry.
Where such property is taken or held outside the country.
Outside the country, then the property equivalent in value held within the country. Lords, let us assume, Lords, that I commit an act here.
Only
100 crore rupees, I take it outside. Then, notwithstanding that the proceeds of the crime is not the property which I am holding in this country, then 100 crores worth of properties which is not relatable to the schedule offence, which is transferred out of the country, I can attach it here. This is the bifurcation. Therefore, three facets. But there's no Euclid's theorem in this. Lords, of course, I'm not relying upon that. There are series of judgments which says that state is required to be fair in taking a defense. It can't behave like an adversarial litigant when the litigations come up. No, I'm happy, Milords, of course. No, I'm happy.
We had the same argument yesterday in another matter. So today
No,
also
I
you are
should
at
be
the
happy,
same-
Milord. Sometimes it's only for the purpose of arguments, but they should contest. They should go to the writ appeal.
Yes.
They are very courteous to the profession at large, so therefore I should not have a grievance about it. But this is what it says. Now your lords may kindly see that the prerequisite to exercise powers under section 5 is either it is directly or indirectly from the proceeds of crime, or the value of such property. If your
It is
lords is
taken
going to
out of the
see,
country.
yes, such property, that is interpreted, my lords. Or if the proceeds of the crime is taken outside India, then the value of the proceeds which is taken out of India, even though such properties are not acquired out of the proceeds of the crime. That's all the definition says. Lords, therefore, to come before the court and say that we want to attach an immovable property worth which was purchased in 2004, 2009, when the predicate offense itself emanates from for the years 2011, 2012, it is too far-fetched. It is not permissible for them to exercise such a jurisdiction. So, since this is having some expropriatory effect, because you are taking the proprietary rights in relation to your property as crippled in terms of an order which will be passed in terms of section 5. One principle which has been laid is that all expropriatory provisions will have to be construed very strictly. There cannot be a deviation. There cannot be a substantial compliance theory also. It should be a strict compliance theory. Here it says, has reason to believe, the reason for such belief to be recorded in writing, on the basis of the material in his possession. So two ingredients in section 5, which is extracted, my lords, in the judgment of this honorable court, the coordinate bench, saying what? That any person is in possession of any proceeds of crime, such proceeds of crime are likely to be concealed, so on and so forth. It is nobody's case that some money has gone outside India. Therefore, the value of the property cannot be the concern. That's the reason why that value of the property is used. If your lords were to again turn to clause U, why the value is used, my lords? There is some reason for it. U. This is what, my lords, even the Kerala High Court has said in the earlier paragraph. But I'll just indicate, my lords, why that value is used. Means a property derived or obtained directly or indirectly by any person as a result of criminal activity relating to schedule offense, or value of any such property, or where such property so and so. Because the reason why the value of such property is utilized is to say, let us assume, my lords, that I am involved in some criminal activity which comes within the purview of the scheduled offenses. That money I put it in a huge property built in a big apartment complex. You cannot say that the entire apartment complex is required, because if the allegation is pertaining to 10 crores, you can attach only the property which is worth 10 crores, such value as relatable to the proceeds of the crime. That's essentially, Lords, what the Kerala High Court has referred, that it cannot be disproportionate to the value of the value for which the allegation is made. You cannot say 1 crore he has swindled, I will take away 100 crores worth property. That is not permissible. That is the reason why consciously it says value of such property or value of such property. Now, can I request your lords may kindly have a look at the first judgment.
You know, that value is not
Pavana Dipur's
relevant in
case.
your matter because no property has gone out of the country.
No property has gone out of the country, my lords. There is no question of getting into the question. Only question is, if I have acquired these properties in 2004, 2009 and the predicate offences are of the year 2011-12, where it is an allegation that I have given a certificate saying that my stockyard is containing ores, on the basis of which he has entered into some transactions, private transactions, as a result of which somebody else is caused with the loss. So therefore, I am held responsible, saying that I am the beneficiary of the proceeds of the crime. This is essentially, my lords, how it is proceeded. And even according to the statements which they have made, 19 lakhs rupees is what is said to have been transferred into my account in this transaction. I am a stevedore.
You are covering the law first and then coming to the
Please,
facts.
my
is
lords.
what we thought.
So therefore, my lords, now your lords may kindly take the first judgment. Lords, Pavan Dipur's case, of course, is extracted in the Kerala High Court judgment, my lords. Kindly, this is paragraph numbers. Mark Manipala. Para 13 and onwards, my lords.
Para 13.
Copy ile. Para 13. At page 13, my lords.
Yes.
Clause 5 of para 12 extracts section 3, then extracts the definition of proceeds of crime, including its explanation. Then clause 5 of subsection 1 of section 2 of PMLA defines property to mean any property or assets of every description, whether corporeal, incorporeal, movable, immovable, tangible, or intangible. To constitute any property as proceeds of crime, it must be derived or obtained directly or indirectly by any person as a result of criminal activity relating to the schedule offense. The explanation clarifies that the proceeds of crime, including the property, not only derived or obtained from the schedule offense, but also the property which may directly or indirectly be derived as obtained as a result of any criminal activity relatable to the schedule offense. Clause U also clarifies that even the value of such property will also be the proceeds of crime. Thus, the existence of proceeds of crime is sine qua non for the offence under section 3 of the PMLA Act. Then clause 10 of subsection 1 of subsection 2, PMLA defines schedule. Clause Y defines schedule offence as so and so. Para 15. The condition precedent for existence of proceeds of crime is the existence of the schedule offence. On this aspect, it is necessary to refer to the decision in Vijay Madan Lal Chowdhury's case in paragraph number 109. Minutes, I'll skip this minutes. Then para 17. Coming back to section 3 of PMLA on its plain reading, an offence under section 3 can be committed after a schedule offence is committed. For example, let us take the case of a person who is unconnected with the schedule offence, knowingly assists the concealment of the proceeds of the crime, or knowingly assists the proceeds of the crime, use the proceeds of crime. In that case, he can be held guilty of committing an offence under section 3. To give a concrete example of offences under section so and so relating to extortion or schedule offences included in para 1 of schedule to the PMLA. An accused may commit an extortion, crime of extortion covered under section 384, 389 IPC and extort money. Subsequently, a power unconnected with the offence of extortion may assist the said accused in concealment of the proceeds of extortion. In such a case, person who assists the accused in the schedule offence for concealing the proceeds of the extortion can be guilty of the offence of money laundering. Therefore, it is not necessary that a person against whom the offence under section 3 of the PMLA is alleged must have shown as the accused in the schedule offence. What is held in para 135 in the decision of Madan Lal Chowdhury supports the above conclusion. The condition precedent for attracting the offence under PMLA are that there must be a schedule offence, there must be proceeds of crime in relation to the schedule offence as defined under clause U of subsection 1. Now, the reason why I am reading this is para 13, para 14, 16 says that to exercise powers under section 5, there should be an offence under PMLA Act, because they get the jurisdiction to exercise powers under the PMLA the Act only if it is an offence under section 3 of the Act. For attracting the powers, the plenary provisions, milords, under section 3 of the Act, which they want to invoke, they should say that the proceeds of the crime is in my hands, in the nature of the property for which they want to seek this provisional attachment. Bank and other properties are always available. They are at liberty to do anything, because then para 18, milords, it says that you cannot
offense.
Yes.
And that there must be proceeds of crime in relation to
there should be a schedule offense.
Yes.
Then there should be proceeds of crime. Then comes section 3. Then comes section 5. Schedule offense, that's a predicate offense. Then there should be the proceeds of crime. Because every schedule offense, if your lordships were to see, has got some money generating through this crime. So therefore, it is very consciously captured under the provisions of the Prevention of Money Laundering Act. So wherever this wealth generation takes place by means of such activities as defined in the schedule, the whole object is to ensure that these proceeds, which is illegally or ill-gotten, is required to be extracted and then forfeited or confiscated to the central government. That's the whole object of the Act.
Yes.
Here, 2004, 2009, if I have purchased the properties, the question of they saying that no, this is proceeds of the crime would not arise. The definition is very specific. Now, what they want to do is, they say Value of property. Not value of property. Again, I said, there are two things. One is value of such property or value of the property which is already transferred outside India. Value of such property refers to the property which is in fact obtained as a proceeds of crime. That's what I read section 2U.
Yes.
But this is essentially where it lies, because the object and the purpose for which this statute is framed and the limited jurisdiction which they are entitled to make an order of attachment being circumscribed, they can't spread their wings beyond. Can I just take your lordships on the, because I'm not asking for something, my lords, which may be very unjustified. I will take your lordships to the kind of allegation which has been made against me.
Where is this extract by the Kerala High Court at para 16? It has been
In Pawan
observed.
Dipur's case.
Another
Lords, this is,
allegation is that both the first and second provision. Where is that particular extract?
This is, I just point acquisition of first and second property. There I had marked it, I just point it out. Definition, every crime generate para 29. Para 29, my lords. Para 28 and 29. My lords, so that particular phrase I will point it out, my lords. I'll just check it in the iPad code. I marked it. Kerala High Court judgment, where it says first property expression. That is, my lords, it commences from paragraph number para 19.
19.
Para 19, it starts acquisition of first and second property. That is essentially what is extracted, my lords. I'll just point out that
because the
my lords, in Placitum E, my lords, at page 16.
As the acts constituting the schedule offence took place after its acquisition.
Yes, my lords,
is what you are relying
my lords,
on.
Placitum E at page 16. Lordship gets it.
Another allegation.
Yes.
Is that both properties.
The next sentence, my lords, between Placitum E and F. The first property ex facie cannot be said to have any connection with the proceeds of crime as the acts constituted the schedule offence took place after its acquisition. That's what is extracted.
Happened finally in this judgment. Reject the first and
of course, second property, they say that it is not. Can I just persuade your lords? May also have a look at para 28 and 29, my lords, where they speak about the intent of the legislation.
The first property cannot be said to have any connection with the proceeds. The issue of whether tainted money was used for second property can be decided. It is hereby quashed and
that's a bank account, my lords.
Only insofar as the present appellant is concerned as regard the first property, is it?
Yes. Now, para 28 and 29, my lords. Of course, para 27, it extracts the statutory interpretation by GP Singh. And then para 28. While giving effect to the legislature's intention, if two reasonable interpretations can be given to a particular provision of a penal statute, court should generally adopt the interpretation that avoids the imposition of penal consequences. In other words, a more lenient interpretation of the two needs to be adopted. Legislative intent can be gathered from the definition of schedule offence under clause 5 of subsection 1 of section 2 is that every crime which may generate proceeds of the crime need not be a schedule offence. Therefore, only certain specific offences has been included in the schedule. Thus, if the submission of the learned additional Solicitor General are accepted, schedule will become meaningless or redundant. Reason is that even if an offence registered is not a schedule offence, provision of PMLA and the particular section 3 will be invoked by simply applying 120B. If you look at section 120B, only Because there is a conspiracy to commit an offense, the same does not become an aggravated offense. The object is to punish those involved in conspiracy to commit a crime, though they may not have committed any overt act that constitutes the offense. Conspiracy is an agreement between the accused to commit an offense. If you look at the punishment provided under section 120B, it becomes evident that it is not an aggravated offense. It only incorporates the principle of vicarious liability. If no specific punishment is provided in the statute for conspiracy to commit a particular offense, 120B treats a conspirator of the main accused as an abettor for the purpose of imposing punishment. Interpretation suggested by ED will defeat the legislative object of making only a few selected officers as schedule offences. If we accept such an interpretation, the statute may attract the vice of unconstitutionality for being manifestly arbitrary. It cannot be the legislature's intent to make every offence not included in the schedule offence by applying 120B. Therefore, in our view, the offence under 120B included in Part A of the schedule will become a schedule offence only if the criminal conspiracy is to commit any offence already included in Parts A, B, C of the schedule. In other words, the offence punishable under 120B will become a schedule offence only if the conspiracy alleged is of committing an offence which is otherwise a schedule offence. Not the reason why I read this para is same thing. Their contention is in 2011, 2012, I have given them a certificate saying that the 44,000 metric tons of iron ore which is there in my stockyard as a steve door is of so and so quality, say 53 grade iron ore. Now they say, no, it is not 53 grade iron ore, it is 49 grade iron ore. So there is an agreement between the person who is the owner of the stock. Notice wherever such transactions takes place, it's a matter of commercial practice. Now it is steve door certificates is of no criteria. Steve door will only indicate whatever is the certificates given. Steve doors as a matter of commercial practice. Some materials comes, then there will be certificates which will be issued. These are the certificates which will be a part of the records to say that this is the item which is lying in my stockyard. Somebody asks me what is lying in your stockyard for X who is given these things. I'll say this is what is there because this is based on the records. Now he says that 53 grade iron ore is lying in my stockyard as per the certificates, because the certificates will be generated by the competent people. They are called as chemists, metallurgists who will give such certifications. What is the sulfur content, phosphorus content, all these things they will give. Now that I have said that 44,000, the quantum of the ore which is lying there in my yard is not in dispute. Their contention is that the grade which is referred to in your certificate is not matching. That's not my problem. If somebody says I am dumping 53 grade, it will be there as 53 grade only. If it is 43 grade, it will remain there as a 43 grade only. I cannot change it. If somebody asks me what is the stock of this person, I'll say this is the stock which is available.
But that is probably your defense in those proceedings.
No, I'm not speaking about that, Milords. Now the allegation what is made against me.
Yes.
Because conspiracy should be there, Milords. Just to say that Milords, they have filed the this synopsis, your Lords may kindly take, Milords. Respondent has filed this.
Their synopsis.
Their synopsis. I filed it as a memo.
No, I didn't.
Respondent. Yeah, memo.
There is a memo along with documents.
Documents. This is again one more thing, Milords. That because they are statutory authorities, they cannot claim that they have got a special procedure to follow. They will have to file it in the nature of an affidavit. Every annexure which is produced, either along with the writ petition or along with the statement of objection, should be verified as the copies of the originals, or what is the nature of. I'm just stating, Milords, this is not the way in which the enforcement directorate can come and do all these things.
Memos in all matters has to be avoided.
I understand, Milords, but when it comes to the state, it should be very cautious.
For everybody.
They are the model litigants.
That will apply for everybody. Everybody
Yes, of
just
course,
comes
everybody
and dumps a memo.
I understand, Milords. We also do it sometimes.
We will stop taking these memos from now.
Milords, with an affidavit if it is filed, Milords, because the requirement is to.
My lords, I'll not rely upon that.
I am relying upon it.
If that is
Yes,
the
what
case,
do you want in this?
Milords, kindly have a look at page number 36. What is the allegation against me?
36.
Yes. Mr. Shankar Mahadevan Iyer, the proprietor of SS Maritime, has cheated Mrs. Manibal Global Services Private Limited. Milords, I'll just pause here for a minute. I'll take your lordships to the main offence. The allegation is that this Manipal Global Services Private Limited has entered into an agreement with Hanuman Minerals for supply of 44,000 metric tons of iron ore.
Where do we get that?
Page 34.
There's a specific role of the accused.
The specific role is, this is what they say at page number 34, and 36 is specifically with reference to the present petitioner.
Where are the details of the so-called crime?
Let's see, in our petition, we have produced it at page 15. In the provisional attachment order, they have extracted everything, Milords.
Yes, page 15.
Page 15, 2.2. In the schedule offense, the Deputy Superintendent of Police so-and-so has filed charge sheet video number so-and-so. As per the charge sheet, Girish Jaggal had entered into agreements with the complainant company Manipal Global Services on so-and-so 7/7/2009, 23/3/2010 regarding supply of iron ore. After supplying the iron ore and gaining trust with the complainant, he conspired with Rohan Prakash Lolitkar with the ulterior motive of cheating the complainant company. Accordingly, Hanuman Minerals Mrs. Global Services had entered into an agreement on 18/1/2012 for export of 40,000 metric tons of iron ore with 50% ferrous content in the presence of witnesses Damodar Shanbag. Next, with the help of Shankar Mahadevan, SS Maritime, they created a fake stock certificate showing Maritime was in possession of 40,000 metric ton iron ore on account of Mrs. Hanuman Minerals had given the same to Manipal Global Services, therefore betraying the trust of the complainant. None mere offense ಏನಿದೆ ಇದರಲ್ಲಿ?
He had created fake showing that SS Maritime.
He relies upon the stock certificate. It is not addressed to Manipal Global Services, Milords. It's a stock certificate which is issued at his instance. He is the one who comes and gives the stocks.
To issue a stock certificate, anybody would act upon it.
Milords, the stock certificate is given to him.
To whom?
Milords, to this Girish Jaggal.
SS Maritime gave it to Hanuman.
No, I have not given it to Manipal Global Services.
You have given it to Hanuman.
Milords, if I have given it to Hanuman, Hanuman, if he wants to deal with somebody else that the stocks is there, stocks will have to be verified physically. Nobody deals on the basis of the paper. Stock certificate is the basis for dealing with iron ore. I have never heard of it, Milords. Who will deal with the stock certificates and saying that I am having 2 crore?
That is a defense in your criminal.
Milords, that's not a defense. The allegation against me, Milords, is the second part. Milords, I am not a part of the conspiracy. Lordships, I am reading from the provisional attachment order. The first paragraph after 2.2, unnumbered paragraph, second paragraph says the conspiracy is with Rohan Prakash Lolitkar. Where my role comes in is because he used the certificate which I have given him. Milords, 40,000 metric tons is there, but the ferrous quality is low. It is 48 grade.
Yes.
Let's if in a transaction, this is like some standard, because when we are concerning with an allegation made between private parties, I can understand 2 private individuals, business transaction takes place.
You are arguing only the attachment.
I'm only the attachment. The reason why I am submitting with reference to para 28 and 29.
This cannot be considered by this court.
No, Milords, I am only saying only one sentence, Milords, out of whatever I read is conspiracy theory is also not there against me in the order of provisional attachment.
It is not something that can. Finally, your goods went from your place. It was loaded onto the ship from your place.
Milords, the goods.
How did it go?
Milords, that's the reason why I said, Milords, whatever stocks was there is removed. 40,000 metric tons was there. 40,000 metric tons is removed.
There's a matter
There's
of
no
trial,
doubt about
whether
it.
43, 50, all those things are a matter of trial.
No,
Not
I have no
before this
difficulty
court.
about it, Milords. The question is, when I say 40,000 metric tons is there, 40,000 metric tons is the physical quantity. There is nobody is doubting it. Kindly have a look at that, Milords.
But did your certificate have 50?
Can I just read that continuously, Milords? By relying on this stock certificate, Milords, I have not given any stock certificate of this. Kindly have a look at that. By relying on the stock certificates issued by Mrs. SS Maritime, complainant company advanced 2.3 crores and to Hanuman Minerals on various dates. However, at the time of loading iron ore into the ship, it was found that Hanuman Minerals had supplied low quality iron ore, which forced the complainant company to procure the required quantity and quality of iron ore from outside India in order to comply with the agreement signed with overseas client so and so due to the act of the accused, complainant company incurred a total loss of 9.2 crores on account of demurrage charges and purchase of high quality iron ore from outside vendors. Milords, how does it even remotely attract an offense, Milords? I'm really concerned with this.
Not on a 482, you may be.
Milords, I'm not
concerned
under
with this.
482, but to say that there is a crime and that there is a proceeds of the crime, there is no crime against me. Milords, I'm reading from what is the allegation against
Not
me.
something that we can.
Very well,
consider
Milords,
in
I
this
leave it at
petition.
that. I'm sorry, Milords, I leave it at that.
Don't expand it beyond what it
No, I quite get the point what your lordships is indicating, Milords. I'll stop it at that. Only wanted to make the point that as per para 28 and 29, even I don't fit into conspiracy theory.
Your only contention is, so far,
yes,
your only contention is that these properties were purchased before even the offense was committed. Therefore, it cannot be attached, number one. I have not secreted any property outside India to even apply the value. principle to it.
Theory, they cannot apply.
This could not have been done.
Yes.
Those are the two contentions.
Two
which are there.
contentions. Third contention,
Clear
of
and
course,
partly.
Milords, I'll not going to, as your lordship said, I'll be relegated elsewhere to urge this
Elsewhere.
contention.
If you argue that, then it stops
No,
here.
I'll not invoke any observations from your lordship, Milords. I'll get it elsewhere. So
Yes,
therefore,
madam.
Milords, this is a case where your lordship's indulgence may be required, Milords.
Yes, madam.
Yes, my lords, may
Can I
kindly-
seek your lordship's excuse, Milords? The iPad.
My lords may kindly turn to,
Just pull up the mic.
my lords may kindly turn to page 15
Of,
the petition, my lords.
yes,
It's the provisional attachment order.
yes.
Now, my lords may kindly see 2.2. As per the charge sheet, Sri Giri Jugal had entered into agreement with complainant company, means Manipal Global Service Private Limited on 7/7/2009 and 23/3/2010. So cause of action has arose on 7/7/2009. Now, my lords may kindly see how based on his certificate, the transaction has happened. My lords may,
7/7/2009.
please, my lords.
Yes. When were these properties purchased?
My lords, one is in 2004, one is in 2009.
Date
Now, my
of-
lords, we are
Date
not.
of purchase in 2009?
Please at page number, my lords, may kindly turn to page 38.
Yes.
Details of immovable properties mentioned.
19/1/2009.
My lords,
19/1/2009, my lord,
Just
second
one
sale date.
second, let me complete.
We did not ask you. Yes.
My lords, may kindly turn to 38, page
So the
38.
first property is 2004.
Correct, my lords.
Second property is 19/1/2009.
2009. Please,
For cause of action is 7/7/2009.
please, my lords.
So much
Please,
after that.
Please, my lords. My lords, I'll take my lords, the jurisprudence have evolved. I'll take my lords to the subsequent recent 2026
After
judgment.
Pavana Debur.
Please, my lords.
Yes.
May kindly turn, we could not trace the proceeds of crime because the amount were withdrawn, my lords. That's why we had no choice but to attach value equivalent. That is permissible, my lords, has been held by Supreme Court as well as other courts,
you
which
take
I
us
will
through
take,
those.
my lords. May kindly turn to page 33.
33. Yes.
My lords, two lines from the bottom. On perusal of bank accounts of Hanuman Minerals, it was found that amount of 2 crore 30 lakhs advanced by Manipal Global Private had been received in its bank account maintained with the Bank of India. From this bank account, part amount was withdrawn as a cash, so we could not trace. And a portion of amount had been diverted to the bank accounts of Sri Rohan Prakash and Shankar Mahadevan Iyer. 17 lakhs was transferred to him. So, my lords, the entire 2 crore 30 lakhs we could not trace, lay our hands because that has been withdrawn.
53,80,000 you are not able to trace.
Yes, my lords. We could not trace it because it has been withdrawn.
And
Now, my
again,
lords,
out of 96 lakh, 32 lakhs.
please, my lords.
So you had around 86 lakhs.
Please, my lords. Now, my lords, based on this, we have attached certain properties. May kindly come to 38.
Yes.
My lords, at the last column, relation of the property with the schedule offense. Value of any such property in lieu of proceeds of crime. At the last, my lords.
Yes, but the
38, my lords.
the value as argued is to you Value would only be relevant if it is secreted out of the country.
May not be, my lords. That is where, my lords, I'll take you to the judgments,
Okay.
the jurisprudence on the
Yes.
value thereof.
Yes.
Please, my lords, I have to address only 2 points. One is value thereof and other is prejudice.
Purchase.
Purchase.
One is you have to address purchase.
Please, my lords.
Purchase is before the cause.
Please, my lords.
After that, the value will come in.
Please, my lords. Now, my lords.
Value is your standby.
Yes, value is my standby. Relation of the property with schedule offense. Value of such property in lieu of proceeds of crime.
Yes.
So we do not level it as proceeds of crime. We level it as a value.
Value.
My lords, the last paragraph, value equivalent.
Yes.
Now, my lords, I have offense is 2009 to 2011. Proceeds of crime is value thereof we have taken, and we could not trace the amount. 2 crore 30 lakhs, we could not trace it.
85 lakhs you could not trace.
Only
You have traced
85
out-
lakhs, my lords.
Only
Balance is
85
still,
You have traced 17 lakhs with SS Maritime.
please, my lord. SS Maritime is nothing but the same. He's the proprietor.
So you have traced it.
17 lakhs, my lords. His account, this
And,
amount was not there in his
Phoenix
account.
International, you have traced 96 lakhs.
Please, my lords. My lords, these accounts did not have this money. They withdrew it.
Even that money was
Yes, my lords. They have withdrew. What we can attach is, my lords, the details of movable property, my lords.
withdrawn.
May kindly turn
Bank
to page
accounts have not been attached.
39.
Bank accounts have not been attached.
Bank accounts are attached, my lords, not of this petitioner, of other accused.
Yes. How much of the bank accounts have been attached?
My lords, there is totally we have attached 3,27,223. 3,27,223. Page 40, my lords.
Only 3 lakhs.
Only 3 lakhs.
Yes.
Yes, my lords. So we could not lay hands on the proceeds of crime, that is 2 crore 30 lakhs. Now, my lords, may kindly take the judgment on this point. So I have given a,
Yes. Memo along with citations.
please, my lords. My lord, the first judgment is Arun Suri versus Directorate of Enforcement. This is passed in February, my lords. Similar set of argument. The 7, my lords, para 7. It has been argued that subject property could not have been attached value thereof in terms of section 2(1)(u) of PMLA Act. Since the said property was never actually purchased by the appellant himself, the right of the appellant in the subject property has flown through his deceased father, and thus it was wholly impermissible to rely upon section 2(1)(u) of PMLA to attach such property. Placing reliance on Karnataka High Court in so-and-so, so-and-so, it is argued that as per section 2(1)(u) of the PMLA, only these tainted properties which are obtained directly or indirectly as a result of criminal activity relating to scheduled offense can be termed as proceeds of crime, which is not in the situation in the present case, as the subject property which was not purchased by the appellant's money, but rather purchased by his father from his own money. He also placed reliance on Pavana Dibur. Then, my lords, may kindly come to para 9.
Yes.
We have considered the rival submissions. The principal contention urged on behalf of appellant is that subject property was neither acquired nor purchased by the appellant from proceeds of crime and was ancestral in nature, and therefore could not have been attached. At the very outset, it is opposite to note that the competent authority under section 5 of the PMLA is empowered to provisionally attach property believed to be proceeds of crime. The Honorable Supreme Court in Vijay Madan Lal had that offense of money laundering is not dependent or linked to the date on which the scheduled offense or predicate offense is committed. The relevant date is the date on which the person indulged in the process of activity connected with such proceeds of crime. While interpreting the word value thereof, the Honorable Supreme Court in the case of Vijay Madan Lal clarified that definition of proceeds of crime is wide enough not only to refer property derived or obtained as a result of criminal activity relating to scheduled offense, but also the value of any such property. If the property is taken or held outside India, even in such case, the property equivalent in the value held within the country or abroad can be proceeded with. This court in the case of Prakash Industries held that properties which were acquired prior to enforcement of the Act may not be completely immune from action under the Act. In Prakash Industry, this court reiterated that observation made in Axis Bank that the expression proceeds of crime emphasize both tainted property as well as untainted property, with it being permissible to proceed against later, provided it is being proceeded as equivalent to the value of any such property or property equivalent in the value held within the country or abroad, provided the actual tainted property cannot be traced or found. This is important, my lords. Thus, where the respondent is unable to discover.
This was held by the Delhi High Court in Axis Bank.
Yes, my lords, followed by this present judgment, my lords. Thus, where the respondent is unable to discover the tainted property, it may proceed to attach even an untainted property equivalent in value.
Within the country.
Please, my lords. My lords, in this case, ancestral property. The adjudicative authority, upon reappreciation of evidence, recorded a finding that the property represent value equivalent to proceeds of crime generated from scheduled offense. The plea of property being ancestral does not ipso facto grants immunity from the attachment under the PMLA. The statute doesn't carve out an exception for an ancestral or inherited property. Thus, they are not immune from attachment. The argument that the ancestral property cannot be attached unless purchased from illicit funds is misconceived and contrary to scheme of the PMLA. Hence, we find no perversity or illegality in the findings of the adjudicatory authority. The appellant tribunal, while upholding the attachment, has exercised jurisdiction vested in it under the statute, and impugn order reflects due application of mind, adherence of statutory requirement, and consideration of material on record. Now, my lords, all these things, whether it is arguments which has been advanced on the merits of the provisional attachment order, can be adjudicated before the adjudicatory authority. My lord, that has been strictly interpreted by the Honorable Supreme Court in the recent JSW judgment. That, my lords, will get it at page. It's there. My lords, may kindly turn to page 14. Similar set of facts, my lords, in that case, they have stated that the arbitral tribunal have held that this property belongs to someone else. So set aside the provisional attachment order. My lords, may kindly turn to page 19. Para 33, having heard learned counsel for both the parties and on perusal of records, we note that appellants have already invoked their statutory remedy before the appellate tribunal under 26, which remains pending. It is important to know that PMLA provides a comprehensive and self-contained adjudicatory mechanism. Section 5 enables provisional attachment, Section 8 contemplates confirmation by adjudicatory authority, and Section 26 provides an appellate remedy before the appellate tribunal. The appellant in the present case have already invoked their statutory remedy of appeal, which remains pending. Now, my lords, we have issued the show cause notice. He doesn't appear before the adjudicatory authority. He comes directly under 226. Then, my lord, this court has consistently held that constitutional or appellate jurisdiction should ordinarily not be exercised when efficacious alternate remedy is available and actively being pursued. Reference may be made to Union of India, which cautions against bypassing statutory forums except in cases of patent illegality or jurisdictional error. We find that note that it is undisputed that ECI registered by ED does not name the appellant as accused person. The charge sheet filed by CBI so does not array them as accused. The complaint filed by the ED is predicated not on any independent act or laundering, but on the allegation that the appellant withdrew certain sums from the attached bank accounts in violation of POS, thereby frustrating the recovery of so-and-so, alleged to be proceeds of crime. The core issue before us is not whether the appellant's entire banking operations are tainted, but whether the specific sum so-and-so representing unpaid consideration of iron ore supplied by AMC can be treated as proceeds of crime, and whether it is withdrawn post POA constitution offense under Section 3. The apprehension that the entire account balance constitutes proceeds of crime is misplaced, and particularly when the indicted position is that payments were made and received through regular banking channels are duly reflected on books of account. Viewed from this, the appropriate course would be permit the statutory process to run its route through reach its logical conclusion. Interference at this stage would prejudice issues that are squarely within the domain of appellate tribunal, including whether the attached property represents proceeds of crime within the meaning of section 2(1)(u) PMLA and whether the withdrawal were in violation of law. In light of these findings, we are unable to hold that the case for the quashing of cognizance order or interdicting proceedings is made out. The allegation at this stage are confirmed to the recovery of quantified amount of 33 crore, do not extend fastening criminal liability on the appellants beyond that process. The apprehension of arbitrary prosecution is therefore misplaced. Accordingly, we decline to interfere with the proceeding at this stage. The appellant shall be liberty to pursue their statutory appeals before the appellate tribunal. We shall decide the same on their own merits and accordance with law, uninfluenced by any observations contained thereon. Then, my lords.
That's a different issue. This
My
was
lords,
a
that's a
matter
different issue. But, my lords,
where the cognizance was challenged.
they have challenged the event, my lords. They have challenged the adjudicatory authority's order, appellate.
Relying on of the Supreme Court, there are two facts which are completely different.
Please, my lords.
One is what was challenged was the issuance of summons and taking cognizance. Two is that they had already approached the appellate remedy under section 26.
Please, my lords.
Here, they are neither challenging the summons or cognizance, nor are they challenging nor have they already been on appeal.
No, my
They
lords.
have
We have issued notice. Proceedings have been started before the.
You have issued notice.
My lords, adjudicatory authority has already
because
seized.
you issued notice, only the matter has come up.
My
There's
lord,
no
that is
dispute
not
about it.
challenged. Adjudicatory authority has already seized of the matter.
Please see two things.
Please, my lords.
They had already gone on appeal.
Please,
That is
my
why
lords.
the Honorable Supreme Court said, let them prosecute
Please,
the appeal which they've already filed and let the appellate authority decide.
Please, my lord.
And that was said in a matter where the challenge was to the cognizance
Yes, my lord.
and summons being issued.
Please, my lords.
This is a different fact situation.
My lords, in that case, they have challenged the not only summons, my lords. They have also challenged the
Please see
provisional
para one.
attachment order also.
Para one.
If I am not wrong.
PC para 1. Unnumbered para 1.
Please, my lord.
Challenge writ petition number so-and-so was to the proceeding including investigation emanating from so-and-so or passed by a special court taking cognizance of the offence and issuing summons was challenged.
Well, as both are together taken, my lords.
Where is the other one? The facts is only this. It was not a case where
My lords, both were taken is, my lords.
where the PO has been challenged. That was not the case in there.
My lords, my lords, may kindly come to para 8.
Yes.
On 27/3/2015, ED issued first provisional attachment order attaching bank account.
Para 10.
8, my lords.
8. Yes.
On 27/3/2015, ED issued first provisional order attaching bank accounts of appellant so-and-so. JSW challenged the POA before the writ petition before the High Court. On so-and-so writ petition seeking quashing of original complaint and show cause notice dated. Another POA was issued on so-and-so.
Those were different matters. Those ended
My lords,
in a division bench. Then it went to this SLP.
yes, my lord. That also, my lords, has been.
Were admitted. That's a
Those
complete
also
different-
has been set aside, my lords. Those were dismissed.
No. Please see. Don't mix up the facts.
Please, my.
That writ petition 2444,
Hmm.
show cause notice was challenged.
Please, my lords.
Another PO was issued that was challenged in 19/3/13.
Please, my lord.
Writ petition which were preferred by so-and-so and other petitioner were quashed by the division bench of the High Court of Karnataka. By ordered 13/3/2017 by holding that the ED could not have invoked the provision of PMLA with retrospective effect for the offences. Pursuant to the decision of the division bench of the High Court, the appellate tribunal and PM disposed of the appeals filed by so-and-so. SLPs were preferred. Those facts are different.
Yes. Well, ultimately, my lords,
Please
the
be
fact
clear
remains
on-
is the statutory, when there is a efficacious statutory remedy available, these things
It is
can.
not what this decision says. In this decision, they had already gone on appeal.
Yes, my
Therefore,
lords.
they were allowed to complete the.
Please, my lords.
Your argument is different.
My argument is, my lords, is what I try to formulate is that already adjudicatory authority has seized of the
Correct.
matter.
For that, this decision doesn't support.
Please, my lords.
Yes.
Please, my lords. Then, my lords, may kindly turn to another judgment of Kerala High Court, my lords, at page 22.
Page 22 is Supreme Court judgment.
My lords, this is confirmed by the Supreme Court. So that judgment also I have produced, my lords, order.
Dinesh
They have
Krishnan
challenged
on
that order.
Kerala judgment is 24.
24, my lords.
Yes. Division bench judgment. Yes.
My lords, may kindly come to page 42.
42.
Yes.
Yes.
My lords, may kindly come to 44, para 15.
44.
I'm sorry, my lords, 14, my lords.
What is being relied upon is a Karnataka judgment. We are bound by the coordinate
Yes, my
bench's
lords.
judgment.
That is correct, my lords. This is not
Unless
reliable
you
because
show us a judgment which is different from that delivered by the coordinate bench or by a division bench of this court or by a Supreme Court. To other courts will not help because we are bound by this court judgment.
yes, my lord, but why I am relying upon is because this order has been confirmed by the Supreme Court, my lord.
Yes.
My lords, 14. Furthermore, the provisional attachment of property involved in money laundering can be effected only by the officer, specifically the statutory solitary in a matter is seizure under so and so. My lords, the authority is of the authority of an authorized officer under Act is to initiate prosecution of offence money laundering is triggered only when the property in question satisfy the definition of under section 21U is involved in the process of activity connected with the offence. Mere existence of undisclosed income, regardless of magnitude, will not attract the definition of proceeds of crime unless there is it has a nexus with the criminal activity relating to the scheduled offence. In that view of the matter, any action taken by assistant director under section 54 will have no effect once a provisional attachment order is duly made in respect of property that qualify as proceeds of crime. With respect to properties included in such order, the appellants are at liberty to raise all their contentions before the adjudicatory authority and other forums provided under the Act, and to exhaust their remedy in accordance with law. We find that by an interim order passed by single, the proceedings before adjudicatory authority were stayed. In that view of the matter, 30 days time was granted by the adjudicatory authority under section so and so. If reply is filed so and so, in the light of above, these appeals stand dismissed, granting liberty to appellant to pursue their contention in terms of the statutory scheme. So, my lords, whatever objections that they have filed, that with respect to the provisional attachment order, can be very well adjudicated before the adjudicatory authority.
What did
my
the
lords.
Supreme Court say on this?
Then, my lords, I have placed on record
Only on the exercise of discretion.
Yes, my lords, it is. Well, they have to make out a case.
There's no finding that. See, there's a finding of this court.
Yes, my lord.
Coordinate bench of this court has
Yes,
said
my
that
lord.
it is maintainable.
Please, my lords.
Unless that is set aside, number
Yes,
one. Or unless there is a bench of higher strength
Yes, my lords.
holding otherwise.
Yes,
There's a coordinate bench judgment.
Yes.
Committee requires us to follow that, or
Yes,
we'll
ma'am.
have to refer it.
Yes, ma'am.
That's the only two options.
Yes, yes. That is true.
Since there is an order passed by a coordinate bench,
Yes,
we are
my lords.
generally bound by it.
Yes, my lords.
Apex Court dismissed the appeal
Yes,
in
my lord.
limine.
Yes, my lords.
There no
There is no finding on.
Honorable Supreme Court has also held that
Yeah.
that will not be a binding precedent.
Yes, my lord. Again, it is facts to facts, my lords. In this case, my lords, his allegation.
You have to, they have shown us a judgment. Now it has gone beyond the facts.
Yes, my lords.
When they show us a judgment,
Yes,
you will have to show us a judgment.
Yes, my
We'll be bound by judgments.
Yes, my lords. I'll place on record, my lords, identical.
Nothing is here.
My lord, so far as proceeds of crime, property, untainted property can be attached under provisional attachment order. That, my lords, I have satisfied that we could not lay hands. We could not lay the hands on the proceeds of crime, so we had to take value equivalent.
That you will have to place before us the judgment which has been quoted. That is that Axis Bank judgment.
Please, my lord.
Because the reasoning we can't make out from here.
Yes, my lord. I'll place on record that Axis Bank judgment.
Finish everything.
My lords, because that is referred in this Arun Suri, so therefore I did not.
That is why we keep telling all of you. If you are referring a passage of a judgment in another judgment, give us the original judgment. Don't give us the passage.
I will do.
This passage doesn't help.
Yes. I will
Even
place
the
on
original,
record.
you are relying on that passage.
Yes,
For us to understand what the judgment is, we'll need the facts of it.
yes. My lords, me pass it over. I'll just get the copy.
Yes, please get.
Yes,
Pass over.
this one. What happened there?
Serial number 7.
To the respondents.
Yes, where is Mr. Ranga? Pass over, ask, call him.
I apologize for his absence.
Call him. You are arguing.
My lord, is it possible that I have it tomorrow or day after, my lord?
No,
that-
no, no, let us finish
or
it today.
Then I'll
This
address,
happened the last
I will
3
address
times.
the arguments, my lord.
Yes, please. Good.
My lords, for comments, my lords, may kindly see the order that was passed by this honorable court in the very same proceedings, my lord, 31/7/2025. The reason why the interim order was granted.
Thirty-one, 725. Yes.
Yes, my lord. I may be permitted to read, my lord.
Hmm.
Shri S. Sriranga, learned senior counsel for the petitioner, submits that 1. The arbitral tribunal could
Now these
not have.
submissions become irrelevant after Supreme Court
No,
judgment
no, no.
comes
Why,
up.
the reason why I'm pointing it out, my lord, because as on the date, the order was recalled, my lord, the 12-year time period from the date of reference was also over.
That is what the Supreme Court has said. It doesn't matter.
That's the distinction between section 25, 31, 32. It doesn't matter. It is all the same.
Correct.
But, my lords, the mandate of the tribunal itself, when it was over, it is not a question where, my lords, the claim was.
Have you read the
The
judgment?
order,
of,
yes, my
have
lord.
you
The
read the
order-
judgment of the Supreme Court, Mr.
Please, my
Counsel?
lords. My lords, page 171, para number 266. The power of the arbitral tribunal to terminate
170
proceedings.
171.
My lords, I'm sorry. Para 266, I'll just give it from their compilation. No, one that is already filed by the other side.
Which is the page number in your compilation? What is the page
I may
number?
be
in your-
permitted to file, my lord. This is page number. Same page number, 171.
Which is the judgment you relied upon, madam, last time?
My lords, that's the judgment of the Supreme Court in Harshbir Singh.
Yes,
Page
it's the
number?
same judgment, my lord. It is the same judgment.
It's the same judgment.
171, para number 266.
Where did they give it? We had marked it. Now, Didi Ali. Ah, there it is. It's not here. Yes, you can come to conclusions, para 415.
Yes, ma'am.
Hmm.
Para 415.
Hmm.
Section 32 of the Act is exhaustive and covers all cases of termination of arbitral proceedings under the Act 1996. Power of the arbitral tribunal to pass an order to terminate the proceedings under the scheme lies only under Section 32(2).
Yes.
The Section 25, 30, and 38 of the Act of 1996 respectively only denote the circumstances in which the tribunal would be empowered to take recourse under Section 32(2) and thereby terminate the proceedings. Because I'm not disputing any of these facts. All that I'm making a submission is that as on the date the order came to be recalled, the time period of 1 year was already over. There is no memo filed by the parties extending the mandate of the arbitral tribunal. Till date, my lords, there is no memo filed. They have not approached the court. That, my lord, under section 14 and 15, my lords may kindly see. In that regard, I may be permitted to file a judgment of the Delhi High Court. Which deals in a similar situation.
Please come to para 9. You read only 1 or 2 paras. There is a Supreme Court judgment. Don't try to interpret
Yes,
the
ma'am.
Supreme Court judgment in that manner.
If I am aggrieved by the order, the manner in which it is supposed to be challenged
That's
is
all.
also laid down by the Honorable Court.
Can you come before us?
Yes.
You may have the best case, you may have the worst case. We are not saying anything about it. You'll have to comply with what the Supreme Court says.
The only point that I'm trying to make here, my lord, is that the 1 year time period, they have not filed the claim from the date of reference to the date on which the order was recalled. It was already over.
Can you argue that in the teeth of the judgment of the Supreme Court? It's very clear.
Yes.
That may be a ground in 34, it may be a ground wherever.
Yes.
Arbitration is a different footing. Court. Petitioner is before this court. Petitioners are before this court seeking for the following leaves. Arbitral proceedings were initiated by the respondents by only one first respondent, is it?
Please, my lords.
Claimant was only the first respondent.
First respondent.
By the first respondent. Everybody has been served. Or?
My lords, by order dated 18/8/2025, notice has been dispensed with respondent 2 and 3.
Petitioner, respondent number 1 had initiated arbitral proceedings. There being no consensus as regards the appointment of an arbitrator, the first respondent instituted CMP 902 of 2022 under section 11. And there was one other proceeding in CMP 377 of 2021 filed by 1C Manish, who is the son of respondent number 2. This court, by order dated 23/8/23, had appointed an arbitrator with the arbitration to be conducted under the aegis of the Arbitration Conciliation Center, Bengaluru, wherein the matter was taken up for consideration as AC number 584 of 2023 and 585 of 2023. The Director Arbitration Center had called upon the claimant to submit its claim statement within 30 days, which the first respondent failed to do. The proceedings have been fixed on 19/3/24. None appeared for the claimant or neither the claimant nor his counsel was present. The claimant not having filed wakalatnama nor having deposited the fees, the learned arbitrator was pleased to terminate the arbitral proceedings on 19/3/2024. Thereafter, the respondent number 1 filed a claim petition on 23/7/24 with application seeking for recall of the order dated 19/3/24, which was objected to by the petitioners. However, the learned arbitrator, while order dated 14/10/24, was pleased to recall the order dated 19/3/24, subject to payment of cost of rupees 5,000. It is aggrieved by said order of recall that the petitioner is before this court. The submission of learned counsel for the petitioner is manifold, inasmuch as it is contended that the arbitral proceedings have come to an end on 19/3/24. The claim petition was filed only on 23/7/24, and the impugned order was passed on 14/10/24. The order in CMP having passed much earlier, the mandate of the arbitrator has ended, both on account of lapse of time as also on account of the termination of the proceedings under subsection 2 of section 32 of the Arbitration Conciliation Act 1996. This further submission is that once the arbitral proceedings have been terminated, there is no power, the arbitrator is rendered functus officio, and there is no power vested with such arbitrator to recall the order and revive the arbitral proceedings. That counsel for the respondent would submit that this issue has been considered in detail by the Honorable Apex Court in Civil Appeal number 14630 of 2025, Arshbir Singh Pannu and others versus Jaswinder Singh. The Honorable Apex Court has categorically come to a conclusion that, firstly, there is no embargo on recall. Secondly, if there is a recall order passed, then the only option available to the aggrieved party is to challenge the final award in Section 34 and not to challenge it by way of a writ petition. Thirdly, she submits that an appeal is only available, a opportunity to challenge is only available if the recall application is dismissed in terms of subsection 2 of Section 14 of the Act of 1996. She relies on para 415 of the decision in Ashdeep so-and-so, which is reproduced here under for easy reference. A perusal of the conclusions drawn by the Honorable Apex Court in Arshbir would indicate that if an application for recall were to be filed and the same were to be, and a favorable order is passed for recommencing arbitration proceedings, the only option available to a party aggrieved therefrom would be to participate in the proceedings and thereafter challenge the final award under Section 34 of the Act of 96. In the present case, a favorable order has been passed on the recall application. The arbitral proceedings restored and are going on until they were interdicted by this court by the interim order dated 31/7/25. In view of the decision of the Honorable Supreme Court, Apex Court, it is clear that there is no option or opportunity available to an aggrieved party on the allowing of an application and for recall to challenge the said order, but he has to wait till the culmination of the arbitral proceedings and challenge the same under Section 34. The said decision would apply on all fours to the present matter. As such, this court passes the following order. Writ petition stands dismissed. Liberty is reserved to the petitioner to agitate all grounds urged in the present petition in the application, in the proceedings under Section 34, if and so filed by the petitioner. If you succeed, you don't need to.
Serial number 8.
This pertaining to my lord, digitalization of the corporate department of FRS, my lord, finally approved by the my lord on 8/7/26, my lord. My lord,
What has happened?
Further, my lord, the financial department has been sought for.
Financial department.
Para 2 and 3.
An affidavit,
A memo, my lord.
a memo has been filed by the learned AGA, which reads as under. Relying on the memo and the documents produced along therewith, his submission is that the functional requirement specification bracket FRS has been finalized and budgetary allocation is awaited. He seeks for and is granted 3 months' time. Relist on 16th November.
Please.
Passed over matters. List number 1, serial number 8. Mahesh Vayan.
Who appears for the respondent?
Milords, I appear for R1, Milords.
Ah.
For DRI, Madhu and Rao, Milords, can be asked to take notice.
Where is Madhu? DRI, notice will be an issue? No. Fresh matter.
Page 16, we will notice for a minute.
Hmm.
It's that matter where my Lord Rania Rao was caught allegedly smuggling gold to the tune of about 14 kgs.
Oh, this is that case.
That matter. Please
Hmm.
notice.
Because the name is different
Yes,
here.
my lords.
Hmm.
That's a full name.
Hmm.
I think more, we know more than Rania Rao. So this is the prayer which we have sought. My lords, prior to this, we had uploaded this honorable court, and the order passed by this honorable court for preservation of this footage. My lords should get that at page 19. The mother of Rania Rao filed a writ petition,
Hmm.
page 19.
Hmm.
Relevant portion at page 21.
Yes.
And also, my lords, the assurance given that it is going to be preserved.
Yes. And I made available.
Paragraph 3.
That if necessary.
Now, post that, my lords.
4:30 p.m. on 3/3 to 6 a.m. on 4/3
Whole period,
shall
my
be
lords.
preserved, and it would become necessary for trial at a later point of time. Yes. Hmm.
Because that was the whole period.
Hmm.
She leaves the aircraft, comes through the aero bridge,
Hmm.
and till she is coming out.
Hmm.
Now, my lords, after this, the confiscation and penalty procedure commences before DRI.
Yes.
Show cause notice is issued to us. Now, my lords, the show cause notice may kindly be noticed, my lords.
Page.
It's at page 27. The show cause notice has along with it the relied upon documents.
Page.
Page 27 is the show cause notice. The relied upon documents, my lords should get that at page 258, annexure 1.
258.
258, annexure 1. Well, it's shown as RUD, relied upon documents, in which, my lords, the last document may be noticed,
Item number.
152, item number 152, which is the last item.
Yes.
Now they rely upon certain CCTV footages. Now what is given to us, my lords, is truncated CCTV footages and not this entire CCTV footage. So when on the first date of the proceeding, my lords, which was on 16/4/2026, we bring to the notice, my lords should get that, at annexure E, page 261.
Hmm.
The very first aspect, my lords, which we point out is we request for the entire CCTV footage right from the aero bridge to the exit port. Now, my lords, what happens is, my lords,
Hmm.
so far as gold is concerned, it is not a prohibited item but a restricted item, my lords. Now, if I'm going to be carrying gold for a minute, well, not that I'm admitting I'm carrying gold. If I'm carrying gold, and if I'm going to be making a declaration and I pay 35% of what I'm carrying as customs duty, and then I can walk out after declaring it through the green channel or the red channel, my lords, after declaration. Now here what they would do is, they would not wait for me to come out of the green channel, but right at the aircraft, my lords, at the aero bridge, they cause an arrest. So, my lords, the most important aspect for me to show in my defense is, look, it was not even a case of allowing me to make any declaration, allowing me to pay any custom duty, but much prior to that, the DRI officials have come to the aircraft. So now what they give is this truncated.
Why are you disclosing all these things to Mr.
It's
Madhu?
a defense, my lords, but then
Madam,
how would I
I'll
just,
be
my lords,
happy.
how would I just?
I'll be more happy if this gets recorded. I'll be more happy if this gets recorded in the order, because gold bar, my lords, is by nature, it's prohibited in terms of baggage rules 2006. If they're ready to pay duty, my lords, we'll be more happy.
Please notice this, my lords. After that,
Sometimes councils get carried away. We can't get carried away by that. Now, what is the status? Can you give the,
My lord, the status now, my lord, is at the stage of cross-examination of all the officers.
now, what about the status of this pen drive containing the CCTV footage? They are saying it's a truncated one.
My lord,
At your
that is the
instance,
case,
it
my
has
lord.
been
There was
preserved.
an order, previous order, my lords, where there was a direction to give the pen drives. My lords, they made an application to the CASF. They, my lords, we are waiting for the court's order to be directed.
So you will give it to them.
I was also
Pursuant to, my
for a
lords.
moment, my lords, I was so happy that, my lords, my senior friend is telling that she was caught at the Aero Bridge. It is not the scenario.
It's all caveated without prejudice, without admitting.
Pursuant to,
So-
my lords, this court's order, we have saved it, my lords.
You are.
I appear for the CISF.
I have
Yes,
4 and
yes.
5, lordship.
So you have it.
I have it, my lords,
When will
pursuant
you, when will you give it?
to, as in when your lordships would order.
Now, the next date of hearing for my lords is 16th.
16th.
Before the adjudication.
Then you give it to them tomorrow. Tomorrow is 15th.
They can, my lords, always walk into the office, my lords.
After the directions, my lords.
There, it is stored, my lords. Whatever is stored, we will give it, my lords.
No, in fact, they replied, we need an order from the court. That's why we filed this writ.
Unnecessary you make.
Otherwise, we would not filed this writ itself.
Joint Director, Bureau of Civil Aviation Security, Airport Authority of India. Rama, Airport Authority of India.
Joshua Hudson Samuel. Joshua.
Joshua Hudson Samuel for respond number 3. Bad habit.
One submission.
You are appearing for 3, 4 and 5. 3 and 4, right?
That's one submission. It was not truncated. Perhaps they did not have what they wanted. That's the only thing. It is not truncated.
Whatever is there, you give it to them.
It's not truncated, my lords.
Lords, and also, my lords, there is another difficulty. Since, my lords, it involves the case of a woman. Lords, she was frisked in certain premises, my lords, where CCTV cameras are not there. So whatever is available, my lords, we will give it. Whatever we have saved pursuant to the order of this honorable court, we will give it.
That's a little double-edged, but don't invite one more litigation.
No, my lords, the instructions that I have received is that CISF will not have control over all the
Please see the order which has
CCTVs
been
of.
passed. In that light, the CCTV footage between 4:30 p.m. on 3/3 and 6 a.m. on 4/3 shall be preserved for the purpose of completion of investigation, and if it become necessary, for the trial at a later point of time.
We have saved, we have preserved it.
Shri Madhu N. Rao accepts notice for respond number 4 and 5. Notice to respond number 2 and 3 is dispensed with since there is no, they are not required to be heard in the matter. Petitioner is before this court seeking for the following reviews. The grievance of the petitioner is that the entire CCTV footage commencing from 4:30 p.m. on 3/3/25 to 6 a.m. on 4/3/25 has not been made available to the petitioner in terms of the order dated 2nd April 2025 and WP number 9798 of 2025. The submission of learned counsel for respond number 1 is that all the entire CCTV footage is available with respond number 1, and the petitioner can call upon respond number 1 to receive a copy thereof at a time convenient to respond number 1 with prior intimation to respond number 1. In that view of the matter, petitioner or representative of the petitioner is permitted to call upon the first respondent at 11:30 a.m. on 15 July 2026 to receive a copy of the aforesaid CCTV footage. With the above observation, the petition stands disposed.
Grateful.
IA1 is allowed.
Serial number 9. Shailaja K.
ಬಂದಿದ್ರ ಬೆಳಗ್ಗೆ ಏನಿದು Learned AGA accepts notice for respond number 1 and 2. ಅದಕ್ಕೆ ಬಂದಿಲ್ಲ. Issue notice to respond number 3 to 6 returnable by 17th August.
Serial number 41. Government advocate.
They're appearing for respond number 41.
That's in the morning, I think the petitioner, they sought time, GA was not available. We got it passed over.
41.
41, my lord, they said they will seek time. That's what they have informed.
Password marchideve belige.
No, Aditya told he's going to take a time. Anyway, let them commence. We'll call the AAG. If that is the case. He himself told me personally.
They are the respondents, they are the petitioner.
They want
This is
that time.
Aditya.
Aditya is
His
leaving.
colleague is here.
You are appearing for Mr. Aditya. You are seeking for time. Go now.
Aditya has
You
told
are not
me.
discussed with yourself.
I appear for respondent number 19.
So 1, 2, 3, 4 to 18 is dispensed with. Who are 4 to 18?
Plus 4 to 18 and other claimants
They are
against
not
whom we-
bothered.
Yes, madam.
They are counsel for respond number 26 for and is granted the short accommodation. When? After 2 weeks. Released on 6th August.
Great.
6 for and is granted 2 weeks time, released on 6th.
Password matter, list number 2, serial number 6.
List number 2, serial number 6.
Respond. Let's check for a short. Passover.
Passover.
Please apply.
List number 1, serial number 52, Maitreyi Krishnan.
Description. Who is for the
ASU, yeah, my lord. The ASG waiting for the
ASU is here?
Oh, here. So they have to answer.
Bartaranta?
Bartar.
Passed
They have
over?
to pass over.
There's one other matter of ASG which was passed over. We wanted.
That was 8, my lord. That is where
8 is done.
8 is.
Same matter you was waiting. It's 52 Paso.
Serial number 53,
Paper publication.
The petitioners, my lord.
Who is respond number 5?
Respond number 5 is the son of the petitioner here, my lord.
Senior citizen matter.
Senior citizen.
Mursati hogidya.
ಆಗಿದೆ sir, address
No.
absent.
Notice having been dispatched to respond number 5 on 3 earlier occasions was not capable of being served. As such, IA 1 of 26 has been filed for subservice by way of paper publication. Accepting the reasons stated in IA 1 of 26, the said application is allowed. Petitioner is permitted to take out subservice by way of paper publication in respect of respond number 5, which paper publication shall be published on or before 6th August, indicating the next date of hearing as 24th August.
Great.
In which newspaper? Where are they?
My lord, Kannada Prabha Kolar edition.
In Kannada Prabha Kolar edition.
Great.
1 of 26 is allowed.
54, Sudhindra Murthy.
What is this direction?
Number 3 and 4.
Senior citizen.
Respondent number 2 was supposed to file his written submissions.
Anything else anybody has to say? Mr. Arun submitted that yes.
I have filed written arguments in this.
You have filed.
Yes, yes.
All of you have filed.
Everybody have filed.
All the councils submit that they have filed their respective written submission, reserved for judgment.
Grateful.
Grateful.
55, Satish Adija.
Also appear.
I appear with the respondent. I have filed this application for vacating the proceedings under Senior Citizens Maintenance Act.
You are ready for the merits of the matter?
Please.
Yes.
Yes, also ready.
Really?
But originally, they challenging the order at page number 39. Before the assistant
39.
commissioner who passed an order saying that cancellation of the gift deed dated 18/5/2009, which is the favor of the husband of the petitioner. The properties originally belongs to my lord, that is the petitioner is a
Daughter-in-law and mother-in-law.
Please, daughter-in-law and mother-in-law.
Has it gone for mediation?
Please, I will read you.
Millard, it's not gone for mediation, but it's unlikely, Millard, because she is now an accused in the murder case, Millard. She's accused of killing my son.
Killing your son?
Yes, Millard. She's joined with the
Made an
paramour
allegation,
and,
this, the sessions course, my lord, the case was running. Still, it is also pending consideration. They have made an allegation saying that the petitioner would sue the illegal relationship between this some other party, they colluded to each other to commit any murder.
Therefore, my lord, originally the property belongs to the father-in-law of the petitioner. Way back in the year 1919, he purchased this property, which is the self-acquired property.
Yes.
And thereafter, he executed the gift deed in favor of his son, that is the husband of the petitioner. There are the.
And you are
gift deed
claiming
which
it under the person who has been murdered, allegedly murdered by you.
is made an allegation.
Allegedly ಅಂತ ಅದಕ್ಕೆ ಹೇಳಿದ್ದು.
Please, how?
Would you be entitled to the property?
How? Thereafter, my lord, please.
Until that proceedings are completed, would you be entitled for anything?
Blood first, blood is the section 23. He's filed a petition saying that the cancellation of kata is not on the basis of the section 23. Blood, kindly see the petition, page number 33.
Would you still be entitled when you are there's allegation that you have murdered the husband from whom you are claiming under?
Blood,
The mother is also residing in mother-in-law is residing in the said property.
blood, kata is a joint kata. My lord, is the petitioner and his daughter. It's a minor daughter. Joint name.
Can you still claim until you get acquitted in those proceedings?
I will ready to.
It is not that you are
Please.
guilty and until proven innocent Allah, not that. But a person who is accused of murdering somebody under whom they are claiming a property, you won't be entitled for.
But this petition is filed under section 23, which is not at all maintainable because its prayer may kindly see, my lord.
So what is the number, criminal proceeding number, appeal number?
The SC number.
SC number?
327/2014. 327/2014.
Petitioner is the daughter-in-law of respondent number 3. Respondent number 3 had filed an application under subsection 3 of section 20, under section 23 of the Senior Citizen Act, so and so. One of the allegations which has been made is that the petitioner has caused the murder of the son of our husband, that is son of respondent number 3, which is now pending in SC number?
SC number 327/14.
327/14. In that view of the matter, I am of the considered opinion that until the said proceedings are disposed, the present proceedings cannot be taken up.
That the grandchild is with me. I am bringing up the grandchild.
Yes.
That is the daughter of the petitioner.
Yes.
Visiting rights is also granted by the.
And there's a
custody of the grandmother.
custody case is going on.
Right. So
Yes.
the property will have to be in status quo
Please.
until then. In that view of the matter, the above writ petition is adjourned sine die until the disposal of so and so. Liberty is reserved to both the councils to move the matter after such disposal and placing the judgment on record. Both the petitioner and respondent number 3 are restrained from any manner alienating, dealing with, encumbering or changing the character of the property till the next date of hearing.
Please.
Till further orders, next date. Madam.
Serial number 56.
Yeah, for respondent in first matter, the petitioner in second matter. Yes, a week time to file my objections to
Michael ಆದ್ರೂ ಮಾತಾಡಿಲ್ಲ, ಜೋರಾಗಿ ಮಾತಾಡಿ.
In first petition, millets, I appear for respondent millets. In 56.1 and 2 millets, I appear for petitioner millets. I place a week's time to file my objections to the IA millets.
What is the IA?
IA for
Yeah,
impleading
filed an
application.
additional document, my lord, in respect of my.
You want to file objection to your impleading application?
Yes, millets. Impleading
Connected, why should you file objection? We'll allow it.
And another IA is there, millets, that is millets, additional documents, millets.
What objection will you have?
On record, millets, advocate is in
Yes, Mr. Parikshit.
But your lordship,
We'll allow both the IAs. Get
lordship,
ready on the
I will- because the document is a concocted one, I will file an objection because the members of the committee have given a affidavit to the effect that the document is a concocted one. So I will
Yes,
give,
so
I
we'll
will file an
consider
objection. my
IA
lord.
one
That
along
I
with
will
the
be-
main. Impleading application we'll allow
In the connected matter, my lord.
in the connected matter.
Let them permit it.
56, IA 1 of 25. Shall we take?
And the third petition has become infructuous, my lord, that the same may kind
Please,
of be
my lord.
dismissed.
Third petition have become
We'll-
infructuous.
One by one.
Please, my lord.
56. IA 1 of 25 will be taken up for consideration along with the main. 56.1, IA 1 of 25 has been filed to implead the petitioner in WP number 24327 of 2025 as a party respondent. Since these are connected matters and all the parties would have to be heard, IA 1 of 25 is allowed. The person named therein is brought on record as respondent number 5.
Please more.
Counsel for the petitioner to carry out necessary amendment, file amended cause title.
Serve a copy on me, man.
You filed a impleading application without knowing what it is.
Please more. I
How
took a
can
copy
we
from.
accept that? 41 copy. 56.2. Learned counsel for the petitioner submit that the above petition has been rendered infructuous. Placing his submission on record, petition stands dismissed as infructuous. When will you get ready? 24th matter.
Or any time, man. Court feels
Will you
convenient.
get ready, Mr. Parikshit?
Lordship, court audio is not audible clearly.
When will you get ready for arguments?
Not next
First,
week.
in the first petition, I will file an objection, my lord. Week's time may kindly be granted for application.
56. Learned relist on 6th August.
Please, my lord.
It's made clear that no further adjournment.
Please, my lord.
57, G.P. Shastri.
I appear for respondent number 9 and 10. While vacating stay, my lord,
Vacating stay, the main arguments.
Please.
You ready?
I have filed the statement of objection.
Yes, good. Yes, Ms. Shastri.
Milord, the prayer Milord is to, Milord, I am the owner of server number 9/899/21, Milord, in Moodanidimur village. Respondent number 9 and 10, Milord, are the owners of server number 9/5, measuring 10 cents, Milord, in the same village. Milord, the property, Milord, owned by the.
It's a civil suit, Ms. Shastri.
No, Milord.
Try to file a civil suit.
What I say is, not that. What I say is, adjoining the national highway, Milord, their property is there. Within 40 meters. Within 40 meters, Milord, national highway authorities, state highway authorities have, Milord, a liability, duty to see that construction is not put up. I gave representations as per annexure J, K, and M. The property, Milord, your lordships, is annexure D.
Okay, that representation will, the first prayer we can't grant. Second prayer, we'll ask them to consider your representation.
Right. Now, Milord, your lordship says, even this court has said, Milord, a division bench within 40 meters, Milord, construction.
Correct. We can only direct them to consider the representation.
That's
We can direct them to consider. Who appears for respondent number 1 to 8? Mr. Egde, you appear?
6 respondent and Abdullah.
Illa, 1 to 8 can't be one person. One, two, three, four. Would it be, who is to grant the permission? 6 or
But
7?
actually, this being a, Milord, within the building line, 40 meters, it's actually national highway authorities have to permit, if at all.
They have to give NOC. But who is to grant the land sanction?
Madam, I have applied for.
The
NOC
advocate,
and
Milord,
NOC
for.
Udupi Development
I have
Authority.
applied for NOC and NOC has been granted. I have produced it along with my vacating stay application. I'm not making any illegal constructions or something as claimed by the petitioner. I am making only repair works. What has happened is this, Milord. Due to the acquisition by the National Highway Authority, the property, Milord, it is a house property. It has been cut, Milord. So therefore, Milord, the property is in a building is in a dilapidated condition.
When they are granting permission, their objections will have to be considered. Now, who will do it? Udupi Town Development Authority or Udupi City Municipality?
The learned counsel for Udupi municipality told me that development authority
There is
have
no
to
fresh
consider.
license, my lord. National authority issued it seems NOC, my lord. On that basis, they are going to repair it, my lord.
Even for
If they were considered the representation,
They should come to you and take a permission, alwa.
municipality and.
Leave ಯಾರಿಗೆ?
I am for the town planning, my lord.
Municipality, Mr. Abdullah, you will appear. So the application, they have to make it to you.
Yes.
I refer it to the development authority for for sanctioning the plan.
So when you are
Check.
considering their application, consider Mr. Shastri's objection. And then pass orders. If they are aggrieved, they'll come before us, then we can examine the reasons. Until then, it is all hypothetical. Petitioner is before this court seeking for the following reliefs. The submission, the grievance of the petitioner is that respond number 7 may sanction a plan or consider an application filed by respond number 9 and 10 without considering the representation of the petitioner dated 25/8/25 and 17/9/25 at Annexure J and K respectively, as also the legal notice dated 24/9/25 at Annexure M. The reason for the same being that according to the petitioner, no construction can be carried out within the building line of the national highway, and it is that objection which has been submitted by the petitioner. At present, the claim of the petitioner is hypothetical in as much as the application, if any, filed by respond number 9 and 10 is yet to be considered by respond number 7. Hence, by directing respond number 7 to consider the aforesaid representation of the petitioner while considering any application if filed by respond number 9 and 10, the petition stands disposed. And they'll consider that, they have to consider their objections also.
58.
Until grant of such permission by respond number 7, respond number 9 and 10 are restrained from putting up any construction or carrying out any construction in subject property. You get the permission from them and do it. You have got only NOC. NOC is saying no objection, not permission.
Hmm. 58. Varalakshmi P.
Any objections to IA 1 of 25? Who are responding? Deferred for now. Yes, madam, what is this matter about?
This is a complaint against the notary, my lordship.
Investigate the entries made by respond number 4.
Yes, my.
Then notice has to go to them.
It has been dispensed with.
Deferred for now, Antide.
Yes.
Because notarial entry in the book of respond number 4.
Yes.
He has
Yes,
to be heard. Issue notice to respond number 3 and 4, returnable by 17th August.
59.
This case, my lordship, the petitioner was grade 1 contractor. He entrusted the work for the construction of lift irrigation project at Anandpura village. And some additional work has been done by the petitioner. That was completed in the year 2021.
Payment has not been made.
Payment has not been made. Similar writ petition was filed. I produced along with the additional document.
What is annexure Q?
Annexure K, my lordship. Annexure K is the estimation for the addition.
What is
Annexure Q is the earlier writ petition was filed. Thereafter, an
Girish, what is annexure Q?
Q, my lordship. That is in letter addressed by the executive engineer to the petitioner, wherein it is stating that 146, my lordship. Stating that the representation cannot be considered at this stage.
So there's no mandamus. You will have to consider.
Subsequently, there are several developments has been took place, my lordship. I produced along with the application has been filed to produce the additional documents, wherein kindly peruse the page number 26, my lordship.
The representation that you have submitted
Yes, my
has
lordship.
been rejected.
That is not been rejected. No. You have to sought approval from the competent authority, the government approval, and liberty. The contempt has been closed by reserving liberty to agitate the grievances, if any. Thereafter, the several developments has been taken place. Now I produce the documents along with the application, additional documents, wherein they have stated that entire exercise has been completed. Page number 26, may I kindly peruse for a moment.
The proposal is rejected.
Proposal is not rejected, my lordship.
In view of the rejection of the proposal by the government and view of the order of the High Court order to still pending.
Still pending for consideration of representation stated, so it's beyond the powers of this office. They have stated that it is not within the purview of that office. Subsequently, they have brought to your lordship knowledge with respect to the subsequent development.
What
my
is the
lordship.
subsequent development?
And the application may kindly peruse, my lordship, page number 26.
Application.
I produced some documents along with the IA. That is in page number 26. Page number 26, my lordship. Billu
Yes.
SB ಅವರ ದಿನಾಂಕ ಕೊನೆಯದಾಗ ಪಾಲಿಸಿ ಬಿಲ್ಲಿನ ಲೆಕ್ಕಾಚಾರ ತನಿಖೆಯನ್ನು ತಯಾರಿಸಿ ತಾಂತ್ರಿಕ ಮೌಲ್ಯ ನಿರ್ಣಯ ಸಮಿತಿಯಲ್ಲಿ ಮಂಡಿಸಿ ತಿರುವಳಿ ಪಡೆಯಲು ಮತ್ತು ನಿರ್ದೇಶನ ತರಿಸಿಕೊಡಲು ತಿಳಿಸಿದ್ದು, ಮುಂದಿನ ದಿನಗಳಲ್ಲಿ ಆದಷ್ಟು ಬೇಗ ಜರೂರಾಗಿ ಬಿಲ್ಲನ್ನು ಪಾವತಿಸಲು ಸೂಕ್ತ ಕ್ರಮಕ್ಕಾಗಿ ಮೇಲಾಧಿಕಾರಿಗಳಿಗೆ ಮನವಿ ಮಾಡಿಕೊಳ್ಳಲಾಗಿದೆ. ಈ ಮೂಲಕ ತಮ್ಮಲ್ಲಿ ತಿಳಿಸುವುದರಿಂದ ಸರ್ಕಾರದ ಅನುಮೋದನೆ ಆದೇಶ ಬಂದ ನಂತರ ಬಿಲ್ಲನ್ನು ಪಾವತಿಸಲು ಕ್ರಮ ವಹಿಸಲಾಗುವುದು. There is no dispute with regard to the entrustment of the work and completion of the work.
So we can't direct them to make payment. You'll have to go under the contract, file recovery.
Similar
They are
petition.
denying all these.
The similar petition has been filed, my lordship. Similar petition has been filed. Kindly peruse the page number 27, my lordship.
Yes.
For the same village, for the same project, he has done another work, wherein the direction has been issued by the Supreme Court to consider the petitioner representative to pay the additional bill along with the interest, which is effect from 21/7/2021. This is pertaining to the Irakoplu village, and the earlier order was pertaining to the Mailahalli village, my lords, for the same project. And also in the today there is a memo, idon memo dalli ide samidra. Kindly peruse the memo, my lords.
So consider the representation ಅಷ್ಟೇ.
ಮೆಮೋದಲ್ಲಿ ಅದ್ರಲ್ಲಿ ಹಣ ಬಿಡುಗಡೆ ಮಾಡಬೇಕೆಂದು ಕೋರಲಾಗಿದೆ. Now I place the memo on memo.
The order passed at page 34 is to consider your representation.
Along with the interest that.
Consider with that. What is the purpose? You lose your limitation. Please understand.
We are not receiving any amount since from 21 after the completion of the work.
Filing a writ petition doesn't help.
Now then thereafter.
We can't advise you, but see what.
And I place one document along with the memo. Kindly peruse for a moment, my lordship. I place the document along with the
same
memo.
order we are passing, Mr. Girish. We can't do more than that. The grievance of the petitioner is that the petitioner, having carried out the work of construction of lift irrigation scheme near Ananduru village to fill up water to tanks in Irapana Kokulu, Nagwada, Bommenhalli, Ailulu, Marathi Kyatanahalli, Dasana Koppulu and Lingamuddi village of Mysore Taluk, Mysore district. The petitioner has carried out the said works and raised his bills which have not been paid. In that background, that a representation had been submitted by the petitioner on 27/2025 at Annexure K, which has also not been acted upon by the respondent. Whenever any bills are raised by a contractor under any tender, any agreement, stroke contract, stroke work order, it is required for the employer to consider the same and pass necessary orders within a reasonable period of time, either accepting or rejecting the request made. In the present case, the representation was made on 27/2021, which apparently has not been considered till now. In that view of the matter, needless to say, order of rejection is passed, is to be accompanied by reasons. In that view of the matter, this court passes the following order. Writ petition is partly allowed. Respondents are directed to consider the representation submitted by the petitioner and pass necessary orders within 30 days of the receipt have a copy of this order. It's made clear that this court has not expressed any opinion on the entitlement of the petitioner. The same would have to be
Interest, my lord.
adjudicated on the basis of the contractual documents entered into between the parties.
Within this, within the stipulated time,
30 days,
along with interest, my lord.
as per contractual documents.
Serial number 60, Shiv Kumar.
Mr. Shivkumar, IA 1 of 26, you don't have a copy.
We are appearing on VC, my lordship.
You're not served IA 1 of 26 on Mr. Noor
It is,
Mohammed.
we have served it to everyone, my lordship. In fact, PF has been filed. It was filed on the same day.
IA 1 of 26. You filed an
IA
application.
Okay, my lordship. That will check, my lordship.
Counsel for the petitioner undertakes to furnish copy of IA 1 of 26 on counsel for you are appearing for respondent number 1 to 3, madam.
My lord, we will file wakalat for respondents 1 to 3, my lord.
Have you received the copy of IA 1?
We have not received the copy of I-1.
Counsel for the petitioner undertakes to furnish copy of IA 1 of 26 on each of the counsel for respondent by end of day 17th. Objections, if any, by 30th, relist on 6th August.
Obliged, my lordship.
You have already been suspended now.
Suspended by the governor. That has been called in question separately, my lord.
Correct.
In that matter, my lord, the issue is this, my lord. Only after reference by the president for the inquiry under 317 clause 1, the governor has power under 317 clause 2 to suspend. Now, without there being a reference, the suspension has been
You are
passed.
the president.
I'm the president of the.
Without your reference, it can't be
No,
done.
no, no, not
so nothing
president.
can be done.
His Excellency, President.
President of India.
Yes, President of India. That is what 317. It's squarely covered by the judgment of the division bench of this honorable court, where this honorable court clearly held that unless there is a reference by His Excellency or Her Excellency, there cannot be any suspension order by the governor.
That is challenged by you. That's a different.
That's a different matter. That is end of the list matter. In this matter, my lord, the KPSC members, my lord, resolved seeking my resignation, and my lord, they have also appointed one person as in charge. That has been stayed by this honorable court. And your lordship, while staying,
We have filed.
that observed, my lord, and our prayer was also, my lord, in respect of additional agenda 1.
Mr. Rubin mentioned the matter only for one.
Look,
Is
sir.
that the stay has to be restricted to only that particular
Additional agenda and the communications
But now,
on
my lords,
the basis of agenda.
the submission is
additional.
this petition, my lords, has become infructuous because the consequential action in terms of the Functions Act has been taken. If my lords may see what.
No.
No,
No.
I'll just point out, my lords. I'll just point out once. Lords, kindly
Can't
take.
be, because there is a recommendation on the basis of these
Let him
additional.
make his
Yes,
submission.
my lord.
Lords, page number 30.
They're presuming his submissions.
No, not.
Lords, page number 28, my lords.
28.
Please. This was the meeting notice, my lords, of dated 17/6 regarding a meeting to be held on 19/6/2026. Kindly see page 29, my lords. Next page. Agenda number 4, my lords.
Yes.
ಕೈಗಾರಿಕಾ ಮತ್ತು ವಾಣಿಜ್ಯ ಇಲಾಖೆಯಲ್ಲಿ ಕೈಗಾರಿಕಾ ವಿಸ್ತೀರ್ಣ ಅಧಿಕಾರಿ 50 ಹುದ್ದೆಗಳು ನೇಮಕಾತಿ ಸಂಬಂಧಿಸಿದಂತೆ ಅಭ್ಯರ್ಥಿಯಾದ ಶ್ರೀ ಸುಮಾ ಸಾಹುಕಾರ್ ಇವರ 3B ಮೀಸಲಾತಿಯ ಬಗ್ಗೆ. This is in respect of his the chairman's daughter.
Item number 4.
Item number 4.
It was part of the agenda.
It was part of the agenda.
Yes.
Now see 14 minutes kindly. ಮಾನ್ಯ ಅಧ್ಯಕ್ಷರ ಆದೇಶದ ಮೇರೆಗೆ ಇತರ ವಿಷಯಗಳು.
Yes.
So with the permission of the chair, my lords, other items can be taken. Page 30, my lords. Next page.
Yes.
So noticing, my lords, agenda number 4 on 19/6/2026, the chairman, my lords, recuses from the meeting, and he says, my lords, last but 3 lines. ಈ ದಿನದ ಸಭೆ ಮಾನ್ಯ ಮೊದಲನೇ ಸದಸ್ಯರ ನೇತೃತ್ವದಲ್ಲಿ ನಡೆಸಬಹುದಾಗಿದೆ. ಈ ದಿನದ ಸಭೆಯ ಅಜೆಂಡಾದ ಎಲ್ಲಾ ವಿಷಯಗಳ ಬಗ್ಗೆ ನನ್ನ ಅನುಪಸ್ಥಿತಿಯಲ್ಲಿ ಸಭೆಯ ಸೂಕ್ತ ನಿರ್ಣಯಗಳನ್ನು ತೆಗೆದುಕೊಳ್ಳಬಹುದಾಗಿರುತ್ತದೆ ಎಂದು ಈ ಮೂಲಕ
Not only
ತಿಳಿಸಿದೆ.
for item number 4, for everything.
For everything, including item number 4.
Yes.
1 to 13.
Now, my lords, in respect of item number 4, my lords, the decision, my lords, it starts at item number 4, agenda discussion is at page number
86.
86, my lords. It starts at 86. I'm sorry, my lords, 86 is a decision with regard to agenda item number 4. Notes 86 Nirnaya anta ide, top of the page.
Yes.
Notes the discussion actually starts at page number 73, 75.
75.
75, the agenda starts.
Church 78 ante.
Please, my lords,
75 is the
75
agenda
Vishaya
item.
4. Then, my lords, it is the discussion till page 86. Then page 86, my lords, is the decision.
What is the decision?
Notes it says, my lords, have the top of the page, my lords.
Yes.
ನಿರ್ಣಯ 3B ಮೀಸಲಾತಿಯನ್ನು ತಿರಸ್ಕರಿಸಲು ನಿರ್ಣಯಿಸಲಾಯಿತು. ಕರ್ನಾಟಕ ನಾಗರಿಕ ಸೇವಾ ಸಾಮಾನ್ಯ ನೌಕರ ಭರ್ತಿ ನಿಯಮಗಳು 1977 ನಿಯಮ 20 ರಡಿ ಸದರಿ ಅಭ್ಯರ್ಥಿತ್ವವನ್ನು ರದ್ದುಪಡಿಸಲು ನಿರ್ಣಯಿಸಲಾಯಿತು. ಕರ್ನಾಟಕ ನಾಗರಿಕ ಸೇವಾ ಸಾಮಾನ್ಯ ನೌಕರ ಭರ್ತಿ ನಿಯಮ 20 ರಡಿ ಸದರಿ ಅಭ್ಯರ್ಥಿಯು ಸೋ ಅಂಡ್ ಸೋ ಆಯೋಗದಿಂದ ಕರೆಯಲಾಗುವ ಯಾವುದೇ ನೇಮಕಾತಿಗಳಿಗೂ ಶಾಶ್ವತವಾಗಿ ಸೋ ಅಂಡ್ ಸೋ ನಿರ್ಣಯಿಸಲಾಯಿತು. 4. ಸದರಿ ಅಭ್ಯರ್ಥಿಯು ಮತ್ತು ಅವರಿಗೆ ಸುಳ್ಳು ಜಾತಿ ಆದಾಯ ಪ್ರಮಾಣ ಪತ್ರವನ್ನು ಪಡೆಯಲು ಸಹಕರಿಸಿರುವ ವಿರುದ್ಧ ಕರ್ನಾಟಕ ನಾಗರಿಕ ಸೇವಾ ಸಾಮಾನ್ಯ ಸೋ ಅಂಡ್ ಸೋ ನಿಯಮ 20 ರಡಿಯಲ್ಲಿ ಕ್ರಿಮಿನಲ್ ಮೊಕದ್ದಮೆಯನ್ನು ದಾಖಲಿಸಲು ನಿರ್ಣಯಿಸಲಾಯಿತು. ಸದರಿ ಅಭ್ಯರ್ಥಿಯಾದ ಕುಮಾರಿ ಸುಮಾ ಸೋ ಅಂಡ್ ಸೋ ಇವರು ಅಭ್ಯರ್ಥಿತ್ವವನ್ನು ರದ್ದುಗೊಳಿಸಿರುವುದರಿಂದ ಇವರನ್ನು ಹೊರತುಪಡಿಸಿ ಉಳಿಕೆ ನೇಮಕಾತಿ ಪ್ರಕ್ರಿಯೆಯನ್ನು ಮುಂದುವರಿಸಲು ನಿರ್ಣಯಿಸಲಾಯಿತು. ಹಿಂದಿನ ಸಭೆಯ ನಡವಳಿಕೆಯನ್ನು ಕಾಯ್ದಿರಿಸಿ ಆಯೋಗದ ಕಾರ್ಯದರ್ಶಿಯವರು ಮೇಲಿನ ನಿರ್ಣಯಗಳ ಬಗ್ಗೆ ಮುಂದಿನ ಕ್ರಮಗಳನ್ನು ತೆಗೆದುಕೊಳ್ಳಲು ಅಧಿಕಾರವನ್ನು ನೀಡಲು ನಿರ್ಣಯಿಸಲಾಯಿತು.
Yes.
So, my lords, there was a direction even to lodge an FIR as against her. Now, my lords, since the issue was connected, with the permission of the chair, the additional agenda item number at 87. ಹೆಚ್ಚುವರಿ ವಿಷಯ 1. 87 middle of the page. ಹೆಚ್ಚುವರಿ ವಿಷಯ with regard to, my lords, the role of the chairman, that is the
Yes.
agenda item number 4 in respect of the candidate. Now, my lords, in view of the fact, my lords, that she is the chairman's daughter, agenda item number, additional agenda item number 1 is in respect of the role of the chairman. After discussion, my lords, kindly see the Nirnaya is at page 93.
Yes.
ಸದರಿ ವಿಷಯದ ಕುರಿತು ಆಯೋಗದ ಸಭೆಯಲ್ಲಿ ಕೂಲಂಕುಷವಾಗಿ ಚರ್ಚಿಸಿ ಈ ಕೆಳಕಂಡ ನಿರ್ಣಯಗಳನ್ನು ತೆಗೆದುಕೊಳ್ಳಲಾಗಿದೆ. ಈ ವಿಷಯವು ಗಂಭೀರವಾಗಿರುವುದರಿಂದ ಸರ್ಕಾರದ ಅವಗಾಹನಕ್ಕೆ ತರುವುದು ಸೂಕ್ತವಾಗಿರುವುದೆಂದು ಭಾವಿಸಿ ಮಾನ್ಯ ಕಾರ್ಯದರ್ಶಿ ಅವರು ಈ ಕುರಿತಂತೆ ಸರ್ಕಾರಕ್ಕೆ ಒಂದು ವಿವರವಾದ ವರದಿಯನ್ನು ತಕ್ಷಣವೇ ನೀಡಬೇಕೆಂದು ನಿರ್ಣಯಿಸಲಾಯಿತು. That is 1. Only to send a report to the state government. 2. ಇಂದಿನ ವಿಷಯ ಸಂಖ್ಯೆ 4ರಲ್ಲಿ ಕುಮಾರಿ ಸೋ ಅಂಡ್ ಸೋ ಕೈಗಾರಿಕೆ ವಿಸ್ತೀರ್ಣ ಅಧಿಕಾರಿ ಹುದ್ದೆ ನೇಮಕಾತಿ ಸಂಬಂಧಿಸಿದಂತೆ 1:3 ಅನುಪಾತದಲ್ಲಿ ಮೂಲ ದಾಖಲಾತಿ ಪರಿಶೀಲನೆ ಆಯ್ಕೆಯಾಗಿದ್ದು, ಇವರು ಶ್ರೀ ಸೋ ಅಂಡ್ ಸೋ ಮಾನ್ಯ ಅಧ್ಯಕ್ಷರ ಕರ್ನಾಟಕ ಲೋಕಸೇವಾಗಿ ಇವರ ಮಗಳಾಗಿದ್ದು, ಈ ವಿಷಯವನ್ನು ಮಾನ್ಯ ಅಧ್ಯಕ್ಷರೇ ಸ್ವತಃ ದಿನಾಂಕ 19/6/2026 ತಮ್ಮ ಟಿಪ್ಪಣಿಯಲ್ಲಿ ಒಪ್ಪಿಕೊಂಡಿರುವುದರಿಂದ ಹಾಗೂ ಮಾನ್ಯ ಅಧ್ಯಕ್ಷರು ತಮ್ಮ ಅಧಿಕಾರವನ್ನು ದುರುಪಯೋಗಪಡಿಸಿಕೊಂಡು ಕುಮಾರಿ ಸುಮಾ ಎಸ್ ಸಾವುಕಾರ್ ಇವರ ಸಲ್ಲಿಸಿರುವ ಜಾತಿ ಆದಾಯ ಪ್ರಮಾಣ ಪತ್ರದಲ್ಲಿ ಸುಳ್ಳು ಆದಾಯವನ್ನು ನಮೂದಿಸಲು ಸಹಕರಿಸುವುದು ಮೇಲ್ನೋಟಕ್ಕೆ ಕಂಡು ಬಂದಿರುವುದರಿಂದ ಆಯೋಗದ ಘನತೆಯನ್ನು ಕಾಪಾಡುವ ಉದ್ದೇಶದಿಂದ ಹಾಗೂ ಈ ಸಂಬಂಧ ಮುಂದೆ ಒಂದು ಇಂಪಾರ್ಷಿಯಲ್ ಎಂಕ್ವೈರಿ ಆಗಬೇಕಾಗಿರುವುದರಿಂದ ಆಯೋಗದ ಮಾನ್ಯ ಅಧ್ಯಕ್ಷರಾದ ಶ್ರೀ ಸೋ ಅಂಡ್ ಸೋ ಇವರು ತಕ್ಷಣವೇ ನೈತಿಕ ಹೊಣೆ ಹೊತ್ತು ಆಯೋಗದ ಅಧ್ಯಕ್ಷರ ಹುದ್ದೆಗೆ ರಾಜೀನಾಮೆ ನೀಡಬೇಕೆಂದು ನಿರ್ಣಯಿಸಲಾಯಿತು. Then 3 minutes. ಆಯೋಗದ ಕಾರ್ಯಗಳು ಯಾವುದೇ ಅಡೆತಡೆ ಇಲ್ಲದೆ ಸಾಗುವ ಸಲುವಾಗಿ ಆಯೋಗದ ಮೊದಲನೇ ಹಿರಿಯ ಸದಸ್ಯರು ನೇತೃತ್ವದಲ್ಲಿ ನೇಮಕಾತಿ ಪ್ರಕ್ರಿಯೆಗಳನ್ನು ನಡೆಸಲು ಸರ್ವಮತದಿಂದ ನಿರ್ಣಯಿಸಲಾಯಿತು. Now, lords, these are the decisions. Now, in so far as 2 and 3, now this was placed before the chairman in terms of the act, section 7 of the act. Now he writes a tippani at page 95. 95 is his tippani. Lords, in his absence, whatever proceedings happens, I'll point out the provisions of the act. We have to place it before the chairman.
KPSC Act.
Let's, I'll just pass it on. Let's
amendment is
let's at 95 This is placed before him. He writes a tippani. Now kindly see, my lords, last two paras at page 98.
Yes. Yes, please.
ಮುಂದುವರೆದು ಸದರಿ ಸಭೆ ಹೆಚ್ಚುವರಿ ವಿಷಯ ಸಂಖ್ಯೆ 1 ನಿರ್ಣಯದಂತೆ ಮುಂದಿನ ಕ್ರಮಕ್ಕೆ ಮುಂದಾಗುವುದು ಭಾರತ ಸಂವಿಧಾನದ 371 ಅನುಚ್ಛೇದ ಉಲ್ಲಂಘನೆಯಾಗುತ್ತದೆ ಎಂಬುದನ್ನು ಗಮನದಲ್ಲಿಟ್ಟುಕೊಂಡು ಸೂಚಿಸುತ್ತೇನೆ. ಅಲ್ಲದೆ ದಿನಾಂಕ 19/6/2026 ಸಭೆಯ ನಡವಳಿಕೆಗಳಲ್ಲಿ ವಿಷಯ ಸಂಖ್ಯೆ 4 ಅನ್ನು ತಿದ್ದುಪಡಿ ಮಾಡಿದ್ದು ಹೆಚ್ಚುವರಿ ವಿಷಯ ಸಂಖ್ಯೆ so and so ತಿರಸ್ಕರಿಸಿದ್ದೇನೆ. He says I have rejected it. ಅದರಂತೆ ನಡವಳಿಯನ್ನು ತಿದ್ದುಪಡಿ ಮಾಡಿ ಮರುಪರಿಶೀಲನೆಗೆ ಹಾಗೂ ಸ್ಥಿರೀಕರಣಕ್ಕಾಗಿ ಆಯೋಗದ ಮುಂದಿನ ಸಭೆಗೆ ಮಂಡಿಸುವಂತೆ ಸೂಚಿಸಿದೆ.
Section 7.
Please, my lords. Kindly see section 7, my lords, of the Act, of the Functions Act.
Yes.
Procedure during absence of chairman. If the chairman is unable to be present at a meeting of the commission, the senior most member present shall act on his behalf, provided that the chairman shall be informed of such decisions arrived at in such a meeting in respect of any case which he may specify. If on being so informed is of the opinion that any such decision should be reconsidered at a meeting of the commission at which he is present, such decision shall be reconsidered accordingly, and until such reconsideration, no action shall be taken on such decision. Now, my lords, what happens is this: in respect of agenda item number 1 to 13, he says, I am recusing. Whatever decision you take, it is fine with me. That is what he says. So therefore, he did not specify that any item has to be brought to my notice. But additional agenda item number 1 was not in the agenda at the time of recusal. So therefore, my lords, it was brought to his notice. There are 3 resolutions that were passed. One is to send a report to the government. That is what the secretary has done. She has just stated this is what has happened. In respect of 2 and 3, she says that further action has to be taken in terms of this act and article 371J. That I'll point out the communication of the secretary. And insofar as it is a call for resignation, maybe the way it is worded, my lords, I can ask somebody to, resignation is a voluntary act.
Resignation is different, but then to say that we are resolving that.
My lords, at the, we are resolving that he should resign.
Can't do that.
We should have said, my lords, we should have said that we should request him to resign, because any citizen, my lords, can.
You are entitled to pass another resolution.
No, my lords, what he does is, no, the consequence is this: he has seen this resolution. He says, I'm rejecting your request. He has rejected it. Now, afterwards, my lords, we had to place it, my lords, before the next meeting. Now, my lords, along with the statement of along with the vacating stay application, this was part of the agenda for the next meeting.
Yes.
Now that was supposed to be held today. In view of the interim order that was granted, my lords, we deferred it. In the meantime, my lords, he has been suspended, my lords, under 317 of the Constitution.
As when you mentioned it, as
Please.
you said, the interim order is the entire resolution.
Interim order is entire resolution is stayed.
It is as if 1 to 13 is also covered.
1 to 13 is covered, my lords.
We'll restrict it to only additional item.
Please, my lords.
Additional agenda.
Please.
When you are ready, we'll take up for hearing and we can consider it.
Please, but additional item, we have just asked him to resign. It won't, the operation of the
That's
interim.
left up to you.
Please, my lords. My lords, or may I request, my lords, one indulgence also. Interim order may, my lords, interim order may continue, but the action in terms of the proviso.
Lordship also, my lord, clarified in the last part of the
My lords,
order.
his annexure F is for the entire proceedings.
We'll be clear on it.
Please,
because you wanted clarity on it.
Please. No, I understand,
So,
lords. I mentioned it in that.
Again, we also don't want interpretation from both the sides.
Please,
on that.
let's with one indulgence that we had actually called for a meeting insofar as for the purpose. Insofar as the stay is concerned regarding additional agenda item number 1 is fine, my lords. But if in the further meeting that gets modified, my lords, that liberty should be there, my lords. Otherwise, I can't even
That
touch
will
that.
observe. That will
Please,
observe.
Great.
Only this item is stay.
Please.
We can't come in the way of your holding any other meeting for any other purpose.
So, my lords, even this agenda, if in the subsequent, usually what happens in the next meeting, it has to be ratified. Ratification, it was there today, it has been postponed because of the stay. We will take it up in the ratification, and if it has to be modified, it will be modified. It will have request for, so.
Honorable Governor and also the state government reporting that it is a misconduct. That is the problem. That is why the other annexures are stayed.
They are entitled to write.
Not 1 to 13, your lordship may restrict it, but so far as additional agenda is concerned, it was not at all there in the agenda. And now even the consequence, not our issue.
I'm saying let the interim stay continue, but with liberty to take
If
action.
it is so, rule, section 7.
They don't have such power at all. So far as additional agenda.
What Mr. Ruben is saying is it is only a request, not a resolution.
No, my lord.
We-
It is not.
We'll record his submission.
Last portion, they appoint somebody, which is without their jurisdiction. My lord, kindly see the item 3 in that resolution at page 94. ಆಯೋಗದ ಕಾರ್ಯಗಳು ಯಾವುದೇ ಅಡೆತಡೆ ಇಲ್ಲದೆ ಸುಗಮವಾಗಿ ಸಾಗಲು ಆಯೋಗದ ಮೊದಲನೇ ಹಿರಿಯ ಸದಸ್ಯರ ನೇತೃತ್ವದ ನೇಮಕಾತಿ ಪ್ರಕ್ರಿಯೆಯನ್ನು ನಡೆಸಲು ಸರ್ವಾನುಮತದಿಂದ ತೀರ್ಮಾನಿಸಲಾಗಿದೆ.
No, they can't, it has to be the governor, my lords, who actually appoints. So that resolution also, insofar as that is concerned, I concede, my lords.
Even writing this additional agenda to the governor or the chief secretary, that will have, my lord, the bearing on my case.
Lords, I
There
understand.
is no inquiry conducted, there is no hearing, nothing.
So we'll stay the additional item number 1.
Yes, my lord, that may be.
Restrict the stay,
and the
or
other
rather
communications
restrict the
also.
stay only to additional item number 1.
Additional agenda, not that may be. And other two communications.
While order dated 10/7/26, this court had stayed the operation of the resolution dated 19/6/26 at Annexure F and the communication dated 6/7/26 and 7/7/26 at Annexure A and B on the ground that no resolution could have been passed for removal of the chairperson of the KPSC. The resolution in effect contains 13 agenda items, and the additional agenda item deals with the resolution for resignation, calling up on the resolution of the chairman. Insofar as item number 1 to 13 are concerned, the petitioner having recused himself from the said meeting and having directed that the meeting can go on to consider those items.
My lord, only one submission. So far as item 4 is concerned, I have, my lord, made one observation that unless opportunity of hearing is granted
To
the
whom?
candidate, any candidate for that matter, my lord, that is why one
That is for
dissent notice.
that is for the candidate to take action,
Yes, my lord.
not for you.
Lord, what happened is, my lord,
You're
now without
creating
hearing,
more problem for yourself.
I have not resolved to take all actions. So hearing should have been given, opportunity should have been given. That's what, my lord,
That is a ground
made
available to the aggrieved party, not for you.
but my observation is there, my lord, in that. So far as item agenda 4 is concerned.
You could not have said that once you have having stated that the meeting could consider all the agenda items. The stay of the resolution dated 19/6/26 shall only be applicable to the additional item and not to the agenda item number 1 to 13. The said stay order is restricted as such.
1 to 13, my lord.
1 to 13. Agenda items 1 to 13.
That's one observation regarding
In
that we could consider it, my lords, for the new next meeting for ratification, and if modification also is permissible. If we modify it, it's infructuous.
That is always there in the ratification.
No, but because it's stayed, I cannot consider for ratification. That is what I had called for the next meeting.
Additional agenda, my lord, your lordship may hear and my lord then decide. Everything, so far as additional agenda is concerned.
He has rejected it.
Absolutely, they don't have power.
Correct, but even if you look at the proviso,
Please, my lords.
that does not permit you to go ahead with the additional item without informing.
Please,
If
therefore,
you- Once you are informed, should be reconsidered at a meeting. of the
It could be reconsidered. So reconsideration, if you
You
reconsider
yourself have given your tipney at Annexure G that it has to be placed before the next meeting.
meetings, so
It will have to be
we
placed
might
before
even
the
modify it, my lords, and then petition is infructuous.
Behind back. So, my lord,
Your annexure,
jurisdiction per se.
please see annexure G at page 98, 98, 98.
98.
ಮುಂದುವರೆದು
No, my lord, now there is a consequential, my lord, subsequently,
Next.
His Excellency Governor has suspended me. That is separate writ petition, my lord.
correct, that will be considered separately.
Therefore,
But
my lord,
insofar
I cannot
as
participate unless it is considered.
ಹೆಚ್ಚುವರಿ ವಿಷಯ ಸಂಖ್ಯೆ 1 ತಿರಸ್ಕರಿಸಿದ್ದೀನಿ ಅದರಿಂದ
ಒಟ್ಟಿಗೆ your lordship may decide, my lord. So far as
ಅದರಂತೆ ನಡವಳಿಕೆಯನ್ನು
additional agenda one
ತಿದ್ದುಪಡಿ
is
ಮಾಡಿ
this is your
ಮರುಪರಿಶೀಲಿಸಿ we want to do this
Yeah,
one.
At that point of time, I was the chairman. Now, His Excellency Governor has
Can
suspended.
you change your submission just because you are no longer the chairman? We'll consider that separately. That's a different issue. But here you asked it to be placed.
But what happens is, my lord, if I am not there, in my absence, it will be, my lord, again, they will ratify it. And my lord, I may have to again challenge it, my lord, or my lord,
If it's ratified, it's
That will
stayed.
give
If I
further
withdraw it, is
litigation.
what I'm saying. If I modify it and
Let
I
it
take,
be as it is,
that,
my
that
lord,
is
so
what,
far
my
as
lords,
additional
if,
agenda is concerned.
in terms of his rejection,
The
if we
recommendations
pass
are
in
not
a
there.
resolution that agenda is, we are not acting on that agenda, the petition becomes infructuous. That's what I'm saying.
Their
If
worry
yours-
is, my lord, regarding other aspects of
If your
the.
submission is that you are withdrawing the additional item, we'll record that
No, my
submission.
lords,
then
that
there
has to
won't
be
be
done
any-
in, that has to be done in the meeting, my lords. That has, because the secretary,
If your submission is in the meeting,
please, my
you're
lords.
going to withdraw that
No, my lords, it
resolution.
will be placed if it is modified. Otherwise, stay will continue, my lords. I cannot act on that. But I will place it on the next date of hearing so that the petition will become infructuous. If suppose they ratify it, then petition will have to will survive. That is what
Continue.
I'm saying. Unnecessarily court's time, my lords, insofar as adjudication of this issue is what I'm saying.
So let us see what you,
Please, my lords, please keep it open.
Therefore,
we'll see what resolution.
but if liberty is given, my lord, tomorrow, my lord, if my.
We'll stay the
Consider.
No, I
will
don't
not be
understand
there
my-
as a part of the.
effect of that resolution shall be subject to orders of this court. Giving effect to.
Please, my lords.
But my lord, that communication may be, that stay may not be continued. Because otherwise this communication will have other.
It is already lost.
It is there, my lords. Communication will continue. I'm not saying communication stay will continue.
It is all done. In fact, this resolution, if they withdraw it, it may help you.
No, my lord, that may not have consequence, but it is per se, my lord, illegal without jurisdiction.
In view of the request made by the petitioner himself, wide annexure G for placing the additional agenda item number 1 before the next meeting, the respondents are permitted to place the same before the next meeting in terms of section 7 of the Karnataka Public Service Commission Conduct of Business and Additional Functions Act 1959. It is however made clear that no effect to the resolution shall be given without the leave of this court.
Insofar as that agenda.
Additional item.
Additional, please. Grateful.
Insofar as any modification or ratification to additional item number 1.
Grateful.
So this you will file your objections depending on.
Depending on that, my lords. If otherwise it.
When is the meeting now?
My lords, meeting was scheduled today. It's been postponed without a date. It can be held tomorrow day after any time, my lords.
So relist on 23rd July?
Please, my lords.
23rd July.
Grateful, my lords.
IA 2 of 26 will be taken up along with the main.
My lords, one submission.
Yes.
That dispensation to, insofar as notice for 1 to 11, notice has gone, but KPAC is appearing all.
How can you appear for them?
No, I'm only appearing for KPAC.
Yes.
Respond number 12.
Yes.
Let the notice go, please. Grateful.
Awaiting service.
Awaiting. Grateful.
Can we also permitted and summons, alva?
And summons court.
Only notice has been.
Let's see what the resolution is.
Grateful.
End of the list.
B. Siddheshwara.
Agreed by annexure A and A1, my lord. Notice is issued by CCB without registration of a crime, my lord. And before my lords, my lord. Page number 37 and 38. Notices, my lord. Well, my lord, they say there is a financial transaction between me and the complainant. Meanwhile, my lord, complainant had filed 138A proceedings, which is pending. The cognizance has not yet been taken, my lord. Before that, my lord, CCB issues this notice, my lord. I even went to the investigation, my lord, but now the difficulty is.
Where is the complaint?
Lord, 70, page number 70 is the PCR complaint, my lord.
Page number?
70, my lord, annexure E.
70.
Yes, my lord. Cognizance is not yet taken, my lord. PCR is pending for consideration. My threat is, my lord, they are trying to settle the matter, my lord, CCB. I don't know why.
Yes. Then we'll have to stay this annexure A and A1. And AGA accepts notice for respond number 1 to 3. Notice to respond number 4 is deferred for now. The operation of annexure A and A1 he stayed till the next date of hearing, considering that the complaint which has been filed by respondent number 4 is as regards certain monetary transaction and does not ex facie appear to be a criminal offence. Relist on 17th.
Please.
Serial number 2, Sri Rama.
Mr. Srirama?
For the petitioner in this case, my lord. This is regarding the demolition purpose, my lord, by the respondent PWD executive engineer without following the due process of law, my lord. They have directly come to the scheduled property of the petitioner and marked the portion, my lord.
You got the instructions, Jaffer?
My lord, I'll secure the instruction, my lord, in this, but they were just marked. They've not undertaken any demolition or what they
They
have said.
marked the
Not,
Don't carry out any
Yes, ma'am.
demolition unless,
without giving any notice.
if you have, without complying with law, without giving them
Yes,
notice. Whose land is this? They are claiming it's their land.
It's my land.
there's a widening of the road, my lord, there's a notification.
You have to
Place it on
acquire
record.
it.
Yes, sir.
Have you acquired?
No.
I'll place it on record, ma'am.
That
Lordship,
AG
can you have
accept
it tomorrow,
notice
my
for
lord?
respondent number 1 and 2. Relist tomorrow at 2:30 PM. Until then, respondents are restrained from carrying out any demolition in the property of the petitioner.
Grateful, my lord.
Dilip Kumar Gowda.
Appear for petitioner's counsel. Lord, in this matter, my lord,
They
the
gave it-
pursuant to this,
Oh, in Imdena.
yes, my lord, pursuant to this, my lord, His Excellency Governor, by order dated 10th, my lord, 10/7, suspended the petitioner.
Yes.
And my lord, he says in his report, in his that order itself, that he has recommended for inquiry, my lord, under 317. But 317(1)
Constitution code.
Constitution of India says, my lord, the President, His Excellency President, my lord, has the power to recommend for inquiry to the Supreme Court. 317 clause 1, subject to the provisions of the clause 3, chairman or any other members of the Public Service Commission shall only be removed from his office by order of the President on a ground of misbehavior after the Supreme Court, on reference being made to it by the President, has an inquiry held in accordance with the procedure prescribed in this behalf under Article 145, reported that the chairman or the other members, as the case may be, ought on any such ground be removed. Lord, there should be a reference, there should be an inquiry as contemplated, and there should be a report. On that report, President can remove. Now, subsection 2, my lord. President in case of a union commission or a joint commission, and the governor in case of the state commission may suspend from office of the respect of whom a reference has been made to the Supreme Court under subclause 1 until the President has passed the orders on receipt of report of the Supreme Court on such reference. Lord, condition President is reference and the report is awaited. Till then, my lord, the governor has got power to suspend. My lord, is squarely covered by the judgment of this honorable court, my lord. The division bench clearly held, my lord, that.
Is there a reference made to the Supreme Court?
No, in this case, not yet made any reference, my lord, according to our instruction.
The governor is.
Governor has made, my lord, the
You are
recommendation.
appearing
to
for first
President.
respond.
President has been sent.
You have sent the reference.
Yes, yes. In
That is-
fact, if I can give.
Now,
my lord, my
President
learned-
has to refer, my lord.
Just, my learned friend says, my lord, there's a division bench judgment. I'll rely upon, my lord, one judgment of the Supreme Court. Your lords may have a look at it. Ultimately, my lord.
Let us first get the facts straight before we
Oh,
get
sorry,
to
sorry,
the
sorry,
law.
sorry.
Ye-
My lord,
Now
what
the
has happened
governor
is,
is.
let me tell your lordship what has happened. Here is this, my lord, chairperson of the UPSC, KPSC. What he does is, his own daughter, my lord, appears.
That resolution Ruben read it.
Therefore, in the light of this, my lord, I as the governor, my lord, have suspended him. I have sent, my lord, the reference to the president, and my lord have suspended him.
Clause 2 of 317
Correct.
says, the president in the case of a union commissioner, a joint commissioner, and the governor in the case of a state commissioner may suspend from office the chairman.
Correct.
Or any other member of the commission in respect of whom a reference has been made to the Supreme Court under clause 1.
In respect of whom a reference is made under clause 1.
Under
Can I
clause
request-
1,
Clause 1 is, my lord, where
who makes the reference?
President, my lord.
president.
In both the cases, UPSC as well as KPSC or state.
So as the Honorable President made a reference to the Supreme Court.
No.
request will go from the governor.
Governor, my lord, I've sent it.
Because
So
it is
it
a
is in
state
the
commission.
process.
It is, yes, request has been made by the governor to the president, my lords, to make a reference.
So until a reference is made by the president, can you suspend?
It can be done. So it can be done.
It was the law.
My lord, can I persuade your lordship?
Kindly see
My lord,
the judgment.
2007, 11 SCC.
Code.
547. Almost identical circumstances where, my lord, again, chairman of the, my lord, UPSC, Maharashtra, my lord.
2007-11 SCC.
547.
They will
Please
consider.
come to, my lord,
Sanjeev
paragraph 2.
Paragraph
2.
Page number?
Page number, my lord, 7. Ali, mailgade, small letters, my lord, you have to
Yes.
get to the top.
Page.
My lord, internal page number 7, my lord.
Yes, please.
Para 2, my lord. The said respondent joined Maharashtra Public Service Commission as a member on 8/5. She was arrested on 8/6 in a crime registered in connection with the complaint lodged by the Public Service Commission relating to malpractice in respect of examination conducted in the year 1999. 21 others are also arrested. A respondent was lodged in the jail. This led to His Excellency the Governor of Maharashtra to request His Excellency the President of India to initiate action under 317 of the Constitution of India for her removal. He also suspended her from office until an order has been passed by the President under Clause 1 of Article 317 of the Constitution. It is seen that the respondent was subsequently released from on bail, though at least on 3 earlier occasions her prayers for bail were rejected. Since a request was made by the President of India to act in terms of 317(1) of the Constitution, placing of the respondent in suspension under 317(2) was proper. Considering the nature of the scam, etc., etc., my lord, what emerged? Then, my lord, in fact, identical circumstances. Please come to para 11.
Now, this is a fact. What is the finding?
This was, my lord, they did not, my lord, hold that, my lord, this suspension was bad. Please come to, my lord, para 11. I'll tell you, lordships, why. At, my lord, running page 11, charge number 3.
Yes.
Bottom, my lords, get that. Para 11, charge number 3. Whereas Ms. Joshi deliberately in a manified manner omitted to disclose a very vital fact to the commission, namely that her daughter was appearing for an examination being conducted by Public Service Commission, which disclosure was mandatory as per the office order number so and so of the MPSC, and hence sought to suppress vital and material information from the commission, which affects her integrity, complete devotion to duty in an impartial manner, amounting to misbehavior.
This is on the charges.
Please,
on the charges.
and this has been held to be proved. Please come to, my lord, page 152.
That is after
Para
inquiry.
152.
Mr. Ola, the question now is whether His Excellency the Governor could suspend the petitioner pending a
Judgment has
reference,
been considered.
pending a reference being made by Her Excellency the President to the Supreme Court of India.
Correct.
For inquiry to be conducted by Supreme Court. But here it happened, but that was not the issue. There's no finding on it. What was challenged is
That is a similar issue.
the
Honorable Court
final
considered,
order
my
was
lord, in the
challenged.
identical matter. ILR, my lord,
Only thing is, my lord,
2017.
Where their
Court of-
lordships, where their lordships.
The
hold.
same judgment has been considered, my lord.
Para
Your lordship
2,
may kindly come.
where they say it is proper.
Show us the judgment which says.
No, this
that-
has been, my learned friend, what has been cited, my lord, that has been observed in this, at, my lord, para 16.
Division mean judgment.
Yes.
Para 15 and 16, my lord, the same has been observed, my lord. Para 17 onwards, observation made in Supreme Court of India in case of Ram Kumar is clear and unambiguous that the power of the suspension under Article 17, 317 clause 2 can be exercised by the governor only after the president has referred the matter to the Supreme Court of India. Further, Article 317 clause 2 leaves us with no element of doubt that the governor can exercise such power only after reference is made by President of India to Supreme Court of India under Article 317(1). We can profitably refer to the decision of Supreme Court of India in matter of so and so, para 18, where the language of 317 is clear, unambiguous. Reading anything further into it would not be justified. In the instant case, it is an admitted fact that as a on so and so, when the governor of Karnataka issued the order of suspension under Article 317 clause 2, no reference to the Supreme Court of India has had been made by the president under Article 317(1). We are informed that even till date, no such reference has been made by president to Supreme Court of India. Then, my lord, we have considered the decision of honorable single judge, that is regarding, my lord, the single judge's observation, they agree. However,
Was
it is
set aside
equally.
by the division bench.
Yes, my lord. Next para, 20 is important. In the instant case, when the order of suspension was issued under Article 317 Clause 2 on so and so, the governor admittedly did not have the benefit of the aid and advice of the Council of Ministers under Article 163. Further, as on that date, no reference has been made by the President to the Supreme Court of India under Article 317 Clause 1. On these counts, we have no option but to hold that the order of suspension dated so and so unconstitutional. We therefore allow the appeal. Last, my lord, the appellant shall be entitled to officiate as the member of Karnataka Public Service Commission and shall entitled to all emoluments and consequential benefits.
Please come to my lord paragraph 15. I'll tell you lordship why. That was not considered by the division bench at all. And I'll point out my lord again. Learned additional comment advocate general has relied upon the decision of so and so, which 2007-11 SCC, in support of the proposition that once the governor has made a request to the president under 317, governor can proceed to suspend a member of the Public Service Commission under 317(2) without there actually being a reference to the president to the Honorable Supreme Court of India. The impugned order also proceeds on that ground. They, my lord, consider, now my lord, my learned friend read to your lordship para 17. Para 17 considers the other judgment, not this judgment. And this judgment, my lord, if your lordship come to paragraph 2 of what I've read, 2007-11 SCC. Specifically, my lord, it holds that, my lord, the order was in
It is not holding, it's only
please come to my
statement
lord.
of.
Can I persuade your lordship? Just have a look at.
Yes.
I may be wrong, but your lordship may be just my lord.
Please.
Please come to my lord para 2 at page 8.
Yes.
The respondent was, my lord, last 1, 2, 3, 4, 5, 6, 7 lines. Since the request was made to the President of India to act in Article 317(1) of the Constitution, placing of the respondent under suspension of 317(2) of the Constitution was proper. Considering the nature of the scam that emerged and the constitutional position enjoyed by the Public Service Commission, reference to this quote on 317(1) is seen to be proper, a step to be taken. Therefore, my lord, that was the finding of my lord.
Where are you reading this?
37, my lord, para 2.
Para 2, yes.
Otherly,
Since the
next
request was
page,
made to so and so.
next page, my lord.
Yes.
Next page, para 3 kinta. My lords may not
Since
go
the
up
request was made to the President of India to act in terms of 317 point, placing her under suspension of the Constitution was proper.
proper. Considering the nature of the scam that emerged, the constitutional position enjoyed by the Public Service Commission, reference the court under 317(1) is seen to be proper step to be taken. So, my lord, earlier sentence, suspension was proper. This, my lord, has not been considered. My lord, they refer to something else. And in that case, what has happened is, I must tell your lordships, para, my lord, please come to para 11. Same, my lord, the para 11 at, my lord, charge 3. Joshi, my lord, deliberately in a malafide manner omitted to disclose a very vital fact to the commission, namely that her daughter was appearing for an examination being conducted, which disclosure was mandatory as per the office order number so and so. Hence, sought to suppress the material information from the commission, which affects her integrity, complete devotion to duty, in an impartial manner, amounting to misbehavior under Article 317(1). Please come to 152. This, my lord, the Supreme Court have held charge 3 is proved. She was removed and, my lord, accepted.
Yes,
Last
that is
page, my
after
lord.
inquiry.
Correct.
It is after.
That's right. Removal, my lord, has to be only after inquiry.
Correct.
Suspension, my lord, in the light of, my lord, para 2. This is all, my lord, that I can say. Para 2, my lord, where the Supreme Court holds, suspension is in order.
This judgment in Ram Kumar,
Ram Kumar, my lord, is
9 SCC 378, SCC really.
Compilation leader, Swami. Can I give you a lot?
Yeah. Ram Kumar,
171.
171.
171 ಅದರಲ್ಲಿ ಇದು ಹಾಕಿಲ್ಲ ನಾನು. ಅವ್ರು ಸಾಹೇಬರಿಗೆ ಕೊಟ್ಟಿರೋದ್ರಲ್ಲಿ ಪೇಜ್ ನಂಬರ್ ಹಾಕಿದ್ದಾರೆ.
Yes, 170 ಇದೆ. Ram Kumar.
Yes.
That is regarding, my lord, entitlement of pre-reference hearing, my lord.
Para 12, show
Para
cause notice
17
ಕೊಡಬೇಕಾಗಿಲ್ಲ.
there is a
There, the argument was, my lord, show cause notice should have been issued.
Pre-reference hearing.
Para 17.
Correct.
The division bench has observed the observation of the Supreme Court of India in the case of Ram Kumar Kashyap is
Allah,
clear
17.
and unambiguous that the power of suspension can be exercised by the government only after the president has referred the matter to the Supreme Court of India. That is what they have observed. Which para would that be?
My lord, para.
No, in fact, that judgment does not say so, my lords. That judgment says that, but Ram Kumar does not hold so. Is a
That is why we keep telling, don't rely on passages, give us the original judgment. These passages are creating a lot of trouble.
that para 12 minutes is a relevant para in Ram Kumar.
It's clear from the perusal there. Show cause notice,
makes
their
it clear
argument was
that-
show cause notice ought to have been given before
Since
suspension.
Supreme
The
Court gives all opportunity, there is no precognizance opportunity is required, and only after reference only suspended. Therefore, it will not come in the way.
Therefore, my lord, 2007, 11 SCC, my lord, para 2, my lord, holds the field even today.
We are of the opinion that the en bloc suspension of the 8 members and the chairman of Haryana by the Honorable Governor of Haryana by an order dated 9/8/2008 under so and so of the Constitution and notification are valid and not liable to be quashed. In fact, the reverse.
Anyway,
What
this
is
requires
stated
some
in
more
the-
hearing.
Otherly para
My lord,
12
my lord, give us some time to file our objections, we'll file, because I've got the, my lord, only at afternoon, my lord, they gave us the
My lord, on
papers.
2 counts, my lord, whatever relied on division bench, my lord, we are entitled for, my lord, benefit, because, my lord,
The
there is
judgment
no
which has
aid
been-
and, my lord, assistance, my
The
lord.
judgment which has been referred to on para 17 is what you are relying on for that purpose. Your argument is based on para 17, but para 17 is not reflected in this judgment.
And not only that,
Para
para
12
11
is, my lord,
In
referred.
fact, it is contra.
Ram Kumar is concerned, my lord.
and para 11 minutes, para 2 of Sayali is referred to as a finding
Well,
in para 11.
my lord, justifies that only after reference, there is no need for pre-reference hearing, because Supreme Court considers each and everything. Therefore, that will operate only after the reference. That is how, my lord, it has been interpreted.
See para 11 minutes.
Para
Where is that reasoning for us to follow?
That's 11 in fact refers to Sayali. Para 2 is extracted as a finding. If my lords may see para 11
Was proper.
was proper. That is extracted, my lords, in a subsequent judgment as a finding.
We'll have it tomorrow, please come.
In para 11, my lord,
Please come. We understand your anxiety also, but we need to be clear on this because this is dealing with the power under Constitution and 317.
but in para 11 of this, para 16, it has been
You
relied.
place everything before us.
Sayali Joshi, my lord, member of Maharashtra Public Service Commission, which concerned the removal of a member of the Maharashtra Public Service Commission under Article 317 on the ground of misbehavior. This court has observed, since a request was made to President of India to act in terms of Article 317(1) of Constitution of India, the placing of respondent under suspension under Article 317 clause 2 of the Constitution was proper.
This is contrary to the finding, my lord.
That
of the
is why,
Supreme Court.
There was a reference, it was proper.
though we were with you on that till now, because that was only a statement of fact, but the way the Honorable Apex Court has considered it in the next matter is as if it is a binding precedent. And thereafter, the Honorable Supreme Court held that the placing of suspension, though of course after the reference, was valid and need not require any interference. This para 17 that you are relying on to be an extract or an interpretation of Ram Kashyap, we do not find in Ram Kashyap.
But the provision itself, my lord, Constitution speaks very clear.
If it
And,
was,
my lord,
if it was
just 2
another,
minutes for, my
if
lord,
it was
if you can-
another division bench or a single bench of this court, yes. When it is a Supreme Court judgment, it's different.
Yes, my lord. But the manner in which the order has been passed, Lord, there is no inquiry, there is no hearing, nothing. Complaints have been
required.
received and various news articles
That is very
have
clear.
been published.
That you may not have any ground at all. Your only ground
Correct, my lord.
appears to be whether before
But
this
the idea and
excellency.
object is, my lord, there should be due application of mind. My lord, which complaint, who has given
That
complaint?
is why we are having
what
it
is the
tomorrow.
complaint? Nothing.
Tomorrow itself. Rely on, place whatever judgments that you want to rely on. Make your arguments tomorrow. Tomorrow itself we'll consider it.
Till then, my lord, the impending order may be kept in
One day nothing will happen. One day nothing.
No,
will
let them not precipitate at least, my lord.
happen. Indian precipitate madbekappa.
It's been acted upon.
An absential meeting ಮಾಡೋದು.
Nobody can precipitate anything until
And that
the
submission may be
inquiry is
recorded,
done
my
by
lord.
the
In the
Supreme
meantime,
Court.
they will not.
I have got nothing to do with it, but I'm the prayer.
Yesterday, my lords,
Who will accept notice for respondent number 1? Shri
the
Mohammed
gov-
Shamil accepts.
No, my lord.
Two. Abhishek, my lord. Abhishek.
Abhishek?
For the, for
Kumar.
the, go-
Abhishek
Abhishek
Kumar
Kumar.
for
That's the first respondent. Governor.
respondent number 1.
Governor.
And what about for respondent number 2?
Mr. Shamil appears.
Mohammed Shamil accepts notice for respondent number 2. The issue in the present matter is relating to whether His Excellency the Governor of Karnataka could have suspended a chairperson of the Karnataka Public Service Commission before a reference was made by Her Excellency the President to the Honorable Supreme Court of India under clause 2 of Article 317.
Please.
Both the councils are, all the councils, there are 3, both. All the councils are requested to place on record any and all judgments that they rely upon
Yes.
in respect of the above. Relist tomorrow at.
Lord, can it be day after? By then, my lord, I'll file that.
Yes, his anxiety.
My lord, I'll be here. No difficulty.
And actually,
No question of
till
precipitation.
we read para 17, we are with Mr. Arun Sham. After reading para 17, saying it as a problem. So we'll consider it tomorrow.
Your lordship. Yes. Only thing is whether, my lord, we'll be able to give that objections, my lord, may not be. Only
Shamil
a
is
question.
there, Abhishek is there. He'll burn the midnight oil today.
Great.
We are not looking into any of those things, please. Don't expand the writ petition beyond that. Your only contention that we can look into is whether the power has been exercised in proper manner or not. We are not looking at your allegations, rightness, wrongness. All those things we are not looking into. That is for the Supreme Court to appoint an inquiry committee. We can't look into any of those things. Only the aspect of the power.
Please.
That you can make your submission.
Please.
Because the only reason why we can interfere is on the ground of lack of jurisdiction. Not by us, not before us. There's a council appearing for His Excellency now. A senior counsel is appearing for the Excellency, and we won't be asking for His Excellency to file an affidavit. That obviously not. We won't be doing, and we'll go by the submission made, not like that. Responsible officers of this one. E-office is being used by Karnataka government. You can be anywhere. You know that. Doesn't require to be in town. Normal, this one is that.
Mohammed Tahir.
Not top of the list, 230.
230.
All of you prepare and come properly.
Please. Grateful.
Mohammed Tahir.
Yes, Tahir. Only that restriction we have. Yes. Yes, Tahir. Reducing the externment period. What is the urgency to move it at the end of the list for this? You have to give them an opportunity to get instructions, not end of the list. Now, AGA accepts notice for respond number 1 to 4.
Page number 20, my lord.
You got instructions 20.
Opposite is given to them. Appear not. Last two paras.
They're asking for, no, they're not asking for that. They're asking for reducing the period of externment to the period already undergone. On that, you'll have to make the submission. Sorry? Huh. Copy paste. File an application for amendment. Now we'll have to. Amendment you have to file. Relist on 17th.
See Jagdish.
Yes, Mr. Jagdish. You have not served a copy on the GA.
They have served.
Yes, sir. Michael Matadi, ಕೇಳಿಸ್ತಾ ಇಲ್ಲ?
Annexure B may be kindly seen, my lord.
Annexure B.
B. For procurement of my lord, fire force.
Page number?
Page number 69, typed copy. The Home Minister has said that Make in India products should be purchased in all the fire force purchasing while fire forcing equipments. Lord, in pursuance of that earlier annexure C, the very same department, in page my lord 71, the relevant page would be my lord page 82. They have invited my lord tender of Indian manufactured equipments. That your lordship could find on the last para, my lord.
Yes.
The OMA must have been NFA, complaint manufacture facility for rescue tools in Indian manufacturing facilities. Similarly, my lord, annexure D in page 83, that your lordship could find at my lord page 93. Here also they said that Indian manufactured equipment.
Yes.
Now annexure A, contrary to that, they have invited tender. There is no mention regarding the equipment has to be purchased from the Indian manufactured companies.
Yes, madam.
Lord, if my lords may kindly see page 70. This is the advisory, my lord.
Page
70, my lord.
70.
70.
Yes.
This advisory, my lord, serves as a general guideline to assist state fire services. It is only a guideline, my lord, that they should give priority to Make in India.
You not even mentioned it, saying that priority will be given.
They are.
On earlier occasion, on 2 tenders, they have invited.
Earlier it was
following
mandatory. Now at least, even if your contention is it's a guideline.
Please, my lord.
And priority will be given. Your tender doesn't say that priority will be given to Make in India products.
I'll seek instructions also.
The reason. A clear advisory for that.
If my lords may kindly see their grounds, my lord, they are only say.
And the advisory is
Only
more or less
about the
binding
advisory they
because
say,
it
my
is
lord.
committed to fostering domestic innovation, manufacture of meat. And if there are Make in India products available, why should you get it from outside?
What would happen, my lord, if the equipment are purchased outside the
Standard
manufacturer
compliance
outside
in
India?
page 69
My lord,
also
the
may
cost
kindly be
base will be
perused, my
high.
lord.
Shipping rate
They
we have
say
to
while
pay.
choosing Indian made equipment, it is essential to ensure that these systems meet international safety and performance standards. Manufacturing must undergo third party certification to guarantee product quality.
Unless it is your case that this equipment is not manufactured in India.
It is not
It is
so.
unlikely so. It is unlikely. And AGA accepts notice for
Only one respondent.
Respondent. Considering that there is an advisory which had been issued. by the Ministry of Home Affairs in pursuance of the 15th Finance Commission grant in aid, advising that prioritization has to be made for procurement of Make in India firefighting equipment, state fire services, fire service equipment. There being no such clause in the tender now issued at Annexure A, the said tender is stayed till the next date of
May
hearing.
I seek instructions also, my lord?
We are staying it for now, so because financial bid is opening tomorrow is what I relist on 17th. If you want, you can make amendment. We don't need to tell
Please,
you
ma'am.
what you do that
I need fresh matter, my lord. I need to seek
in
instructions.
preliminary hearing.
Please,
Please,
ma'am.
ma'am.
Oblige.
One mention, my lord. My lord, may I make one mention? Morning, my colleague has moved a memo that he has filed an IA for seeking stay. My lordship has accepted that memo has not been gone to the section.
IA for?
IA challenging, my lord, the land acquired by a farmer MLA.
Pending matter or?
Not bidding matter. Pending matter.
Pending matter will come in seniority.
They have filed IA for seeking stay, my lord. What happened? Your lordship has stayed the second inquiry. Already there is an order passed by the my lord, the coordinate bench, where an inquiry was conducted with regard to the encroachment of 60 acres of land in Kolar. My lords have stayed it. Tave stay madidira. Subsequent inquiry has been. Now again a fresh inquiry has been passed, where the earlier order direction pursuance of the High Court order, my lord, coordinate bench, inquiry was concluded, and he has approached this honorable court. Status quo order is there.
Fresh inquiry matter.
Fresh inquiry has been
Based
passed.
on Adu told.
Tomorrow, lordships.
Tomorrow, now it can't be listed at 6 o'clock.
ಬೆಳಗ್ಗೆ ಮೂವ್ ಮಾಡಿದ್ರೆ ಮೆಮ್ಮ ತಗೊಂಡಿದ್ರೆ ತಾವು ಅದಕ್ಕೆ
Pending ಅಂತ ಹೇಳಿದ್ರೆ ಬೇಡ ಅಂತ ಹೇಳಿದ್ದು ಅದಕ್ಕೆ. ಇದು ಹೇಳ್ಬೇಕಾಗಿತ್ತು. 16th. ಆಪರ್ಚುನಿಟಿ ಸಿಗತ್ತೆ ನಿಮ್ಗೆ ಕರೆಕ್ಟ್ ಆಗಿ ಫ್ಯಾಕ್ಟ್ಸ್ ತಿಳ್ಕೊಂಡು ಹೇಳ್ಬೇಕು. ಸೀನಿಯರೇ ಬಂದು ಹೇಳೋದು ಬೇಡ. ಆಯ್ತೇನಮ್ಮ? Fast over. All matters will repeat.
Don't be trouble, my lords, now. 52, my lord, was passed over. If it can be added on Tuesday, my lord.
52, 21st.
Because the union, my lord.
My lords, I appeal for the
I will
respondent, my lord. That just
Yes.
seeks 2 weeks, my lord, because we need to say the instructions, my lords.
My lord,
My lord, this is an
I was
illegal
given
immigrant.
bail by the Allahabad High Court and now they put me in again, my lord.
My lords, what happens, my lords, he's already convicted in the same offences of the Foreigners Act. We need to just secure the instructions from there. My lords, we have come
We
in
already
the-
given you 2 weeks time. How long does it take?
My lords, fine, 2 weeks.
You asked for 2 weeks, we gave you 2 weeks. Can't be as, these are all
My lords, please.
liberty
Only for the
matters.
2
Liberty
please.
matters, we can't be giving you more time.
In fact,
Can
yesterday,
it
my lord,
be
the
on
Honorable
20?
Apex Court.
We'll give you 1 week's time, 21st. We'll have it. Your serial number?
21st.
My lords, can it be on
Serial number
22nd,
52,
my
please.
lords?
52 at the request of counsel for respondent, released on 21st.
Serial number 63, my lords. The bunch of matters regarding right to be forgotten, my lords. If it be
Summons is only not served on many of them. Service is not completed.
completed most of the matters, my lords.
Copy is not served.
Service is not completed in all of them.
I think it was posted for final hearing before my lords only on the earlier occasion.
Service is not complete. How
Date
can
may
it
be
go
fixed.
for final hearing?
I think the bunch of new matters, my lords, a date may be fixed, my
We'll
lords.
only say permitted serve by hand if you want.
Maybe
All of you,
petition may be
sir.
done.
60?
63, my lords.
63. Awaiting service of summons, respective counsels for the petitioners are also permitted to take out hand summons on the unserved respondents.
Interim orders need to be extended, my lords.
Released on 10th August.
The interim orders need to be extended.
Interim orders wherever granted are extended till next year.
Serial number 65.
65. 65 memo file madidira? Memo file dismissed as withdrawn.
My lord, serial number 64, my lord. Though notice is served, still it is coming in orders, my lord. It has to, interim order has to be considered, my lord.
64 interim order service agide.
There is no interim order, my lord. It is to be considered, my lord.
Enagide?
Notice everything is served, but it is coming in orders, my lord. There is no.
List kodi.
My lord, loan, I applied for loan, my lordship, but they have disbursed to some other account, my lordship, without instructions. They admit it, my lord. But coordinate bench one.
24.
Please, my lord. Interim order has to be considered.
Police report service of hand summons on 3 to 7.
Please, my lord, coordinate wanted to dispose of the matter itself, my lord, because this is a small issue was
Is the service completed?
completed, my lord.
Him.
It is completed, my lord.
3 is Kotak, Canara Bank. Respond number 7 is not served.
Refuse, my lord, that is been police, through police has been served, my lord. They refuse to accept it, my lord. That is what have been considered and taken as a sufficient, my lord.
When was it taken as sufficient?
My lord, it is because through hand it was given, my
When
lord.
was it taken as sufficient? Date of the order?
Long back, my lordship.
It's not been taken as sufficient. Reissuance.
Notice has been served, my lordship, because first it was served through hand, my lordship. We went to serve, they assaulted the advocate, my lordship. Then this honorable court directed the police to serve the notice, my lordship. And notice was served to police, my
This
lord.
report ಬಂದಿದೆಯಾ?
ಬಂದಿದೆ sir.
ಎಲ್ಲಿದೆ? His police report has been filed indicating service on respond number 7 on 7/3/2026 at 12:26. Hence service in respect of respond number 7 is held sufficient. There would be therefore no requirement. Since all the other responses have been served, there is no requirement for filing any acknowledgement. Relist on 21st in preliminary hearing.
Please, my lord.
But if I make a mention.
Yes.
63.18, it's a right to be forgotten matter. On the last date of hearing, the matter was not that. In fact, it was passed over for the court to consider because in my petition, service is complete and the limited relief is only with respect to masking the.
Now all of them are connected. Service has to be effected on all of them. Once they are effected, we can take it, not before that.
In passed over matter, my lord.
Lord,
The main matter, my lord, serial number 63. We filed a memo, my lords, dated 27/6 for having served the respondents through email.
Registry to verify, 63 ಅಲ್ಲಿ ಆಗ್ಲೇ ಹೇಳಿದ್ರಲ್ಲಿ. Registry to verify if service has been effected on all the respondents and file a report there too.
Serial number 63.20 from the petition.
Same.
May be dispensed with service of notice to respond number 12 and respond number 14.
How can it be dispensed with?
This Facebook and daily motion.
Yeah, they are the ones who are to remove the entries.
But the other respondents, we are not seeking relief against insofar as respond number 12 and 14 are concerned.
You don't want it to be removed from Facebook.
Facebook ಅದರಲ್ಲಿ ಒಂದು ಪರ್ಟಿಕ್ಯುಲರ್ ಅಕೌಂಟ್ ಮಾತ್ರ ಇದೆ ಸ್ವಾಮಿ. ಅವ್ರ ಯೂಸರಿಗೆ ಹೇಳಿದ್ರೆ ಆಗುತ್ತೆ.
ಆಮೇಲೆ ಅಲ್ಲಿ ಒಂದರಲ್ಲಿ ಜಾಗದ ಇದ್ರೆ ಮತ್ತೆ it will replicate. It has to be removed everywhere.
My lords, that judgment, my lords had asked.
Day after tomorrow.
Yes.
Serial number
Yeah,
7.
My lords,
on submission.
6.
6 in list 2.
And my lords, I got the.
on submission.
Just a moment, please.
Other judgment.
I apologize.
Whatever judgments, give it to them. Relist on 16th.
Serial number
My lord,
7.
17th. My lords, if possible, 17th. On 17th.
17th ಏನಮ್ಮ ಪಾಠ ಯಾವ್ದು ಇದೆಯಾ ಆಗತ್ತಾ 17th
Interim order maybe.
interim order earlier.
Serial number 70, please, my lord. There is a await service of notice to the private respondent. Any date may fix, my lord.
Await service pre-list on 17th August. Yes, on VC.
My lord, serial number 66, my lords. I was on by order dated 3/6, my lords. I was being directed to furnish bail orders, my lord. I have received all the bail orders on today, my lords. Kindly it may be had on day after tomorrow, my lords.
It's not going to be day after tomorrow. You should have filed it by now. Pre-list on 11th August.
My lords, at least on 22.
ಯಾವುದು ಸರ್ GM ಪಾಟೀಲ್ ಸರ್ ಯಾವುದು ಸೀರಿಯಲ್ ನಂಬರ್
66 ಮೇಡಮ್ ಅದು ಪರೋಲ್ ಮ್ಯಾಟರ್.
ಪೆರೋಲ್ ಎಲ್ಲ 22nd ತಗೋತಾರೆ ಈಗ ಬೇರೆ ಡೇಟ್ ಹೇಳಿದ್ರೆ
ಸರಿ ಸರಿ ಮೇಡಮ್. ಅಲ್ಲಲ್ಲ ನಾನು ಬೇಕಾದ್ರೆ 22nd ಗೆ ಹಾಕಿ ಮೇಡಮ್ ಕೊಡ್ತೀನಿ. ನಾನು ಪರೋಲ್ ಅಂತ ಹೇಳಿಲ್ಲ ಸಾಹೇಬ್ರಿಗೆ ದಯವಿಟ್ಟು.
ಪೆರೋಲಾ ಅಲ್ವಾ ಅದು?
ಪರೋಲ್ ಮೇಡಮ್ ಪರೋಲ್ ಮ್ಯಾಟರ್ ಪಿಟಿಷನ್ ತೆಗೆದು ನೋಡ್ಬೋದು ತಾವು. ಆ ಜನರಲ್ ಪರೋಲ್.
66 22nd. 63 ಡೇಟ್ ಕೊಟ್ರಲ್ಲ 7th August 10th August.
66 22 ಅಲ್ಲ ಮೇಡಮ್?
ಹಾ ಸರ್ 22nd ಗೆಲ್ಲ ಬರ್ತಾ ಇದೆ ನಿಮ್ದು ಅವತ್ತೇ ಬರುತ್ತೆ.
ಆಯ್ತು ಮೇಡಮ್, ಥ್ಯಾಂಕ್ ಯು.
ಯಾವಾಗ ಆಯ್ತದು? ಇವಾಗಿದ್ದು ಇವಾಗ ಆಗಿದ್ದಾ? ಇನ್ನು ಆರಿಸ್ಬೇಕು. ಅದೊಂದು ಫೈಲ್ ನಾವು ಇಟ್ಟಿದ್ದೀವಿ, ಎರಡೇನೋ ಇದೆ. ನಾಳೆಗಿದೆ ಇದು ಬರ್ದ್ಬಿಟ್ರಲ್ವಾ? ಅದು KTY ಡೇಟ್, ಅದು ಕೆಳಗಡೆ KTY ಡೇಟ್ ಕೆಳಗಡೆ ಅದನ್ನ ಅರ್ಜೆಂಟ್ ಕಳಿಸ್ಬೇಕು. ಸೀರಿಯಲ್ ನಂಬರ್ ಏನಪ್ಪ? ಹ್ಯಾಂಡ್ ಡೆಲಿವರಿ RES ಬ್ರಾಂಚು 482. ನಮ್ ಕೋರ್ಟ್ಗೆ ಯಾಕೆ ಬರ್ತೀರಾ? 482 ನಮ್ ಕೋರ್ಟ್ಗೆ ಯಾಕಪ್ಪ ಬರ್ತೀರಾ? ನಿಮ್ದಲ್ಲ, ಅವ್ರದ್ದು ಎರಡು. ನಾಳೆ ಅವ್ರದ್ದೆ, ನಿಮ್ದಿಲ್ಲ. ಇದೊಂದು ಕೆಪ್ಪಿಲೋ ಮಾಡಿಬಿಟ್ಟು PRS ಫೈಲ್. ಇದು ಯಾವ್ದು ಗೊತ್ತಾ? ಲಿಸ್ಟು ಸೀರಿಯಲ್ ನಂಬರ್ 6 ಪಾಸ್ ಮಾಡಿದ್ರೆ ಇದಿಷ್ಟು ಇಲ್ಲ ಹಾಕಿದಿಲ್ಲ ನೋಡ್ತಾ. SR ಇದು SR ಇದು KTY ಇಷ್ಟು ಮೇಲ್ಗಡೆ ಮಾತ್ರ ಡೇಟ್ ಎಂಟ್ರಿ ಮಾಡರ್ ಕೊಟ್ಬಿಟ್ಟಿದ್ದಾರೆ. ನಾಳೆ ಡೇಟ್ ಬ್ರಾಂಚ್ ಹೇಳಿದ್ರು ಅವ್ರು ಕೊಡ್ಬೇಕು, ಅದೊಂದು ಡೇಟ್, ಮಿಕ್ಕಿದೆಲ್ಲ KTY.
Madam, serial number 63 next date?
ಹೌದು ಹೌದು
63.
63.
Hold on, let me check the date.
63 10th August.
10th August. Thank you.
KTY. ಇದು PRS ಇನ್ನ 6,000 ಇದಾವೆ. ಸ್ವಲ್ಪ ಟೈಮ್ ಕೊಡ್ಬೇಕು. ಓಕೆ, ಇದು ಅಷ್ಟೇ PRS ಕಳ್ಸೋಣ. ಒಂದು ವಿಡ್ರಾ ಫೈಲ್ ಆಯ್ಕೊಂಡ್ರ ಹೇಳ್ದೆ. ಯಾವುದು ಹಂಗ್ ಕೊಟ್ರೆ ಫುಲ್ ಆಗ್ತದಿಲ್ಲ ಅಂತಾರೆ. ಅವ್ರಿಗೆ ಏನ್ ಬೇಕೋ ಕೊಡಿ, ನಾವ್ ಹೇಳೋದು ಕೇಳಲ್ಲ. ಇನ್ನೂ ಬೇಡ, ಇಷ್ಟೇ ಕೊಡಿ.
ಇವ್ರದಲ್ವಾ?
RES ಬ್ರಾಂಚ್ ಅವ್ರೇನ್ ಇರ್ತಾರಲ್ವಾ? ಯಾಕೆ ಇವತ್ತು ಬರ್ಲಿಲ್ಲ ಅಣ್ಣ?
ಅವಾಗ RS ಅವನೇ ತಂದೆ.
ಅಲ್ಲ ಇವರು
ಗೌರ್ಮೆಂಟ್ ಎಲ್ಲ ಅವರಲ್ಲ.
ನಾನೇ ಕೊಡ್ತೀನಿ ಇರವ. ನನ್ನ ಹತ್ರ ಇಲ್ಲ, ನಾನು ಕೊಡ್ತೀನಿ ಅಂದ್ರೆ ತಗೊಳ್ಳಿ. ಇದೆಲ್ಲ ಈಗ PRSಗೆ ಆಗೋಯ್ತು. ಸೊ ಹಂಗಾದ್ರೆ ಎಲ್ಲ ಡಿಕ್ಟೇಷನ್ಗೆ ಬಂದ್ಬಿಡ್ತಲ್ವೇನಮ್ಮ? ಹಾಗಾಗಿ ಇವಾಗ ಆರ್ಡರ್ಸ್ ಇಂದನಾ ಎಲ್ಲಿಂದ ನಾವು ಲೆಕ್ಕ ಹಾಕೊಂಡಿದ್ದು? ಹಾ ಹೌದು, 10th August 63 ಆಯ್ತಾ? 64 ಡಿಕ್ಟೇಷನ್ ಆಗೋಯ್ತು, 65 ಡಿಸ್ಪೋಸಲ್. 66 PRSಗೆ. 67 ಇಲ್ಲೇ ಫೈಲ್ ಕೊಡ್ತೀನಿ, ಬರ್ದ ಹಿಂದ್ಗಡೆಗೆ ಹಾಕ್ತೀನಿ. 67 68 PRS ಡೇಟ್ 7/8 ಎಕ್ಸ್ಟೆಂಡೆಡ್. 69 ನಾವೇ ಬರೀತೀವಿ. 70 ಯಾರು ಅವರ 70 PRSಗೆ ಆಗೋಯ್ತು. ಇದು PRS ಬಂತ, ಸಿಕ್ತಾ ಎಲ್ಲ? ಈಗೇನ್ ಗೊತ್ತಾ, ಇದು PRS ಫೈಲ್ ಇಲ್ಲಿ ಹಾಕ್ತೀನಿ, ಅದ್ರ ಜೊತೆಗೇನೆ ನೀವು PRS ಹಾಕಿ. ಆಮೇಲೆ ಇದು PRS ಇದೇನ್ ಬಿಡೋದು? 63 PRS ತಾನೆ? 63 ಎಲ್ಲ PRS. ಓಹ್ ಏನ್ ಎಂಜಾಯ್ ಅಲ್ಲಿ, 3 ಮುಕ್ಕಲ್.